At the outset of the symposium, we wish to pay respect to the Algonquin people, who are the traditional guardians of the land. We acknowledge their long-standing relationship to this territory, which remains unceded. Nous rendons également hommage à toutes les personnes autochtones qui habitent Ottawa, qu'elles soient de la région ou d'ailleurs au Canada. Nous reconnaissons les gardiennes et gardiens des savoirs traditionnels de tous âges. We acknowledge the traditional knowledge keepers, both young and old, and we honor their courageous leaders, past, present, and future. C'est avec grand plaisir que je vous souhaite la bienvenue à ce symposium. Sanda Rodgers et moi-même avons décidé d'organiser cet événement avant tout parce que nous pensions qu'un repas au sein de la faculté ne suffirait pas à marquer le départ à la retraite de Professor Martha Jackman. We wanted to gather together scholars and legal activists who not only recognize, but who integrate into their own work the extraordinary contributions of this whirlwind of a woman to a remarkably broad range of areas of constitutional law and administrative law, and to an equally impressive range of public advocacy groups and their practices. We hoped to convene a diverse gathering of scholars, legal practitioners, and legal activists to underline just how influential Professor Jackman's work has been over her nearly 40 years of committed social justice advocacy. Nous avions également un autre objectif. Pour la plupart d'entre nous réunis ici, la loi a donné des résultats bien inférieurs à ce que nos efforts dévoués et nos arguments convaincants méritaient. Aux yeux de la majorité d'entre nous, les tribunaux ainsi que les gouvernements fédéraux, provinciaux, territoriaux et municipaux sont peu enclins à une réforme égalitaire substantive. Nous avons tout constaté l'aggravation des inégalités sociales, économiques, raciales et sexuelles. Mais malgré cela, nous militons en faveur d'un monde meilleur. Et il est essentiel que nous le fassions. So, our second hope for this day was that in gathering this multi-generational, multiracial, bilingual, and pan-Canadian group of social justice advocates, we would be emboldened and reassured by a sense of common cause, of community, a sense that even after Martha Jackman retires, there is a we who share the same sense of urgency about the necessity of activism in these very troubling times. To that end, I do want to mention that 4 of the we assembled have had to cancel in recent, actually the last cancellation was an hour and a half ago, recent times for decent reasons, but I do want to mention their names because if they're not here, you can look up their work and think of them as part of our community. Pamela Cross, a 40-year legal activist in combating sexual violence against women and finding redress for survivors. She's writing a book about those 40 years, and let us hope it comes to completion soon. Fatima Cotter, a Toronto labor lawyer who until very recently was sole practitioner working, among other things, on organizing gig workers. She's also a really prolific independent journal writer with brilliant political analysis. So look up Cader and read her. Mary Eberts and Kim Stanton were a Section 15 duo of some substance. Mary Eberts started her equality work in the 70s and helped to give us a reasonable accommodation law before the charter. Kim Stanton was executive director of LEAF, does both Section 15 and Indigenous right litigation. And so that kind of blew a hole in one piece of Section 15 analysis. And this morning, Faye Faraday, who is the other half of our Section 15 analysis, had to cancel due to COVID. So I am going to try and embody their work at the last panel and invite you to a blue sky brainstorming on Section 15 equality and theory. Anyway, we hope that you get, I'm a little rattled, you might imagine. You'll get some new strategies and ideas from the papers being presented today. We hope that during the day on breaks and at dinner and meals, you'll find time to make some fruitful connections for continuing work with old and new faces. And we look forward to drawing on each other for affirmation. Je tiens à exprimer notre profonde gratitude à ceux qui, par le soutien financier et personnel, ont rendu le symposium possible. As holder of the Greenberg Chair for Women in the Legal Profession, Natasha Bacht, who's chairing a conference in Halifax this morning, committed substantial funding in support of launching this event, and also secured additional support from several additional sources. Le Centre de droit public a fourni du financement et un soutien logistique. La co-directrice Vanessa MacDonnell a également apporté une aide continue et des conseils très utiles en matière de planification. The Center for Health Law Policy and Ethics provided financial support, and its director, Professor Vanessa Grubin, along with Professors Bacht and MacDonnell, secured a Charte Connection grant that has given us breathing room for travel and logistical support, including food. In addition, the Health Law Center seconded the inestimable Giles Holland. Oh, there he is. Can you stand up, please? Though Giles probably got very little sleep, he is our troubleshooter today. So if you run into particularly technical support, Giles and our tech assistant will be your go-to guys. I don't think I can handle any more last minute needs. I'm struggling as it is. But Giles has handled all the administrative and execution of all the myriad details, including herding cats. Si vous avez besoin d'assistance, please go to Giles. Finally, I wish to thank Shirk and the university's research office for financial support. As you all know, inflation has put all costs up noticeably, including making a conference happen. We're most grateful to their support. Two small housekeeping matters. On your table and on the podium, not yet, but there will be, you will find QR codes. One is to access the web page that includes the program, abstracts of presentations, and speaker bios, should you wish to follow up on that. The other is to the Wordly app for simultaneous translation of presenters' remarks. The app will transmit written translation, like subheads on a movie, which you all know how to do, onto your phones or computers. And if you need one, but you're beside and didn't bring a phone or a computer, sit beside somebody who did. Deuxièmement, nous avons un programme et une journée bien remplie devant nous. Les modérateurs des groupes d'experts ont pour consigne d'être rigoureux en ce qui concerne les limites de temps. Veuillez respecter ces limites afin de laisser du temps pour les questions et les échanges après la présentation de chaque groupe d'experts. We hope you enjoy this assembly of outstanding voices for social justice. And now I have the pleasure of introducing the Susan and Perry DeLise Dean of the Faculty of Law, Common Law Sections. Thank you.
Bonjour tout le monde. C'est un grand plaisir pour moi d'être ici avec vous pour célébrer l'incroyable carrière de la professeure Martha Jackman. Il ne pourrait y avoir de meilleure façon de souligner l'impact de la carrière de la professeure Jackman que d'organiser un symposium sur l'avancement de la justice sociale. Professor Jackman has tirelessly pursued social justice through her teaching, scholarship, litigation, and feminist activism. Our faculty and students are so fortunate to have had the benefit of her guidance and involvement over the past 36 years. Je tiens à remercier le Centre de droit politique et éthique de la santé de l'Université d'Ottawa qui a organisé ce colloque, ainsi que les organisations qui l'ont parrainé, le Centre de droit public, la chaire sur les Greenberg sur les femmes de la profession juridique, ainsi que le Conseil des recherches en sciences humaines. I'd like to echo the thanks that were just given to Vanessa MacDonnell, to Vanessa Gruben, to Natasha Bach, and to Giles Holland for their leadership in launching and paying tribute to a senior colleague like this today. I think it's testament to their community mindedness and to the commitment to the institution and to the mentorship that Martha has shown over the years. Law is a terrain for advancing social justice, a theme that resonates profoundly with the life and work of Martha Jackman today. We'll gather not only to explore this critical topic, but also to celebrate the incredible career of a true pioneer. Professor Jackman, as she approaches her well-deserved transition away from teaching, I'm not going to say retirement because I don't think she's actually retiring, but away from teaching in the faculty. I think it's wonderful to bring everyone together to hear. Depuis qu'elle a rejoint la faculté de droit de l'Université d'Ottawa en 1988, la professeure Jackman a été un modèle de dévouement et d'excellence. On ne saurait trop insister sur l'impact profond qu'elle a eu sur le droit constitutionnel, notamment en faisant progresser les droits des femmes et des groupes marginalisés. Ses recherches et sa défense des droits ont fondamentalement façonné le paysage des droits socio-économiques et de l'égalité au Canada. La professeure Jackman a exercé divers mandats au sein de notre faculté. De la direction du programme des études supérieures au poste de vice-doyenne du programme de Common Law en français, en passant par la co-rédaction de la revue Femmes en droit, son leadership en tant que titulaire de la chaire Shirley Greenberg pour les femmes de la profession juridique a joué un rôle déterminant dans la promotion des perspectives féministes sur le droit et dans le renforcement de la voix des femmes dans le milieu universitaire et la profession juridique. Beyond her formal roles, Professor Jackman is also known as a mentor. She has demonstrated much camaraderie over the years, and she's been invaluable to her colleagues and students. She has cultivated an environment of support and collaboration and has encouraged so many young legal minds to pursue careers dedicated to social justice. Her ability to inspire those around her leaves an indelible mark on our community. D'un point de vue personnel, j'ai toujours été inspirée par la capacité de la professeure Jackman à combiner rigueur scientifique et passion sincère. Sa défense des droits sociaux et économiques a non seulement modifié les lois, mais aussi transformé des vies. I recall early on in my tenure that Martha invited me over for lunch at her place, at her house. She said it was closer than any restaurant to campus. And so we had quiche in her dining room and had a wonderful conversation about the history of the PCLF, her work at the faculty, the things that had inspired her over the course of her career, and where she thought the faculty might go. It was a wonderful and welcoming introduction by a senior colleague. I am sorry that our professional lives have only had 2 years in common, but I look forward to many more collaborations, meetings, and so forth as you transition to the next professional chapter. L'héritage de la professeure Jackman est fait de courage, de compassion et d'un engagement indéfectible en faveur de la justice. En célébrant son départ à la retraite d'enseignement de la faculté, nous célébrons également les innombrables vies qu'elle a touchées, les esprits qu'elle a éclairés et les barrières qu'elle a fait tomber. In closing, please join me in extending our deepest gratitude to Professor Martha Jackman for her unparalleled contribution to advancing social justice. Professor Jackman, your impact on our faculty and our students and our society is profound. We wish you the best in your transition to the next chapter and look forward to all the projects, causes, and other things that you will champion in your next professional chapter. Thank you, Martha.
So the panelists and moderator for the first panel could come to the podium, please.
Okay, so in the spirit of doing my part to keep the agenda moving here, we will get started with the first panel. Good morning, everyone. It's so nice to have you all here today to celebrate Martha Jackman and her extraordinary career across many domains, really, of legal research. This first panel is going to deal with constitutional principles, and we'll touch on the various ways that Martha's work has really propelled our thinking about constitutionalism forward, particularly in the domain of individual rights and social rights. So my name is Vanessa MacDonnell. I am co-director of the U-Ottawa Public Law Centre, and I'm thrilled to have a bunch of my constitutional heroes on this panel this morning. Unsurprisingly, when you host a conference honoring Martha, the best and the brightest turn up. So it really is an honor to be able to be sitting here today with these esteemed colleagues. So today we're thrilled to hear, I'll just briefly introduce the presenters in the shortest with one-line bios, but I really do encourage you to go online and take a closer look at their research. Margot Young, professor at the University of British Columbia, who alongside Martha has really been a pioneer in thinking about social rights and Section 7. My dear colleague Aimée Craft, who is joining us online and so temporarily behind the PowerPoint presentation, but she is here, and Aimée is a university research chair at the University of Ottawa, and also a giant in the field of Aboriginal and Indigenous law research with a real constitutional dimension. Colleen Sheppard, who I'm going to introduce this morning in a slightly different way because of the labor situation right now at McGill. So Colleen is a member of the Ontario Bar and a SSHRC-supported researcher. It's very nice to have Colleen here this morning, as well as David Schneiderman from the University of Toronto, also a close colleague of Martha's and again, a leader in our field. As is Colleen. I just can't really tell you this morning about all of the amazing things she's doing at the institution that will, for today, remain unnamed. Okay, so we are going to get started. We will have each of the speakers speak for about 15 minutes. I'll try to be actually to enforce that, because I think it will be really great if we have some time at the end for conversation. So we will start with Margot.
Great.
Over to you.
Thank you. Thank you.
You're not, I don't think you're blocking, right now. I think we're okay. And I'd invite the speakers, please feel free to speak sitting, or if you feel more comfortable presenting from the podium, that's also great.
Well, I'm going to sit. and begin by saying that I want to thank the organizers for pulling together such an absolutely phenomenal group of friends and colleagues of Martha. And Giles over there, thank you for being constant in my email box and even at midnight last night, taking my PowerPoint. So thank you so much. I am so pleased to be at this event for my wonderful colleague and dear friend, Martha Jackman. Martha's mark as both an innovative thinker and an activist scholar is deep. As a friend, she is steadfast, bluntly honest when necessary, and always on your side. In preparation, I asked Martha for her 3 favorite articles of the many she has authored. She complained. Too tough a task, she said, but she came through and she picked well, naming flagships from a complex and commanding scholarship fleet, pieces that benchmark well the comments I want to make today. And you can see from the range of articles, the 3 she sent to me, the wide scope of Martha's work. From these pieces, I take 3 observations about Martha's work: the linkage of democracy and rights, the centrality to this linkage of judicial review, and the failures of the judiciary to give adequate scope to social and economic rights, which in turn circles back to concern about judicial neglect of the of the essential requirements of democracy. I single out these 3 elements as they all fit tightly together. A central concern about meaningful and fair democracy mandates a judicial role in ensuring the material conditions of welfare that in turn are essential to participatory parity in our democracy. But indeed, I have to admit at the start that I'm actually capturing such a thin slice of the absolutely remarkable and wide scholarship and activism that characterizes Martha's career. Okay, so to my observations, I want to begin by just noting the classical divide that so many set between liberty and equality. Martha has, for the length of her career, disputed this divide, insisting on the symbiotic relationship between liberty and equality for ensuring social justice, highlighting the contradictions of dependency and oppression in a constitutional democracy, noting that the absence of agency and the lack of resources pair. Mediating through the notions of social citizenship, social and economic rights ensure membership in political community where competitive democracies see legislators challenged to do other than prioritize issues of the already affluent majority. So rights are not merely barriers protecting individuals from the state, Martha tells us, but are affirmative mechanisms for ensuring participation in society and in democratic institutions. Martha anchors her observations about the importance of rights to a healthy democracy in the words of then Chief Justice Dickson about the necessity of Section 1, the necessity of Section 1's role in calibrating both democracy and rights. So the Charter's task entails protecting and promoting the capacity of a democratic system to respond to minority rights claims. Here, Martha's work invokes the thick democracy advanced by political theorists such as Nancy Fraser or Iris Marion Young, who both argue that voice and participation are fundamentals of justice. Fraser argues that participation encompasses or actually subsumes both redistribution and recognition, and Young writes of a radical democratic pluralism that ensures the participation and inclusion of everyone through a vision of social relations that affirms difference and brings together strangers. Martha looks at these outcomes through the mechanism of judicial review. Yet judicial review in a democracy is commonly cast as a deviant institution. This was frequent refrain among the early critics of the Charter, with whom from the beginning, Martha has taken issue. The counter-majoritarian difficulty with judicial review sets out a tension between judicial review and commitments to democratic self-government. This debate's moved on. There's now a much livelier and diverse conversation about the relationship between judicial constitutional rights review and the institutional foundations of constitutional democracy. Largely, this debate is framed in terms of the separation of powers. That is, focus on the desirable relationship between the three branches of government, the executive, the legislature, and the judiciary. And the most interesting work, I would say, typically by women, by feminist women, takes up the role of constitutional courts in protecting democratic values. That is, the courts occupy, it's often argued, a unique role that traverses the distinction between law and politics. In this capacity or in this context, scholars contest the merits of strong versus weak judicial review. So Eileen Kavanagh, for example, enters the debate positing the idea of a cooperative model between the three branches, one that frames their relationships in terms of comity and respect. The three branches form a kind of constitutional capital by working together, and Kavanagh calls it the constitutional gift that keeps on giving. And key to this understanding is the idea of responsiveness, which is a piece she picks up from Rosalind Dickson. Rosalind Dickson writes about how a responsive theory of judicial review combines several features characteristic of judicial review. That is, judicial review's breadth, coerciveness, and immediacy that is paired with a narrow case focus and delay in issue resolution. And Dickson sees this as allowing avoidance of democratic debilitation, overcoming burdens of legislative inertia, and guarding against democratic backlash. Dickson frames her discussion in terms of blockages that undermine the capacity of a system to realize constitutional commitments in law. And these are things like blind spots and the burdens of inertia. And the last, she argues, is particularly true for social rights, which rely on a strong positive dimension. So her focus is on leveling up, on extending the benefits of the advantaged to outgroups. Both theorists, Kavanagh and Dickson, resonate with Martha's work in terms of emphasizing the partnership of the judiciary with other branches. But the two other theorists miss the piece of the landscape that Martha's work maps out for us. And consequently, these other theorists chart too subdued a path for judicial review. Indeed, Martha's work is an important interruption to preoccupation with the legitimacy of judicial review by taking the terms of the Constitution and judicial, sorry, I'm just thinking I need to move my slide ahead. There we go. By taking the terms of the Constitution and judicial statements seriously, Martha's work reminds us that the substantive best that constitutionally protected rights can and indeed must provide is rightly our focus. She disrupts the focus from a simple choice between judicial activism and judicial restraint. So our focus is shifted away from ruminations about abstract understandings of the separation of powers to careful focus on the consequences of judicial review for individuals and groups. And emphasis shifts from what judges ought not to do towards insistence on what they are constitutionally obliged to do. Martha reminds us in particular, and very importantly, of the key role the administrative state plays in constituting social citizenship and ensuring social and economic rights, and of the institutional distance from the democratic process that the executive has relative to the legislative branch. So this makes judicial oversight of the executive all the more essential, and Martha's written extensively about this. Emphasis on constitutional judicial review of the executive and of participatory justice concerns in relation to executive actions is a strong and original strand of Martha's work. Canada's liberal market order throws up a large minority unable to access the goods and services they need to live well. Martha chronicles this failure with sharp focus on issues such as low income, inadequate housing, and access to health care. In doing this work, Martha has cemented her place as the primary proponent of the Charter as an accountability mechanism for socioeconomic rights. She has pushed relentlessly against the default liberal legalism of a Bill of Rights that contemplates only formal civil and political freedoms. Martha's critique is sharpened on sections 7 and 15 of the Charter, carving out 3 failings in jurisprudence: an insistence on distinction between positive and negative rights being meaningless. Sorry, the 3 failings are an insistence on a distinction between positive and negative rights, justiciability hurdles, and formal rather than substantive equality renderings of rights. And I have time to say very little about each of these, but I want to note strongly that Martha's work has really moved the dial on each. How am I doing for time? Okay. So in disputing the distinction between positive and negative rights, Martha claims first honors. To quote another commentator, this distinction can only be preserved with significant damage to logic. And Martha has pointed out the failures of our courts to deny positive rights obligations, denies in turn the Charter's wider interpretive context, the historical course of Canada's welfare state, and the presence of economic and social security as a unifying social value. So Martha's work on access to justice and the failure of courts to take up novel and substantive claims pinpoints how constitutional jurisprudence too often has stayed irrelevant to the systemic and deep injustices of Canadian society, either through denials of standing or justiciability for claims that target economic maldistribution. Martha's work on health is a substantial contribution. I'm running out of time. I wanted to say a lot more about this, but she tells us how in jurisprudence we can see, lost my order here we go. In jurisprudence, we can see how the reference point of universality with respect to healthcare instantiates a formal equality, supplanting the more substantive commitments that insistence on comprehensiveness would anchor. Martha's worked extensively on Section 15. She's been involved in litigation around cases such as Gosselin, and she has shown us that the lens that contemplates power structures more than merely equal treatment and the demand that institutions, not individuals, be the focus of transformation is the one that our courts should bring. I want to end by noting the continuing relevance of Martha's work. So very quickly, I've put up a quote from a case that deals with the rise of encampments across Canadian cities. These encampments capture a perfect storm of housing, income equality, and health crises. Key focuses, not coincidentally, of Martha's work. In Adams, this quote from Martha was instrumental in anchoring the factual findings and the understanding of being unhoused and having to set up shelter on public lands that the trial court recognized and that was carried through the Court of Appeal. We've now got scholars like Jonathan Goldberg-Hiller talking about the right to sleep, about how sleep is socially organized and unevenly distributed through sometimes violent arrangements. This work all segues so well with Martha's work on Section 7 as the groundwork or legal stage for really exploring what a socially just rendering of the issue of building homes and encampments on public land raises. Second, I want to point simply to recent cases around challenging the failure of governments to respond adequately to the climate crisis. Martha's criticism of the distinction between positive and negative rights has finally borne fruit. So we can see in the Federal Court of Appeal decision in LaRose, a challenge brought by 12th Youth against government inaction, that this quote from Martha and Bruce, who's also in the audience, was the basis of the judges at the Court of Appeal concluding that the distinction between positive and negative rights is at times a false dichotomy, and the case is advancing to trial on the basis of this kind of scholarship helping to defeat the government's attempt to get it thrown out at the beginning. So Martha, you may be retiring, but your scholarship is going to remain hard at work. Okay, in conclusion, I want to turn to the title of my talk, Martha's Vineyard. And I want to say simply that Martha's scholarship is succinct, piquant, and smooth. It has thoughtful, clear flavor, presenting overtones not of lemon or whetstone or cut grass, but rather of life, liberty, and security of the person. With notes of equality, lively acidity is cut with progressive potential, a rich body of thought, yet with a subtle cast, it is unusually persistent. I'm going to call it organic and socially responsible, like all good distillations. It promises not to disappoint, and the morning after, safe from hangover, you will spring from rest, ready for action in the name of social justice. I heartily recommend the quality, integrity, and price of the Jackman. A score of 10, Martha.
Thank you. Thank you, Margot. Okay, so next we're going to move to Aimée Craft, who is joining us online. So if we could perhaps just take the slides down and return to the Zoom screen. There she is. Good morning, Aimée.
Good morning.
Over to you.
Good morning. So I'm joining you from Treaty 3 territory, Anishinaabe territory that's on the border of Manitoba and Ontario. I'm here helping to prepare an annual Nibi gathering, a water gathering. I'm sitting in a cabin not far from the site, and I hope the internet will hold up. But if it's not, I'm happy for you to just let me know and we'll make other arrangements. I know you have a slate of wonderful speakers today, and I am looking forward to listening to the recording of the rest of the day. Once this is done, this panel is over. So again, thank you to the organizers. Thank you to Martha for having this celebration, for your legacy that you leave with us and will continue to contribute to. I actually changed the topic of my talk today in conversation with Martha. I was going to do a retrospect, and we both agreed that it would be more useful for everyone in the room and probably more interesting to chat about where the court is at today, and to do that through the lens of one particular lengthy decision issued in March of this year, the Dickson and Vuntut Gwitchin First Nation case. And this is a case that, in my view, illustrates how the court struggles to find compatibility between the exercise of Indigenous self-governance and liberal values. And it's a case that illustrates also the complexity of understanding the role of the Charter and all its dimensions and peripheries. So that's the reason we agreed to a little bit of a shift. And I will be honest, I had my moments of regrets because this decision tracks at a very lengthy, let's see here, I have it written down, 500 plus paragraphs, 82,000 words. And I've taken the time to reread it a few times, and I have a lot of remaining questions, which I'll address at the end of the talk. So we'll do a little bit of background and then dive into some questions that I anticipate that when Martha will continue to teach Charter, she will be asking her students as well. So I'm just going to do a check. Everyone can hear me. There's no delay in the Zoom.
Yeah, you're fine.
Okay, fantastic. Great. So the two sections at play in this decision and the interaction between them is, as I said, very delicate. It's in a sense maladroit, and it's definitely not creating a unified front at the court level. So the questions that are posed are whether the Charter, specifically Section 15, applies to First Nations governments, and if so, which characterization is it based on, self-government or delegated legislative authority? And that's a very tricky question. And I'll fast forward to one of my conclusions, which is self-government continues to be incredibly difficult for the Supreme Court of Canada to understand or grapple with. And the second piece of this decision is, I think, the more fascinating one, but also kind of embroiled in this interplay. And again, I'm going to fast forward to my conclusion. I think that the court is really stuck on its Section 15 analysis and the intent of Section 15, rather than really diving into what Section 25 is and could be and should be in the Indigenous context. So some of you will be unfamiliar with Section 25, but it is essentially the protection of Aboriginal and treaty rights and other rights or freedoms that pertain to the Aboriginal peoples of Canada. So a non-derogation, non-abrogation clause that's found within the Charter. And it actually lists two particular other rights, which are the rights that flow from the Royal Proclamation and any that flow from existing land claims or agreements. So essentially saying the Charter cannot impact these rights that stand outside of the Charter. My personal pet peeve when people say that Section 35 of the Constitution is part of the Charter, no, it's in Part 2, it's separate from. And so this delicate interplay between the Charter and treaty and Aboriginal rights and these other rights which come into question in this case is a difficult one. So the background here is that a citizen of the First Nation brings a petition to the Supreme Court where she asks to strike down a requirement that's in the First Nations Constitution. It's a residency requirement to run for council of the First Nation. And the residency requirement requires any candidate to live in the settlement lands or move to them within 14 days of being elected. So the claim is that this is discriminatory on the basis of Aboriginality residence. This is an analogous ground found in Corbière, and that it perpetuates pre-existing disadvantaged experience by Indigenous citizens who live away from the community. And we know for a variety of reasons that many Indigenous citizens cannot live in their home territories. The Yukon Supreme Court, what happens is the Charter is found to apply to this challenge, but there's a finding that there's no breach of Section 15. But the trial judge does say that if there had been a breach of Section 15, it would have been shielded by Section 25. So brings that piece in really to set this up for the appeal. At the Yukon Court of Appeal, they say, yes, the Charter applies regardless of the source of the authority. And I should mention that at the trial, one of the questions was, what is the source of the authority for the Vuntut Gwitchin government lawmaking in which they provide this residency requirement? And at trial, they said whether or not the requirement is viewed as an exercise of the inherent right of self-government or as an exercise of self-government implemented by legislation, that the Charter would apply. And what they say at the appellate level is it applies regardless of the source of authority. And this is the discomfort that then arises at the Supreme Court level, because there's no desire for the majority to actually dive into this idea of the inherent right, the exercise of self-government, and whether or not the Charter applies. So that's an outstanding question. What they did was attach the First Nations authority to the federal government exercise of authority, and they don't deal with the issue of self-government itself. Okay, are your brains rattled? It's a complex case, right? It's really bringing in a lot of different pieces of the Charter, the interplay, different pieces of the Constitution and their collective interplay. So at the Supreme Court, just to make this a little bit more complicated, there's an appeal and a cross appeal. So Miss Dickson applies to appeal the decision that Section 25 applies, and Section 25 becomes that shield for the residency requirement and allows it to continue. The First Nation also makes a cross appeal if Miss Dickson was to get the leave to appeal, which she does, and they ask whether or not the charter applies and whether the residency requirement is discriminatory. So there's really two big decisions within the decision. So both the cross appeal and cross appeal are dismissed by a majority of 4, and the residency requirement is saved as being protected by Section 25 of the Charter. As I said, this is a lengthy decision, 3 judgments, and I want to review all 3. I'm going to kind of power through all 3. They're so different from each other, both in reasoning and outcome, and then I'll make some remarks and observations. So the majority judgment, 4 judges, Cassera, Jamal, Wagner, and Cote, and they say that the charter does apply. And they go through, why the charter might apply to a certain entity. And in this case, what they say is that the charter applies to the residency requirement because the Vuntut Gwitchin First Nation is a government in nature. And I'm using quotes, but there are so many quotes in this case, air quotes, kind of grappling with the proper terminology to use. They go through a set of criteria by which they can find a government by nature. And, these are the typical ones: the democratic election, taxation power, power to administer and enforce laws within a territory. And the 4th piece of the finding of government is that it derives its existence and lawmaking authority from the federal or provincial government, meaning that it exercises powers that otherwise the federal or provincial/territorial government would have to perform. So they say, the majority says that the First Nation meets this criteria, and they emphasize that on the 4th factor, the Vuntut Gwitchin First Nations exercise of governance in the context of federal legislation that implements self-government, and by virtue of Section 9124, is carrying out its activities at least in part under federal statutory authority. So this is that denial of self-government that I was talking about. So they have to attach it somehow to the exercise of federal authority. They also go as far as saying, and this is from paragraph 91, we make no comment on whether an exercise of an inherent right to self-government untethered from federal legislation would be subject to the charter, which in our view need not be decided in this case in view of the self-government arrangements in issue. So help me to understand why the court is finding that a First Nation that has a self-government agreement with the Crown is not exercising self-government, that it attaches that exercise of constitutional lawmaking and criteria for its membership to elect into a federal piece of legislation. I'm not sure that I fully understand where they're coming from. And I think this is something to watch. And I think there's also a push into the future of this important question that the court is hesitant to grapple with. Okay, so they do find that the residency requirement is inconsistent with Section 15, but they then use Section 25 to shield it. There's a protection of the residency requirement through Section 25, whose purpose is to protect Indigenous difference against inappropriate erosion by individual charter rights. So protecting this Indigenous difference, that's not language that I read out to you in terms of what Section 25 actually speaks to. It speaks to treaty Aboriginal rights and other rights, but they create this new category, I would say, of the types of rights protected by Section 25, which are rights associated with Indigenous difference. They do say at one point that these other rights are not just those with constitutional status. which I think is a very interesting point. And they do say in this case, it is a right with constitutional status, but that Section 25 might shield things that do not have constitutional status and to shield them against the Charter. I'm not sure that this is a very clear logical leap, and I would like to hear more from the court on this, and I think it's a point that we should be discussing. The majority also explains that the Section 25 primacy analysis that it adopts, so saying if, you know, that Section 25 primacy is applicable, but that it's different from the Section 1 analysis. And that's something we can certainly have a discussion about.
5 minutes, Aimée, just to let you know. Thanks.
Okay. So the court sets up this Section 25 analysis in a 4-step framework. And again, it becomes this very difficult tension that exists in most of the treaty and Aboriginal rights cases, individual Indigenous claimants cases, where the claimant individual has a heavy burden and so does the First Nation. And so I'll take a step back here and make a commentary that I think applies to the legacy of Martha's scholarship as well, is we're dealing with parties that are essentially have exhausted internal options that are appealing to courts, not necessarily in appellate sense, but that are appealing to courts for some resolution, but there are heavy burdens that are evidentiary, and there's a significant amount of thought and uncertainty that's attached to litigating these issues. And here, this new Section 25 analysis that's being developed is similar to that. And that's a critique that is made within the dissenting judgments as well. So where the state of the law is now is we're asked to do this Section 25 analysis, show the prima facie infringement on Section 15. Then the responding party or the Indigenous collective has to show that the challenged conduct is an Aboriginal treaty right or this other right, and that there is an irreconcilable conflict between these two rights. Now, this is the space in which the dissenting opinions of Justice Martin and Obamsawin come into play, because they actually, in this conflict zone, say that there should be a balancing exercise or a reconciling of rights. And I've been critical of that very much in the past. And then the fourth step of this, this new analysis is to ask if there are any applicable limits on the collective interest. So this incredible shield that's applied will have some limits, and the court points to Section 25 of the Charter. So I'll fast forward essentially to some of the comments, other than to say, you know, on dissent, Justice Martin and Obamsawin take the approach that there is a breach of Section 15 that is not saved by Section 1, and they would not apply Section 25. They say it's an interpretive tool and that it's not an impenetrable shield. Justice Rowe, all on his own, elaborates a decision that and reasons out why the Charter should not apply, and reasons that out in 5 parts that are very interesting. And he points to Indigenous laws and legal orders. I would say it's not often that I find myself agreeing with Justice Rowe, but he's pointing to the applicability of Indigenous laws and legal orders, the principles of reconciliation, the fact that the First Nation never agrees to the application of the Charter, and points to Section 32 of the Constitution Act, saying that the Constitution describes who it applies to and that it does not apply to First Nations governments. So I'm not sure I'm in a total agreement with the reasoning, but the outcome and the idea that there is some nugget of self-governance that needs to be protected and that Indigenous laws and legal orders may have application here, I think is important to consider. So does anybody have whiplash from that that summary of 82,000 words crammed into a few minutes? Here's why I think this case is significant and why I chose to focus my remarks as part of this conference on laws of train for advancing social justice. I think at a superficial level, first, this case engages with Section 15 and the application of equality rights to Indigenous persons in Canada. It's attempting to answer the question of whether or not the Charter applies to decisions of First Nations governments, which the court has already grappled with, and what's outside of the exercise of delegated Crown function. Second, I think that it's an attempt to answer some questions about the application of Section 25 of the Charter, the non-derogation clause, and its interplay with Charter protected rights. So I think it's interesting in that sense. But if we dig a bit deeper, however, we see through the three separate sets of reasons that these questions are complex and extend far beyond the facts of this case and into a myriad of innumerable scenarios that engage over 600 First Nations, multiple Métis governments, and Inuit governments in Canada. So with respect to the now application of Section 15 to these governments, we see some new developments. The creation of another analogous ground specific to this case. The majority dissenters stick to an existing ground, but we see this new development and a lot of focus on specifically that ground and very much narrowing it. So I'm not sure that there's a general applicability of how the court has framed this ground of discrimination. There's also a shift from a trial decision that finds that there's no Section 15 breach to appellate courts that accept the inequality premise. So that's a very interesting outcome, I think. And we have a new framework for the analysis of Section 25 in the context of a Section 15 charter breach in an Indigenous context. So you see all the qualifiers here. What I'm reading between the lines of the decision is that there's a continued inability to acknowledge Indigenous self-government as a Section 35 protected inherent right. That there's a marked tension between individual and collective rights that continues through this case. The collective being some form of Indigenous collective or membership or citizenship or something else. And the collective has shifted over time. There are colonial connotations to who the collective is. And this collective is other than the global Canadian collective contemplated by other parts of the Charter. I think also that this case leaves open questions of what are these other rights that are shielded by Section 25 and that are, quote, not of a constitutional character. And I think that it demonstrates a profound philosophical dissonance on the bench about the Charter and its ability to achieve social justice in an Indigenous context. So really, I think this case, as I said at the beginning, is about how vast the reach of the Charter is. I think we're seeing that debate amongst the justices in this case. And the three sets of reasons are extending from one end of the spectrum to the other. The ultimate outcome in the case resting in that middle space. So as a reminder, the majority says, Charter applies in a tempered way and it should not interfere with Indigenous governance that is quasi-delegated by the federal government and is limited and can only be done in accordance with this four-part framework. Justices Martin and Obamswent say the Charter has full application. The Charter can't shield the decisions of Indigenous governments from scrutiny. So here they have this desire to apply a human rights and equality standard universally to all governments. And they use language of avoiding charter-free zones. So they don't want First Nations, citizens, reserves becoming charter-free zones. And they hope that somehow competing individual and collective rights can be reconciled or balanced. Justice Rowe simply says Charter doesn't apply. I think this is an anti-Charter view, and it's kind of explained through a veiled recognition of Indigenous laws and the application of Indigenous institutions of decision-making. But I note that there's no mention of, for example, UN DRIP or the things that bring about legitimacy of recognition of Indigenous governance and institutions of decision-making. So I feel like Section 25 is a little bit of a red herring in the case. And that as I said, the reasoning is less about what Indigenous collective rights exist outside of the Charter but within the constitutional framework of Canada. And it's about this spectrum of views on the value of the Charter itself. If I have 2 more minutes, I had a list of questions that I feel that Martha probably would have asked her students. And this is one of the things that I loved in being a student of Martha's. So Vanessa,
I'm sorry, I don't want to I don't want to interrupt you. We do really need to move on. So perhaps this is something that we could chat about in the Q&A.
Absolutely. So I have this list of questions and I'm happy to share it. And I'll definitely share it with Martha, just in case you teach Charter in the fall or spring of next year. I think this, as I said, this case raises some very important questions, but also abstracts itself from answering equally important questions. Miigwech.
Thank you. Colleen. So Colleen has a PowerPoint. If we could just bring that up, please.
This is on. Can you hear me?
I don't think it's got it. I can say that.
Colleen, here, pointer.
Oh, well. Oh, thank you. Okay. Bonjour, c'est un grand honneur excuse me, de participer dans ce colloque pour célébrer Martha Jackman. Thank you to the organizers for bringing us together. And I really appreciated what Sheila said this morning about being a supportive community. I think I miss that sometimes. Anyway, OK, aujourd'hui, je vais partager quelques idées sur le droit constitutionnel et les injustices socio-économiques, un sujet que Martha tient au cœur. The title of my talk here, as you see, is Towards a Constitutionalism of Inclusion, Contesting Socioeconomic Injustice. It changed a little bit from the original abstract I sent. Excuse me. As Vanessa mentioned, I'm here today in my capacity as a member of the Law Society of Ontario and as an SSHRC-supported researcher. Currently, my law faculty, McGill, is on strike. We decided after the pandemic to organize our faculty. McGill's one of the only universities where university full-time law professors are not unionized. We were certified in 2022, but we've been unable to secure a first collective agreement. McGill's actively contesting our fundamental right to unionize, in my view, and is, I think, in violation of its duty to bargain in good faith. But I felt like I should be here because SSHRC supported this research, and I wanted to share part of this project derives from that. I've known Martha since our time together at University of Toronto Law School, when Sheila was there too. It was studying in the early 1980s at a time when the Charter was first enacted. And I think it's significant that our entire careers really have provided us with an opportunity to help shape the meaning and promise of the fundamental rights and freedoms entrenched in the Charter. Martha's contribution, as we all know, has been so invaluable, especially her unparalleled efforts in shaping constitutional law to respond to socioeconomic disadvantage in disempowered communities. So taking inspiration from Martha's scholarship and active engagement with the law in my presentation today, I want to explore first constitutional exclusion, the ways in which the Constitution has failed to protect against socioeconomic injustice. And secondly, I want to turn to a bit more of a reconstructive project to think about how we might construct a constitutionalism of inclusion, drawing on the concept of social inclusion, and also thinking about redefining rights beyond the state, which I think Amy's and Margot's presentations both help us to think about. So as this quote, when I did a lot of reading when I was preparing for today, and I found this quote by Indian constitutional scholar Upenda Baxi, his work interesting. He writes, "Constitutionalism provides contested sites for ideas and practices concerning justice, rights, development, and individual associational autonomy. Constitutionalism provides narratives of both rule and resistance. And it's that idea, I think, that I want to play with a little bit today, that viewing constitutionalism as an interpretive site where meanings are asserted, reimagined, and contested, I think is a critical starting point for thinking about constitutional law and about rights that seek to redress socioeconomic disadvantage. As a domain that has and continues to be treated as outside the scope of constitutional rights, insisting on social rights is an act of resistance. Now resistance, I think, as Baxi teaches us, to the rule of law status quo, may engage with reform from both within and from outside of the legal processes and structures of constitutional law. Now, when resistance occurs within the formal channels of law, it's been referred to as contestatory constitutionalism, which is a term used by James Tully in an article he co-authored on what he called global integral constitutionalism, a lot of big words, but now, though these contestatory constitutional struggles often fail, given the constraints of traditional legal doctrine, they continue to be critical and important in seeking to redress socioeconomic injustices. And indeed, Martha's scholarship and advocacy has been at the forefront of these initiatives. And I think a key example is the work in partnership often with Bruce Porter on the social rights, and others, obviously, many in this room today, of the Social Rights Project in Canada, reconceiving human rights practice for a new social rights paradigm. And it's interesting that that initiative had a mandate to develop the conceptual and practical foundations for a new form of human rights practice, one that is capable of giving concrete effect to social rights within a broad range of settings. And I know myself and my students have used that website as an important resource and for thinking about how we might continue to insist on a constitutionalism that protects social and economic rights. Now, despite the strengths of this advocacy and of contestatory constitutionalism, as I think Margot's presentation indicated, and as Martha's work has so often taught us, the formal constitutional rule of law, oops, I forgot to change slides, has not embraced social and economic rights. The refusal of the majority of justices of the Supreme Court to recognize a positive right to adequate social assistance dates back, of course, to the important 2002 Gosling case, which involved a challenge to age-based workfare requirements. And as Martha concludes in an article about the legacy of Gosling, she says the experience of charter claimants in poverty-related cases before and since Gosling is one of constitutional exclusion. Now, although the majority left open a possibility of recognizing social and economic rights in some future case, it was, as you know, it was only in Justice Louise Arbour's dissenting reasons that positive economic rights fundamental to human life or survival were recognized. Now, the legacy of Gosling, I think, lives on in more recent case law, and I have a few quotes here from Martha's scholarship, which, again, remind us that it's been a difficult struggle to try to move formal constitutional law towards recognition of positive social rights. And the quote there, people living in poverty could not have foreseen that 35, now 40, many years after the Charter's enactment, Section 7's promise of life, liberty, and security, the person would offer no more than a right to sleep in a park at night under a piece of plastic or a cardboard box, alluding to the sort of ways in which the court has only moved in towards a recognition of negative rights in this domain, referencing that City of Victoria case, which Margot mentioned earlier. Nor has poverty been recognized as an analogous ground under Section 15, equality rights, while socioeconomic disadvantages have been recognized as one of the effects of discrimination based on grounds such as disability, race, or gender. Poverty itself has not been recognized as a distinct analogous ground, and other potential analogous grounds characterized by socioeconomic disadvantage, such as social condition, being in receipt of social assistance, being unhoused, or a migrant worker, have also not been recognized. In short, I think socioeconomic disadvantage remains only partially acknowledged inequality as an effect of discrimination, as I mentioned, and sometimes as part of a contextual approach to other grounds that gestures towards intersectionality. Perhaps, and again, as Martha has taught us, people living in poverty, the quote there says, would have expected the courts to recognize the disproportionately adverse impact government inaction has on the most socially and economically disadvantaged members of Canadian society. So just as Martha further notes, just as a kind of final summary of this denial, despite this very powerful and to me convincing, I keep wishing I were a judge, but nevertheless, advocacy, but Martha also concludes in that courts increasingly rely on procedural and preliminary motion procedures to deny plaintiffs their day in court and their right to make substantive arguments about social and economic rights. And as she finally concludes, most of all, people living in poverty would not have imagined their charter claims would no longer even be heard. Yet to all appearance, this is the legacy of Gosselin. So with that past, well, I asked myself, well, how can we move? And I think Sheila mentioned this morning that we want to think about the future as well. How can we move towards a constitutionalism of inclusion, as I call it? Drawing inspiration from the insights of Martha's work, I want to highlight two strategies, and there are, I think, many. The first draws on the concept of social inclusion, which I have been reading about in international documents, public policy documents, and in social science literature as a lens through which to examine law and public policy to advance the rights of marginalized communities in situations of vulnerability. Thank you, Christina Vazina. Okay, the second engages with the idea of constitutionalism from below, where citizens and social movements define constitutional meaning and practice with and beyond formal state law. So, if we turn first to constitutionalism of social inclusion, this concept has been, and this is the focus of my current SSHRC project. I'm not sure I applied. Now I'm thinking, it doesn't really make sense, but anyway, I'm presenting it. I've done all this research on it. But I'd be interested in your comments. The concept of social inclusion has been endorsed in both national and international policy documents to underscore the importance of attending to the needs of some of the most disempowered and marginalized groups in society. It's a concept that resonates with issues of social justice, and it's significant for its focus on groups in situation of economic precarity and vulnerability. This 2016 UN report defines social inclusion as the process of improving the terms of participation in society, particularly for people who are disadvantaged, through enhancing opportunities, access to resources, voice, and respect for rights. And what I find interesting about social inclusion is it speaks to both the substantive denial of rights as well as the importance of process rights and participation and voice. So it's that duality which I think is interesting. If you look at just one example of a fairly broad social science literature, this is a book by Anne Tackett, actually an Australian scholar, on practicing social inclusion. She defines actually social exclusion, sort of the other side of the coin, as a complex and multidimensional process driven by unequal power relationships interacting across four main dimensions: economic, political, social, and cultural, and at different levels: individual, household, interestingly, group, community, country, and global. That involves a denial of resources, rights, goods, and services, and an inability to participate. So again, there's that dual dimension. I have a lot more I could say about social inclusion and some of the ways in which that concept has been contested, but I'm not going to do that because of constraints of time, but I'd be happy to talk to people, and I'm writing a paper on it. So just to give you an example of, there's a lot at the international level, a lot in Europe. There's a lot of European public policy around social inclusion, social exclusion. But one example from a Canadian Senate report speaks about reducing barriers to social inclusion and social cohesion. Another term, social cohesion, which is closely related. And you can see that the committee identifies particularly marginalized groups, and it also recognizes the ways in which groups who are members, individuals who are members of more than one of these groups may have a higher risk of exclusion.
2 minutes.
Okay, so what are the implications of this idea of social inclusion on constitutional rights? And I sort of want to look at it briefly, very briefly, in terms of economic and social. 2 minutes, okay, and then equality. 2 minutes. Okay. Well, one scholar whose work I found an interesting starting point was this article by Hugh Collins on discrimination, equality, and social inclusion, where he says that social inclusion, and he's using it predominantly in the domain of equality, doesn't look at relative disadvantage, but focuses in on absolute disadvantage of particular groups in society. And I found that interesting because I was trying to think of what would move judges in contestatory constitutionalism to recognize social and economic rights. And an earlier article also said, I thought that perhaps on social and economic rights, social inclusion might be a mediating concept for recognizing such rights. Although I thought that judges should respond simply with empathy to the contextual realities and the harms of poverty, it seemed that developing a kind of mediating legal principle to help push them in that direction might be of assistance. In terms of equality, you can see, going back to Abella's judgment in the Fraser case, that substantive equality, I think, resonates with social inclusion. It's a philosophical premise, it's a remedy for exclusion and a recipe for inclusion. Social inclusion, I think, can help provide us with insights into the diverse purposes of equality rights. Integration without assimilation, which is one aspect of inclusion. Inclusion of groups which have been are in segregated or ghettoized or forced institutionalization, who are separated off from society against their will. And also this participation aspect of equality, which speaks not only to securing the substantive conditions of equality, but also attending to its reproduction in systemic contexts of inequality. So I'm going to just skip over, given time, to the second strategy, which is really constitutionalism from below. And here Martha Jackman and Bruce Porter emphasized that socioeconomic rights their definition need not be left exclusively to the courts to decide. Civil society groups have begun to take up the issue of rights interpretation. And Baxi again speaks about the importance of going beyond simply formal law in our understanding. Okay, my time's up. Okay, so I'll just conclude. And I can share my PowerPoint slides in terms, some of the strategies for doing that include a legal pluralism strand, an eco-social constitutionalism strand, and an Indigenous constitutionalism strand. And I think some of Amy's comments resonate with that. Some examples for that include actually living social and creating conditions for social economic right through cooperatives and other workplace democracy. And finally, in terms of, I think Martha's work teaches us the importance of both critique and reconstruction. And that aspect has always, I think, been really powerful. The importance, continuing need for both contestatory constitutionalism as well as rejecting the hegemony of law in some instances. And finally, I know this is my final quote is, when Canadian constitutionalism begins to redress the socioeconomic justices of our times, which it will in the future, I'm convinced, it will be a constitutionalism built on the intellectually powerful and engaged foundations of both critique and reconstruction that Martha, in solidarity and collaboration with others, has provided us. Merci. Okay.
Thank you, Colleen. David.
Okay.
Here.
Thank you. Okay, good morning, everyone. So I had the good fortune of, for most of my professional career, having Martha as a colleague, though often at a distance. So that was really lucky. But I also had the honor of calling her a friend, and so I'm really happy to be here today. I have 3 slides, so I'm not going to have much of a PowerPoint presentation, but this is just an outline of the paper that I've been at work at in advance of this session. The title has a question mark added to it. Is there a constitutional culture of sharing? And just roughly, I'm going to talk about Canadian constitutional culture. I'm speaking of English Canadian constitutional culture. There's a bit of a genealogy. It's kind of half-assed that I'm going to do quickly for you. That is a history of sharing. What contribution can legislatures make, which will be the principal message I think I'm going to send today. There's a section on Quebec's distinctiveness, which suggests that there's a different constitutional political culture in operation in Quebec than in the rest of Canada. And then lastly, reasons to be skeptical, which will be Martha's voice inserting herself into this conversation. Okay, inspired by Margot, I'm thinking about Martha as a pioneer in social justice, and she might, you might say, have been roughing it in the constitutional bush. But I'm going to start with Susanna Moodie from the 1830s in Roughing It in the Bush. She writes, Canada has few, if any, native beggars. Her objects of charity are generally imported from the mother country, and these are never suffered to want for food or clothing. The Canadian are a truly charitable people. No person in distress is driven with harsh and cruel language from their doors. They not only generously relieve the wants of suffering strangers cast upon their bounty, but they nurse them in sickness and use every means in their power to procure them employment. It's a glorious country for the laboring classes, for while blessed with health, they are always certain of employment and certain also to derive from it ample means of support for their families. So much rosier view, you might say, than Martha's Roughing It in the Bush. So however accurate this description of life in Upper Canada in the 1830s may be, poor relief was a task that would have been performed by friends, neighbors, other forms of private charity, churches, sects, which are not to be diminished, but the state basically had no place. Moreover, the assistance to laboring classes that Moodie describes was dependent on the dispossession of Indigenous peoples and their lands. There was, of course, no welfare state. The time she describes would be a time that neoliberals might cherish today. In terms of Canada's constitutional culture, we know that the division of powers has impeded the ability of the state to adopt measures to alleviate social suffering, and constitutional review has exacerbated that inability. Constitutional amendment, for instance, regarding unemployment insurance was a way of remedying this incapacity. But on the other hand, Canada's constitutional order has not been blocked from enacting legal change that serve the interests of lower and working classes. Canada's legislative capacity, if often unused, which is a term that Harold Innis developed, unused capacity, was available to improve social conditions. I've argued in a book called Red, White, and Kind of Blue that this capacious capacity allowed for a wider range of claim-making strategies to be pursued. In other words, this enlarged constitutional capacity enabled the emergence of a robust political culture, which with a wide range of policy options available to us, including a left-wing political movement. So I think it's this openness to political options that forms a largely unspoken premise of English Canadian constitutional culture. So briefly, what I mean by constitutional culture are the widely shared and dominant understandings of the fundamental norms that guide relations between citizens and states, and the state, and between institutions of the state, that is, intergovernmental affairs. Constitutional culture is represented not only in constitutional text and court decisions, but also in legislatures, media, indigenous communities, social movements, NGOs, international instruments, and institutions. Constitutional culture speaks to the kinds of arguments that are available to citizens and other actors that allow for change and adaptation in our constitutional understanding. Because the sources of constitutional culture are capacious, its content is not irrevocably fixed, though it will be dominant, allowing for change, but only intermittently. This isn't to say that federalism hasn't given rise to certain difficulties. The empirical study suggests that federalism doesn't paralyze government, but gives rise to delay and frustration. And so we've seen in the 19th century, under the influence of England, the United States, New Zealand, later in the early 20th, and even Bismarckian Germany, the enactment of a wide range of social welfare legislation, including the minimum wage, 8-hour day, culminating in things like a national health insurance. The problem is that intergovernmental spats and bargaining over terms has helped to provide cover, argues Linda White, for significant underinvestment in programs that benefit women, children, and families. So not only delay, but underinvestment. In 1867, these subjects, of course, were largely unspoken, and if they were allocated to any level of government, it was to the provinces. But the federal government, even early on, was committed to some forms of redistribution, transferring grants first to maritime provinces, then to Manitoba, BC, and PEI. These were inadequate. Provinces begin to tax directly, and the federal government follows suit shortly thereafter. These federal grants to provinces continue on through the years, as recommended by Royal Sir One, then entrenched in Section 36 in a commitment to redistributing funds to equalize services. But this refers mostly to intergovernmental sharing. Citizens are impacted mostly indirectly. And so it's not like this form of sharing is adequate to serving the interests of the precariat and the poor. So speaking to whether there is a Canadian constitutional culture of sharing, I think it can be said that poverty relief has never been a top priority in Canada's constitutional order, even though there are a panoply of programs. It can't be said they're plentiful or coherent. And so I conclude in this preliminary part that if there is a constitutional culture of sharing in English Canada, it's weak and poorly anchored. As Martha has shown us, there are judicial resources available to have moved us in a direction of recognizing and enforcing social rights. And while we can say, as she, along with Bruce Porter, has said, that the question remains unresolved and is therefore open, it's likely to remain open for a very long time, in which case it is time to rethink a strategy, as Colleen has suggested. So how might we shift Canadian constitutional culture in a more compassionate and generous direction? I propose that rather than asking the judiciary to take the lead, we ask the judiciary to follow the legislative lead. And I'm going to build on a recent Supreme Court of Canada ruling, Reference Reenact Respecting Indigenous Youth, Children, and Families, that was released in February of this year, is in some tension with Aimée's description of the Dickson case that followed a month later. The reference reveals or suggests that the Supreme Court of Canada is on a path to recognizing Indigenous self-government. This is a wishful reading, hopeful reading of it, following the leadership of Parliament on this question, putting to one side the paradox of having an inherent right to self-government recognized by contingent parliamentary legislation. And this is despite the court's reluctance to recognize self-government in its cramped Section 35 jurisprudence. This reference tells us that legislatures, Parliament, along with other actors, can intervene to disrupt dominant understandings, and that constitutional interpretation can remain a site of struggle over poor rights. So briefly, in the reference case, the Supreme Court upheld federal legislation establishing national standards regarding child welfare and delegating responsibility to Indigenous communities in fulfillment of the UN Declaration on the Rights of Indigenous Peoples. The Act expressly affirms the right of inherent self-government, which you may recall was proposed to be constitutionalized in the Charlottetown Accord, and elevates laws enacted by Indigenous communities regarding child welfare into enforceable federal law. And so it was this that the Quebec government was quite insistent was beyond the capacity of Parliament to do, amounted to a constitutional amendment. The Quebec Court of Appeal and the Supreme Court of Canada reversed unanimously. In their opinion, the justices unanimously characterized the federal law as in service of legislative reconciliation. So though not yet a constitutional right, the court acknowledged that the affirmation of self-government, and here's the lengthy quote I'll read, and you can follow along in this second slide, may in part be viewed as a step toward changing or adjusting the culture underlying the actions of the federal and provincial governments. In a pedagogical spirit, Parliament has used the Act to communicate to the courts and society its position that the law must recognize the importance of Indigenous self-government in relation to child and family services. Thus, the unusual affirmations, in quotes, unusual, use of affirmations of the right of self-government can be explained in part by the fact that Parliament is attempting to persuade other institutions, and that must include the court, to adopt the position it has now embraced. In areas where Parliament cannot order, direct, or command institutions to adopt its position, so the court's hedging a bit, it's not going to take direction in regard to everything. Parliament can't tell the court what to do. This pedagogical function may nevertheless, in time, help to inculcate new attitudes or approaches that will further promote a culture of respect for and reconciliation with Indigenous peoples in Canada. So the ruling appears to acknowledge that executives and legislatures are interpreting and applying the Constitution on a daily basis without judicial guidance, as are Indigenous communities, municipalities, and others, exercising powers that they believe reflect, enforce, reinforce constitutional rights and values, even as the court lags in recognizing those rights. So I take the court as being open to hearing from the political branches about how to interpret the Constitution. And I was prompted to think about this because of the way in which the court has followed the lead of legislatures in regard to some enumerated grounds under Section 15, and also in their interpretation of Section 2A, freedom of association, where they incorporate statutory recognition of collective bargaining rights. So reasons to be skeptical. This is Martha coming back in to say, we've tried this before. She writes, if the socially and economically disadvantaged may not be adequately represented by courts, neither are they well represented by the other branches of government. And in another piece, this is the first from Constitutional Rhetoric and Social Justice, the second from Constitutional Contact with Disparities in the World. The very failure to include poverty, the most common attributes of poverty under federal and provincial human rights legislation, is in some regards the clearest evidence of the socially and politically marginalized status of the poor. Notable, I think, in this regard is the failure of the Charlottetown Accord to amend the Constitution to include a social charter, or even something more modest than the 1992 Social Union Framework Agreement, which, as far as I can tell, has meant little. But even these failed attempts at more meaningful reform may prove to have some utility in nudging Canadian constitutional culture and the judiciary in particular in a more generous direction. I think the reference, re Indigenous youth, families, and children, may come to serve as a model for this sort of movement. But Martha's right to be skeptical. On the other hand, judicial strategies alone don't seem to have worked. So having government perhaps nudge and take the lead is the place we should be looking. Martha, of course, had the courage to press the courts on this front. To borrow a phrase from Obi Okafor, who some of you may know, formerly at Osgoode, now at Johns Hopkins, she's insisted that our laws and institutions exceed their grasp. Otherwise, and this is Obi asking, what's a heaven for? Martha, I think we're all going to be grateful that you sought to bring heaven down to earth.
Thank you. That's great. Great. So thanks, everyone. These papers do really hang together very nicely. I think all of them, in one way or another, reflect on the role of institutions in realizing Martha's vision of social justice in the constitutional sphere. So from Margot, we have a call for courts to do more and to move beyond the thin version of the charter that they've so far adopted. From Aimée, I think a recognition of the challenges involved in finding ways for courts to give meaningful content to different parts of the Constitution, particularly where Indigenous people are concerned. From Colleen, a call to develop new strategies for shaping Section 15 with a focus on social equality and inclusion. And then from David, a call for legislatures to take the lead and for courts to take the lead from legislatures, drawing on the recent case in the Indigenous child welfare reference. Okay, we do have a tiny bit of time for questions from the floor. So I'd like to invite anyone with a question. I see, oh, sorry, YY, you're not moving to the microphone. There are 2 microphones at the back of the room. And so we do have time to take a question or two from the audience. If you'd like to pop up and offer a thought. If I don't see anyone come up immediately, I might ask Aimée if she wanted to expand on her list of questions that I prevented her from providing. I think let's do that, Aimée. No one's coming up right now.
Sure. I'm happy to do an abbreviated list of questions and have a discussion with the panelists also about their thoughts. I really love how all of our comments kind of fit together. It's almost as though we'd sat together and thought this through. But the big question that flows from, the case that I talked about, but the long history of interpretation of Indigenous rights by courts is, this recognition of self-government. Will it ever actually find its way into Section 35 recognition? And is it the role of the courts to do so? And I think that question has already been posed. And if there was a recognition of self-governance as part of the Constitution, Section 35, would it be subject to charter scrutiny? I think what we are hearing from the court now is that Section 25 would shield it, but that's a really important. I think what and you'll see that I pointed to this in my talk, is that the space of legal pluralism is just not fully explored in the court's conception of this constitutional interplay, and I think that that's a big gap. So I would ask that question. What's the role of legal pluralism? What of the concepts that arise from the United Nations Declaration on the Rights of Indigenous Peoples, is the Canadian constitutional construct appropriate for the delicate task of balancing Indigenous individual and collective rights? And that tension between individual and collective rights, I think, is in the minds of most of the people in this room in some way, shape, or form, but the particularities of it in an Indigenous context, I think, are underexplored by the courts, and attempts to do so have been uncomfortable. So that's the gist of my questions. But
Great, thank you. Thank you, Aimée. So we have a question here at the back. If you don't mind, maybe yeah, I'll take the question here, and then if you don't mind introducing yourself first, and then we'll take a question from Carrie, and maybe we'll take them together, and those will be the last kind of 2 questions before we break.
Thank you. My name is Joachim, and I am soon to join the University of Ottawa to pursue my LLM with a concentration in health. And I saw this opportunity on the website for the Faculty of Law, and I'm really impressed. It's been very eye-opening, and I'm glad to be here. And I'm very appreciative to Martha for the great work that she's done that has opened all our eyes. And yeah, so my comment, it's more of a comment and not as much a question. Oh, I come from Uganda, and I'm here now in Canada. So it's a common law system, so there's a lot to pick up from, and there's a lot to learn from here and to compare with what's happening in Uganda. There's a lot about the health rights of the people in Uganda that are being suffocated, and you can't say everyone has a right to health and then a bunch of people do not have a right to health. So this has been very, very eye-opening. So my comment is about what Colleen talked about, that socio-economic rights needn't only be left to courts, but civil society organizations should come to play. When she spoke about that, what came to my mind was the constitutional policies of the political question doctrine and public interest litigation. So through this, I wanted to add on to her voice that lawyers too have a role to play through the PIL. Thank you so much.
Wonderful, thank you. Carrie.
Hello, I'm Carrie Frock from the University of New Brunswick, and my question relates to, it's interesting how conferences develop, that there's certain themes, and even from the opening remarks, the theme developed that this is about community and about togetherness. And my question relates to, how do we marry section 7 and 15? It's something that I've worked on, it's something that others have worked on, Martha included. And I've been doing some work on loneliness, and there's developed a lot of data about how loneliness affects people. I think the Solicitor General in the US said that loneliness is equivalent to smoking a pack a day in terms of the health effects, which is really startling. And there's also really good data on exclusion and how marginalized groups suffer from loneliness. And I'm wondering if that's a way, because we talk about a lot of conceptual things with section 15 about inclusion and political participation. And I wonder if that's a way to talk about social inclusion in a really granular way, is bringing that into section 7. So that's a thought that I'm wondering if the panel wants to explore.
Great. So final thoughts from the panelists in 1 minute less or less each.
Oops, is this on? I don't know how to work this microphone. Okay, can you hear me? Okay. Thank you for both of those comments. The first one was just a comment, so maybe I'll just respond to Carrie's comment about loneliness. I know when I was talking to Sheila about presenting, she also highlighted this notion of belonging as a concept, which sort of resonates with loneliness. And I think that it really, to my mind, it speaks to a need for creativity, to various concepts that help to provide creative meaning to legal concepts. And so I think that's absolutely, that loneliness certainly does resonate with issues of social exclusion, and also pressures to assimilate in order to be included, which I think speaks to that as well. So I think I found that most interesting reading and work I've done is when I take concepts from outside of law and try to use them to nourish the content of our legal concepts. So maybe, I think that's one example.
Oh, okay. So Susanna Moody has something to say about loneliness, right? And I didn't want to be seen to be belittling that sense of community. I felt it on occasion, and I think it's immensely valuable and important. And I think Colleen was pushing in some of those directions as well. But that I think doesn't address what I was trying to get at, which was the public nature of this and how we the public, need to organize to get stuff done. Thank you.
I might just go to Aimée now online. Aimée, you had some interesting comments along the way about, who are the relevant communities in these discussions. So wondering if you have anything you'd like to say about in response to Carrie's question.
Yeah, Carrie, I love that work and thinking about loneliness and exclusion. In an Indigenous context, I think it's very important to consider who are the groups, who are the collectivities, especially as we consider, as I said, that interplay between the collective and individual rights, but understanding the colonial imposition and discriminatory dimensions of how collective identity has evolved in an Indigenous context. So, those outside forces that have molded and shaped in sometimes very disastrous ways, sense of collectivity, even shifted power dynamics and imposed or encouraged patriarchy within certain Indigenous contexts, I think all need to be significantly addressed as we contemplate kind of, who is the group, what are the groups, and what are the mechanisms of exclusion that are associated to that. Great question.
Last word to Margot.
Thanks. Well, thanks for the initial comment. And then, Carrie, your question's really interesting. I think there's something to be said about the sort of creative meaning of what rights fully capture. And so I think about loneliness, about sleep, all those sorts of things that security of the person entails, but also how the relative maldistribution of them gets caught in Section 15's equality framework. But it really makes me think about the complexity of the social materiality of well-being. So there's loneliness, but there's also the importance of being able to be alone, which people who are unhoused don't necessarily have. So there are counterparts to that, and there's probably some interesting connections between that as well. But really the idea of conjoining social to justice should push us to the kind of place you're going with looking at loneliness, again, the complexity of the materiality of well-being that social justice seeks to capture.
Thank you. So merci à nos panélistes. I'd like to invite you to thank our panelists.
Okay, so thank you everyone to be here. I'm really happy to be here with you. It's such an honor to be here as a moderator of this very rich panel to celebrate the career of Martha Jackman and its profound impact on the Canadian jurisprudence and literature on Section 7 and 15 and on economic and social rights. So we will have 4 panelists today at this panel: Professor Lucie Lamarche, Professor Alexandra Flynn, Professor Y.Y. Brandon Chen, and Professor Kristen Vizina. Professor Lamarche will present in French as well as Professor Vizina. You have, I think, an application, Wordly, with you. If you don't have the application, you can scan this code, and you will have it. And there's also an option to have the translation with your headphones. Just have to push on the button in the application. Professor Lamarche, she's a professor at the Faculty of Law, Faculty of Political Science and Law at l'Université du Québec à Montréal. She has been a member of the Quebec Bar since 1978, and she's a director of the Ligue des droits et libertés du Québec. She is also a Jean Monnet Fellow of the European University Institute, holder of the Mérite Christine Tourigny Social Justice, of the Quebec Bar, holder of the Prix Pierre Dansereau for the social commitment of a researcher, Association canadienne française pour l'avancement des savoirs, and a fellow of the Royal Society of Canada. Since 2018, she has served as a member of the Court Challenges program of Canada's expert panel on human rights. And from 2008 and 2013, we were pleased when she was a director of the Human Rights Research and Education Center here at the University of Ottawa, and she held the Gordon F. Anderson Chair in Human Rights. She teaches in social and labor law and international economic and social human rights. So, sans plus tarder, Lucie, je te cède la parole.
Merci, David. Does this work? It does. Martha m'a ordonné de parler français. Alors, tout le monde sait combien je suis obéissante. Je m'adresserai donc à vous en français d'abord pour remercier et féliciter les organisateurs et organisatrices de cet événement. C'est un matin extrêmement touchant, émotif et ô combien riche en engagement social. Je voudrais exprimer toute ma solidarité avec ma collègue, la professeure Sheppard de McGill. S'il vous plaît, transmettez cette solidarité de la part de ma communauté à votre communauté. Exprimer aussi mon désarroi. Ce matin, mon institution s'apprête à demander aux tribunaux le démantèlement du campement pro-Palestine de l'UQAM. Shame on us. Et finalement, c'est ma dernière mauvaise nouvelle, vous dire que je me présente devant vous assez honteuse de résider dans une province qui a récemment mobilisé de manière mur à mur et préemptive la clause dérogatoire de la Charte canadienne. C'est pas une gloire. Mais je ne bouderai pas pour autant le plaisir de me retrouver dans l'entourage de Martha, entourée d'amis profondément engagés envers l'aspiration de justice sociale au Canada. Il faut la regarder attentivement, cette salle qui réunit des dizaines et des dizaines d'années d'expérience militante et d'expertise sur le droit et la justice sociale. Chapeau, si nous savons d'où nous venons, j'aime croire que nous savons aussi où nous allons et que nous ne céderons rien, no passerons. La Charte canadienne doit contribuer à l'amélioration du sort de milliers de personnes aujourd'hui marginalisées par la gouvernance néolibérale et d'aucune façon, comme le disaient les conférenciers précédents, ne pouvons-nous prétendre au devoir accompli. Il faut rendre hommage à Madame Jackman d'avoir cimenté de diverses façons cette généreuse société d'espérants et d'espérantes, butée, déterminée et qui a exploré de multiples stratégies pour rendre le Canada plus juste, notamment par la voie du judiciaire. Notons le rôle crucial et le souffle de Martha au sein d'institutions très importantes telles LEAF, NOL. Notons de surcroît son rôle pionnier, j'insiste, envers le programme fédéral de contestation judiciaire. Et notons enfin cette idée géniale, issue du programme fédéral des alliances universités-communautés, qu'on appelle dans le jargon CURA. Tout le monde sait ce que c'est que cette décennie d'expérience CURA. À titre de Québécoise, je dois enfin rendre hommage à Martha pour avoir réussi le difficile pari, je le concède, de garder le Québec au sein du dialogue canadien sur la justice sociale. Vous pouvez me faire confiance, ce n'est pas une mince affaire. On s'en souviendra, la gauche québécoise, expression qu'il faut utiliser aujourd'hui avec prudence et circonspection, était plutôt contre la Charte canadienne, confondant les droits collectifs et les modes collectifs de mise en œuvre de droits aussi fondamentaux que le droit à la vie, la liberté, la sécurité. Je suis de celles qui soufflaient le chaud et le froid, mais Martha n'a jamais lâché le morceau auprès des militants intellectuels et amis du Québec. Elle a toujours réussi à entretenir mon intérêt, mais surtout mon respect intellectuel envers cette vision de la charte et de sa portée dont elle faisait la promotion. La grande qualité des travaux, l'immensité des engagements de ce que j'appelle le groupe Jackman, c'est la mode maintenant dans l'immobilier, le groupe Jackman est absolument époustouflant. Bref, je doute effrontément du fait que Martha prendra un jour sa retraite. Fake news. Tout au mieux, changera-t-elle d'employeur ou, pour respecter la tradition, continuera-t-elle à travailler gratuitement? C'est tout à fait en ligne avec la justice sociale. En préparant ces quelques notes, j'ai choisi de relire Jackman. J'ai vraiment relu plusieurs trucs, Martha. Tu m'as vraiment contrainte à la lecture, là, et grand bien m'en fasse. J'en conclus qu'on peut résumer l'œuvre de Martha de la façon suivante: une immense contribution théorique au principe de justice fondamentale prévu à l'article 7 de la Charte canadienne, notamment en ce qui concerne le droit à la santé. Et il n'y a rien de plus éblouissant, je crois, que cet article fondateur de 1988, qu'elle publiait d'ailleurs dans la revue de droit de l'Université d'Ottawa, The Protection of Welfare Rights under the Charter. Et Martha, mariant la science politique et le droit, affirmait sur un ton que l'on peut peut-être rétrospectivement qualifier d'optimiste ce qui suit, et je cite, where one to ask individual Canadians themselves what they consider to be the values most fundamental to the Canadian way of life, and by definition, those which they would expect to find expressed in our constitutional charter, one of the first responses would surely be the near universal concern for individual social and economic security. Canada is an interdependent community. Et cette affirmation allait devenir centrale, je crois, dans le développement de cette théorie de l'article 7. Martha pousse déjà plus loin l'analyse et offre un contrepoids, un forum alternatif aux voix marginalisées des personnes vivant sur le territoire canadien. Et quelques années plus tôt, Catherine Lippel et moi avons, me semble-t-il, proposé ça, mais dans un langage différent, en disant qu'il fallait marier la judiciarisation du politique et la politisation du judiciaire. Il me semble que le travail de Martha est admirable eu égard à ce mariage du politique et du judiciaire dans sa vision substantive de l'article 7 de la Charte. Le deuxième souffle de cet imposant article de 1988 consiste à habiller la portée de l'article 7 de la Charte en lui conférant non seulement cette dimension procédurale, fair administration, mais aussi sa dimension substantive. Je cite « a guarantee of core entitlement ». Cette dernière dimension est au cœur de la notion de l'obligation positive de l'État comme enjeu de droits humains et emporte, selon Martha, un aspect crucial, l'imputabilité saisie par les tribunaux. S'il y a un mot-clé aujourd'hui, je crois, c'est ce mot « imputabilité ». Dans une conclusion affirmée, Martha conclut que du point de vue constitutionnel, la Charte canadienne elle-même, elle est la source des droits sociaux au Canada. Mes amis, quelle audace tout de même en 1988. Quelle intelligence que cet article qui retourne toutes les pierres pour contextualiser le texte des garanties offertes par la Charte. Tout est affaire de contexte politique et les juges ne pourraient en faire l'économie, croyons-nous collectivement, aux surprises. En 1990, dans un article du Canadian Journal of Admin Law and Practice, Martha précisait un autre aspect important de sa pensée et il s'agit des droits de participation. On en a parlé ce matin. Elle subsumait en quelque sorte une approche classique du droit administratif en démontrant que la charte, c'est un outil, une voie de monitoring du processus démocratique lui-même. Je cite, The charter is to supersede majority wishes in favor of minority interest which would almost invariably lose out if confined to the democratic process. C'est quand même assez musclé et créatif comme approche. La décennie 90 a mis à rude épreuve l'acception des welfare rights au Canada. Peut-être que Martha dirait la compréhension des valeurs canadiennes partagées. On se rappellera des efforts que la société civile hors Québec, j'insiste, à l'époque, a investi dans le projet d'une charte sociale canadienne. Martha n'était pas très loin du groupe, du task force de ce projet de charte sociale canadienne, mais parce qu'elle avait pressenti l'importance de l'article 36 de la Constitution, et plus particulièrement de l'article 36.1c, qui prévoit l'engagement des gouvernements fédéraux et provinciaux de fournir à tous les Canadiens un niveau de qualité acceptable de services publics, ce qui peut-être fait écho à l'espoir de David ce matin, de mobiliser non seulement le judiciaire, mais aussi le législatif. Donc, il y a une conjonction d'éléments dans cette vision d'une portée substantive de l'article 7 de la Charte qui est absolument admirable quand on l'apprivoise sur le temps long. Si on suit le raisonnement de la professeure Jackman, une fédération sans mécanisme d'imputabilité, dont les tribunaux, lorsqu'il s'agit des droits sociaux, c'est une fédération bancale et les tribunaux sont au nom des ambitions et du propos de la Charte canadienne les institutions gardiennes de cette imputabilité. C'est pour cette raison, finalement, que Martha arrive à offrir une vision dynamique de la relation entre les articles 7 et 15 de la Charte et non pas une vision d'autoroute distincte. Évidemment, on en a parlé, la triste affaire Gosselin, on ne se le cachera pas, généré chez Martha ce que j'appelle une rage constructive. Mais à quoi donc, disait-elle, sert l'article 24.1 de la Charte? Et on parlait ce matin du titre de cet article « Sleeping under a box ». Il y a cette recherche du remède utile, je dirais. Et c'est un réel cri du cœur qu'on retrouve dans cet article. Dans un article publié en 2020 en français dans les cahiers de droit de l'Université Laval, Martha dénonce et démontre avec l'élégance et l'intelligence, il va de soi, qu'on lui connaît, les enjeux du mécadrage. Hein? Quand les débats sont mal cadrés, il y a des conséquences. Donc, ce mécadrage des atteintes aux droits chez les plus vulnérables. Formule choc, c'est sa spécialité. Elle qualifie alors d'exclusion constitutionnelle le traitement par la Cour suprême de l'article 7 de la Charte. Parlant de Gosselin et de Tanu-Jaja, des affaires tristement connues de certainement tout le monde qui est avec nous aujourd'hui, je cite la professeure Jackman. Les tribunaux imposent un fardeau de preuves doctrinal et factuel impossible aux populations vulnérables. L'approche de la Cour suprême à l'égard de l'article 7 soustrait un pan entier de l'action gouvernementale à un examen fondé sur la Charte. en imposant un fardeau discriminatoire à ceux qui contestent les mesures inadéquates ou l'absence de mesures concrètes du gouvernement menant à l'insécurité alimentaire, l'itinérance, et dans certains cas en ignorant, voilà la source de la rage constructive, en ignorant carrément les témoignages et les preuves des demandeurs, qualifiant les arguments constitutionnels en revendications non recevables et non justiciables. Ce faisant, les tribunaux ont érigé un mur pratiquement insurmontable aux revendications des personnes vivant dans la pauvreté quant au droit à la vie et à la sécurité de sa personne. Il me semble que ce soit un vecteur porteur et intellectuel central dans la pensée de Martha, qui va avoir cette capacité de travailler extrêmement fort à établir sur ces mêmes lignes le dialogue avec les tribunaux, je pense à Tanujaja, évidemment, Toussaint, etc. J'ajouterais, avec un complice qui n'est pas à négliger, soit notre ami Bruce Porter. Alors, parlant de groupe Jackman, il y a aussi un groupe Jackman-Porter, bis, dont il faut souligner l'excellence du travail. Convenons-en, ce qui est spectaculaire et intellectuellement cohérent chez la professeure Jackman, c'est qu'elle ne lâche jamais le morceau. Cela n'a pas empêché l'enrichissement de l'expérience de la recherche d'un principe de justice fondamentale actualisé. Ce qui fut, ce qu'on a perdu est perdu, mais on ne peut savoir ce que l'avenir nous réserve. Et là, j'insiste sur un élément, quelque chose qui s'est ajouté à l'escarcelle des stratégies des réseaux de justice sociale au Canada et auquel Martha a contribué, c'est le droit international des droits humains et le droit international des droits économiques et sociaux de la personne. Je pense que Bruce disait en 2006, si on avait su, peut-être qu'on aurait fait les choses autrement, eu égard à l'article 15 de la Charte canadienne, mais Martha, elle, estime qu'on peut faire les choses autrement encore aujourd'hui avec une compréhension constructiviste de ce que c'est que ce principe fondamental dans la Charte. C'est un travail d'une remarquable sophistication constitutionnelle, mais qui est aussi ancré dans la réalité de la pauvreté, l'exclusion sociale et dans la recherche-action. Réfléchir, agir, intervenir, comprendre et recommencer. Ça prend du souffle intellectuel, politique et une légitimité communautaire remarquable. C'est ça, pour moi, la signature de la professeure Jackman. Tout comme dans le cas des grandes marques de parfums. Alors, je suis en compétition avec Margot, qui parlait du vin ce matin. Moi, j'ai pensé au parfum. Je crois qu'il n'est pas exagéré de dire que Martha, c'est l'égérie du modèle juridique de la juriste engagée. Alors, c'est pour ça qu'elle ne prendra jamais sa retraite. Et son engagement envers le droit à la santé ancre, traduit, rend extrêmement concret tout cet apport théorique à la Charte canadienne, parce qu'en effet, Martha, c'est une encyclopédie de l'évolution de la loi canadienne sur la santé et de ses déploiements successifs. Et ceux d'entre nous qui connaissent le domaine, plusieurs dans la salle, savent que c'est à peu près aussi compliqué que le droit fiscal de suivre l'évolution des déclinaisons de la loi canadienne sur la santé. Donc, la question n'est pas tant de savoir si tout le monde inscrira ses revendications dans un cadre de référence de droits humains, mais bien plutôt de pouvoir compter sur la Charte canadienne à plusieurs égards, narratifs, politiques, judiciaires, juridiques, que Martha propose, c'est une formule extrêmement riche selon moi, de comprendre comme une gardienne d'une acception égalitaire de la liberté. Alors, cette capacité dès 1988 d'ailleurs, de marier la liberté et l'égalité et de ne pas tomber dans le piège gauche-droite, ce qui est individuel et collectif, m'apparaît avoir significativement contribué à la théorie Jackman. Je conclus en regardant un brin vers le futur dans les 2 minutes 3, 4, 5 qui restent. La gouvernance néolibérale se technocratise et si tant est que l'on croit aux droits économiques sociaux reconnus ou non explicitement dans les chartes, il faut reconnaître que désormais ceux-ci sont gérés en mode crise. La crise du logement, la crise de l'itinérance, la crise des opioïdes, de l'inflation, de l'immigration, on pourrait poursuivre, ce qui tout de même laisse en sourdine l'effectivité du principe de l'indépendance entre les droits sociaux et cette liberté égalitaire. Faut-il se méfier des crises? Comment les manipuler? Le registre des droits humains, de plus, c'est assez nouveau, est capté par des lois cadres. Alors maintenant, on ne confère plus de droits, on les affirme dans les lois cadres. Et enfin, troisième élément, mais il y en aurait bien d'autres, les welfare rights se fiscalisent, soumettant les nombreuses aides fiscales aux aléas des lois sur le budget. Voilà une mystérieuse rencontre à venir entre les lois budgétaires et la charte. Ces politiques publiques, nouvelles moutures, doivent être mesurées à l'aune du postulat de la professeure Jackman. Welfare rights are constitutionally protected as Canadian values. Alors, les habits neufs de l'empereur ne changent pas le fait qu'il s'agit des habits de l'empereur. Donc, il ne faudrait pas perdre de vue le caractère de valeur des transformations. Oui, mais alors de quels droits sociaux contemporains s'agit-il? Je crois que Martha dirait on en a peu à cirer de la forme de la livraison des droits sociaux. Ce qui importe, c'est la centralité de la mesure de la marginalisation. C'est la marginalisation qu'il faut corriger plus qu'il ne faut agir sur la forme des droits sociaux. Mais on voit bien que plus que jamais, le travail de Martha est pertinent et que la question du caractère inclusif et transformateur des remèdes exigés doit être raffinée et, j'allais dire, rethéorisée. Alors, je crois sincèrement ne rien avoir à offrir à Martha pour calmer sa colère, mais je compte sur toute son énergie. Alors, petite confidence pour terminer, vous irez lire en 2006 un truc assez rigolo que Martha avait écrit dans la revue Options politiques. Je suis certaine que certaines s'en souviennent. Il s'agissait de savoir si ceux qui ne sont jamais contents au Canada, c'est-à-dire le mouvement pour la justice sociale, devait acheter une carte de membre à vie à ce qu'elle appelait le Court Party. Vous irez voir, la réponse est dans le dernier paragraphe de l'article et la réponse est oui. Tout le monde est invité à acheter ce membership au Court Party. Alors, chère Martha, cette retraite, j'en suis persuadée, je me répète, tu sauras me contredire, pro forma. Ceci dit, il ne faut jamais rater une occasion de célébrer non seulement l'incroyable qualité du travail de quelqu'un que l'on aime et que l'on admire, mais aussi manifester son amitié et son admiration pour les incroyables réseaux de solidarité que Martha a su conclure ou construire au nom de cette théorie inclusive et ambitieuse. Mais Dieu merci, elle est ambitieuse, de la justice fondamentale et constitutionnelle au Canada. Chère Martha, le vélo, mais près de l'université.
Merci beaucoup, professeur Lamarche, pour cette présentation très riche et tout en élégance, comme on y est habitué. Our next presenter is Professor Alexandra Flynn. She's a professor at Peter A. Allard School of Law at UBC. Her teaching and research focus on municipal law and governance, administrative law and property law, particularly in relation to precariously housed people. She has published widely on how cities are understood in law and how they govern, including the overlapping geographies and governance of city spaces and the formal and informal bodies that represent residents. She is currently leading a CMHC and SSRHC funded project focused on Canada's housing crisis. And prior to entering academia, she practiced banking and securities law in New York, where she was the recipient of several legal aid awards. She also practiced Aboriginal law at Radcliffe and Company in Vancouver and worked in as a senior policy role focused on intergovernmental relations at the City of Toronto. She has a long history of volunteer work in the areas of homelessness and access to justice.
Thank you.
À vous la parole.
Thank you so much. A bit of a newcomer to the party, but very grateful to have been included and to have been welcomed so generously by the organizers and of course by Martha as well. As I was thinking about this talk, maybe in sort of contemplation of Martha's next step and all the time she'll have for reading, I was thinking about this book, The City and the City, which is an incredible book if you haven't read it before. It's a mystery novel, and it's about two overlapping cities that exist in the same physical space, but are perceived as distinct by the citizens of each. And central to this book is the concept of unseeing. And unseeing is ingrained in the psyche of residents from childhood. Children are taught a mental discipline of refusing to acknowledge what is actually right before them and is in close physical proximity to them. And it's reinforced through norms and through laws, even through architecture, through signage, through all sorts of mechanisms that make these two spaces separate from one another. And of course, this has profound consequences of citizens as well, especially if they so happen to dare to see the other space. But the thing is, once you see it, you can't unsee it. You can't revert to your previous state of ignorance. The revelation is profound and it's irreversible, and it challenges the very fabric of reality. It's akin to discovering a hidden dimension that coexists with your own perception of the world. So this book follows a detective, Detective Borloo, as he investigates a murder that takes place in one of the cities that he then has the ability to see. So of course, this has complete resonance with Martha and Martha's work. It has resonance for many of us here in the room, if not all of us, and many who couldn't join us today, because like Martha, we're inspectors, we're picking up clues and we're making findings. And it's a humbling task. It's a painstaking task to gather, especially when it comes to law, the arguments that are going to fuel not just the immediate case that's in front of us, but to set in stone decades of social change. And while you're doing this work, you can never be quite sure that you're amassing the right clues or you're headed in the right direction. But like the work that Martha has created, once you see them, once you see those clues and they take you down the journey, down the road of the inevitable conclusion, you can't unsee them anymore. So this quote from one of Martha's many articles, which I tried to read as many of that possibly could over again, says, "A constitution is more than a legal document. It's a highly symbolic and ideologically significant one. It reflects both who we are as a society and who we would like to be. Inclusion of certain rights and principles in the Constitution say a great deal about the stature and importance, and the omission of others has the same effect. So there's two themes that I want to pick up from Martha's work in the short remarks that I'll make today. The first has to do with the effect of constitutional interpretation on the most marginalized. And this is crucial not just for understanding law, as many other scholars have noted, including Martha. We really understand law best when we see the perspective of those who are the most marginalized, from those who have the least access to legal protections. That's how we understand law the most. And Martha has written about this in detail, what effect constitutional interpretation as it's done has on those individuals who are least represented by courts and by government. So that's one theme. The second is constitutionalism in its broadest sense. Who are the broad range of constitutional actors that exist in mobilizing and in seeing the constitutional protections that either are there and recognized through formal ways, or that many of us see but haven't yet received their fruitful recognition? So I'm going to talk briefly in the context of housing about how things do, factually speaking, look really bad, right? They look bleak. Second of all, that the tools that exist seem really inadequate for addressing them. But then third, how we can look differently, how we should look differently in order to really mobilize and move forward on change, especially for the most marginalized. Okay, so housing prices are ridiculously high. If anyone here, if any of those here have teenagers or young adult children or loved ones, you know how hard it is now to buy a home. This is a significant change over just the past generation. It doesn't get any better for renters. For renters, the struggles are very real, both for accessing housing, but also for maintaining it. So one of the really awful qualities of tenancy laws across the country is the degree to which landlords can raise rents enormously between tenancies. And so that's resulted in a record-breaking high of no-fault evictions. Across the country, 65% of evictions are no fault. The tenant hasn't done anything at all wrong to cause this to happen. In BC, where I live, it's 85%. So really bad. It's looking terrible from that perspective as well. And the effects on particular populations are especially acute. So those who have the least amount of affordability and are in the most amount of core housing need are single mother-led households, refugee claimants, and seniors. And the result of all of this as well is, as Martha recently opined in the newspaper, is skyrocketing homelessness. Homelessness cannot be distinguished from the housing crisis itself. We don't have good data. The figures that I just reported on don't include homelessness. They don't include those young adult children or loved ones that you may have. They're not captured in the statistics that we have. So it's probably even worse than we can imagine. So compounding this is the inadequacy of many of the tools that should exist to protect this core basic need. Our Constitution is silent on housing. In sections 91 and 92, we don't see housing mentioned anywhere. Moreover, the Charter has been an inadequate tool for addressing poverty for all the reasons that many of the speakers have spoken about. Numerous cases that have not recognized housing, have not recognized poverty as an analogous ground. We do have some bright lights in the future. We have a federal piece of legislation that recognizes adequate housing as a fundamental human right at the federal level. This gives us some hope. Martha and Bruce have written about this, as have others, but so far we haven't seen this lead to positive legal change. And then finally, we have this. We have governments that are all pointing the fingers at one another, saying that they're responsible for addressing this issue. And so what we see, despite some developments in, for example, the federal budget, some new spending that's being created, some tangible change like in BC. There's some momentum that's happening, but we certainly don't see the realization of the right to housing in the way that many of us would like to see it. So that's all the really bad news. And it is bad, right? It looks really bleak. But what I'm going to encourage in the last few minutes of this talk is to take Martha's mantle and look differently, to see other pathways forward. And I would suggest that one of the ways that we can do this is actually through subsidiarity and is through looking at what is taking place at the municipal scale. So cities are a weird kind of body. They're a government on one hand. They represent their citizens. They are elected officials. They're responsive to those in front of them. We've all heard of the right to the city, the way that social inclusion is promoted through democratic practices that somehow are best able to manifest at the local scale. At the same time, though, they're administrative bodies in law. They're not held to account in the same way that governments are. There's charter sections like Section 3 that actually don't extend to municipalities, as a very distressing Supreme Court of Canada case recently held. And for the purposes of this talk, cities are also the main site of the housing crisis. This is where we see cities having to act because the problems are right on their doorstep. So if we were going to see differently, if we were going to look at the charter and at the Constitution through this lens, through the lens of subsidiarity, what could we see? What would become visible in front of us that we might not be able to ignore in the future? So in a Supreme Court of Canada case, the court recognized subsidiarity as applying at the municipal scale, stating that lawmaking and implementation are best achieved at the level of government that's not only effective, but also closest to the citizen affected. And I imagine if you're like me, a skeptic about the law and about how far the law can go, you might be thinking, well, the last thing we need in the context of housing is subsidiarity. The last thing we need is a repetition of the decades of downloading that's been driven to the municipal scale with property taxes that are completely ineffective at solving this humanitarian crisis that exists. And you're absolutely right. The city is, through subsidiarity, is definitely not the body that's the most effective, that's the closest to the citizen affected for the purposes of addressing the housing crisis. But what they are is a level of government that can be held to account for human rights violations that take place at the scale that they operate on. And we have seen this in close vividness through the Adams decision, which recognized the human rights violations that were taking place through the exercise of bylaws that prohibited unhoused people from being able to carry out the most basic of human functions, and the degree to which that just could not exist. One of those situations where municipal governments, as a government, were simply not able to engage in a human rights violation that they were manifesting. And this has exploded in recent times. This decision, with a very slow, immediate rollout over the last 3 years as homelessness has exploded across the country, we see the legacy of this decision, this BC Court of Appeal decision, where Martha was quoted as achieving more and more and more recognition of the degree to which cities cannot engage in this form of human rights violation. It's been used in different ways, the Charter, Section 7, different ways to argue that human rights matter, different arguments that are being asserted as to how this section of the Charter, this constitutional provision, operates in practice. And Martha agrees in response to one of the latest decisions, a finding in Kingston, Ontario, that a bylaw prohibiting sleeping in the park was contrary to Section 7. Martha noted that this was an inevitable result because of the human crisis caused by a lack of housing. and that it would continue, that it wasn't going to stop until cities and other governments stepped up and until they did more. And so there's some degree of change that's taking place at the municipal scale. I'll show a few articles in a moment. Some amount of, tiny homes and provision of porta potties and things like that that make the lives of those living in encampments slightly better. But you know what else there is there's real change that's taking place at the municipal scale. So I just want to talk very briefly about a case that I've been involved in, which is a vacancy control bylaw that was introduced by the City of Vancouver, one of the only vacancy control laws that applies in Canada. The other is at the provincial scale in Quebec, which protects those renters that I spoke about previously, those people who, when they're displaced, their rental units are able to go up in cost enormously. So Vancouver decided, after years and years of advocacy from incredible people pushing and changing and embodying the constitutional culture that David spoke about earlier, they decided that for rooming houses, the last resort housing for very, very poor people living in Vancouver's downtown east side, that landlords could not increase rent above a very small fraction of rental cost. Landlords challenged the bylaw. They won. They won at the lower court. They won at the Court of Appeal. And yet advocates persisted. The City of Vancouver persisted. And just last week, the provincial government agreed to enshrine the bylaw in law at the provincial scale to protect what Vancouver had done. So this is the right to housing being realized at the municipal scale in Vancouver. And there's other ways that cities are also taking this legacy of cases, these charter cases, which only maybe move the pendulum a tiny bit, but recognizing that they are human rights actors that will have to modify what they do, however small. And so that's really where I want to conclude my remarks, is that social justice is a hard road, right? It's not an easy road to be doing the kind of work that Martha has done and that many of us really believe in doing. Sometimes we don't know if the clues that we're picking up along the way, if the pathway that we're working towards is the right one. It's opaque, it's dark. We don't see a lot of successes in the work that we do. This is especially true of the Constitution and of constitutional change. It is a big hippopotamus that we are trying to move forward collectively, all of us together from behind, pushing it. But we have to do it. We do have to do it. We have to keep pushing for change. And I think we also have to keep seeing the fruits of that change when we unsee a very narrow interpretation of what the Constitution is. So Martha, I really want to thank you for the work that you've done in your career. You've done so much in this path to recognize social justice. For me, as somebody who tries to engage in a lot of different ways to move this hippopotamus, I look to you as a mentor, even though I just met you today in person, as somebody who's helping us imagine a different constitutional world. So thank you.
Thank you very much, Professor Flynn, for this insightful presentation. It was really interesting. Our next presenter is YY Brendan Chen. He is a associate professor at the University of Ottawa Faculty of Law, Common Law Section, with expertise in constitutional law, health law, and immigration and refugee law. A lawyer and social worker by training, his research leverages social, legal, and action research methodologies to identify and examine injustices that surface at the intersection of international migration and health. His published work has touched on such topics as migrants, health and rights, social determinant of health, border control of infectious diseases, and medical tourism. He is currently the Vice Chair of the HRV Legal Network, and he previously served as the Co-Chair of the Community Alliance for Accessible Treatment. He has also acted as a co-counsel, along with Professor Jackman and Vanessa Grubin, for a coalition of interveners in the case Toussaint versus Canada.
Okay, so to start, like many others, I'd like to thank the organizers for giving me this opportunity to be part of this event. Beyond being a colleague, Martha has really been, an inspiration, a mentor, and a friend. I relish the opportunities whenever I have to work with you and to learn from you. I'm incredibly honored to join the conversations that we're having today to really celebrate and to reflect upon the voluminous and remarkable scholarship that you have produced. My presentation today hopes to pay homage to your work, Martha, by bringing together both, Martha, your commitment to a strong publicly funded healthcare system that is universally accessible, as well as your advocacy work for a robust guarantee of socio-economic rights and corresponding government duties under the Canadian Charter. And to that end, my presentation today will revisit the federal court's now decade-old decision in the case of Canadian Charter for Refugee Care, and will make a case for recognizing positive socioeconomic rights under Section 7 of the Charter, at least when life, liberty, and security interests are threatened by government's retrogressive measures. To be sure, I do not suggest that Section 7 of the Charter should be interpreted as protecting positive rights only in cases where life, liberty, or security of the person is threatened by regressive measures. Like Martha, I'm in support of Section 7 being interpreted as imposing on the government a broader set of a broader set of positive obligations that the government will have to uphold, including furnishing Canadians with basic necessities of life, such as essential health care. So that's not what I'm proposing. What I'm proposing is effectively a step towards realizing that vision, a way to kind of nudge the court forward, given the Canadian judiciary's general reluctance to recognize a full range of positive socioeconomic rights under Section 7. My proposal offers one possibility for court to expand the scope of Section 7 protection incrementally. So let me now turn to the case of Canadian Doctors for Refugee Care. As many of you would know, the case was precipitated by the Government of Canada's decision in June 2012 to cut the interim federal health program, a program that provides healthcare coverage to refugees, refugee claimants, and many other migrants. I won't get into the details of the cuts here because they were rather complex and they have since been restored by the current government. It suffices for me to mention that prior to June 2012, all beneficiaries of the IFHP enjoyed virtually the same level of health care. So long as one is covered under the IFHP, they were entitled to a list of healthcare goods and services similar to what lower income Canadians would typically receive under provincial health and social assistance programs. The new IFHP that was introduced in 2012, however, divided the beneficiaries under the IFHP into 4 groups, roughly based on how closely they resembled what the government at that time considered to be genuine refugees, right? So essentially, the less likely a person was to be considered genuine, the less healthcare that they would be eligible for. And so according to that logic, government-assisted refugees, along with persons that are detained for immigration purposes and victims of human trafficking, were the only ones that maintained the level of healthcare coverage enjoyed by all beneficiaries under the former program. Okay? Everyone else saw their healthcare coverage reduced in varying degrees, with some people even losing their healthcare coverage altogether. 3 advocacy groups led by the Canadian Doctors for Refugee Care, along with a handful of refugee claimants, challenged the legality of these cuts at the federal court. And ultimately, the court ruled in their favor, holding this 2012 version of the IFHP in breach of the charter. One central finding of the federal court in this case was that the cuts to the IFHP were introduced with an intention of making refugees and refugee claimants' life more difficult, such that they would leave Canada more quickly and others like them would be deterred from coming in the first place. Or in the words of the court, the IFHP cuts constituted what the court called a deliberate action of the state. And so on that basis, in an extraordinary move, the court found such government action, especially given its harmful effect on migrant children, a cruel and unusual treatment contrary to Section 12 of the Charter. And so to the best of my knowledge, this was the first and the only time to date that Section 12 of the Charter has ever been successfully invoked to overturn a government measure outside the criminal justice context. Now, that's the court's treatment of Section 12. Okay? Contrast that to the court's, the way that the court addressed the applicant's Section 7 claim in that case. Despite all the federal court's remark about how the case involved unusual circumstances, the court decided to treat everything as usual under Section 7. Right? The applicant in this case, choosing to focus on the government's decision to cut the IFHP, had argued that their Section 7 Charter claims actually more closely resembled cases involving negative rights, where the government actively deprived the life, liberty, and personal security of affected individuals, rather than positive rights. Those are, again, cases challenging government inaction, right? So they're arguing that this is not a case of government inaction. They're actually doing something, again, to make the life of refugees and refugee claimants deliberately worse. And yet, the court was unsympathetic towards this argument, even with all its references to the IFHP cuts being a deliberate state action. The court held that Section 7 claim made by the applicant in this case was still a claim of positive rights. And the court concluded, and I quote, "The current state of the law in Canada is that Section 7 of the Charter, its guarantee of life, liberty, and security of the person do not include positive right to state funding for health care. Consequently, the applicant's Section 7 claim must be dismissed." And in my view, this was a missed opportunity for the federal court to advance Section 7 Charter jurisprudence with respect to socioeconomic rights. Instead of emphasizing the lack of precedent respecting positive Section 7 rights to state-funded healthcare, I argue that the court should have sided with the applicant in this case and imposed on government a positive duty to restore the IFHP. And here, I just want to recall Chief Justice McLaughlin's statement in her majority decision in Gosling, right? That the question is not whether Section 7 has ever been or will ever be recognized as creating positive rights. Rather, the question is whether the present circumstances warrant a novel application of Section 7 as the basis of a positive state obligation. And we know that she expressly left open the possibility that a positive obligation to sustain life, liberty, or security of the person may be made out one day in what she called special circumstances. And I would argue that one such special circumstance is where a person's life, liberty, or security of the person is harmed by government's deliberately retrogressive measures. And to interpret Section 7 this way will bring Canada actually further in line with its obligations under international human rights law, which provides for the progressive realization of economic, social, and cultural rights. This concept of progressive realization, on the one hand, affords government some flexibility in fulfilling its obligations with respect to economic, social, and cultural rights in light of such realities as resource constraints. But more importantly, and on the other hand, it imposes concrete responsibilities on government to strive towards the realization of these rights as expeditiously and as effectively as possible. And as part of this responsibility, governments are highly discouraged from backsliding on human rights gains previously accomplished. And so in its general comment number 14 on the right to health, the UN Committee on Economic, Social, and Cultural Rights explained this principle of non-retrogression under international human rights as follows. And I quote, and this is the quote on the slide, as with all other rights in International Covenant on Economic, Social, and Cultural Rights, there is a strong presumption that retrogressive measures taken in relation to the right to health are not permissible. If any deliberately retrogressive measures are taken, the state party has the burden of proving that they have been introduced after the most careful consideration of all alternatives, and that they're duly justified by reference to the totality of the rights provided for in the covenant in the context of the full use of the state party's maximum available resources. And I think these comments make it clear that deliberately retrogressive measures with respect to socioeconomic rights are impermissible under international law unless they're duly justified. And so this presumption of non-retrogression, coupled with a burden on the government to duly justify any prima facie breaches, as you can see, can easily be accommodated in our charter context. In this case, will be a Section 7 followed by a Section 1 analysis. And so that's my proposal. But to impose a positive duty of non-retrogression under Section 7, admittedly, could potentially run into opposition on several grounds, including jurisprudential, conceptual, and/or institutional resistance. And so to wrap up my presentation, I will just briefly respond to some of these oppositions. And so in the Canadian Doctor for Refugee Care case, the federal court dismissed the applicant's Section 7 argument in part by citing a number of cases in which retrogressive measures had been found incapable of grounding a Section 7 or really any charter breach, right? So for example, in the case called Farrell, a case concerning whether Ontario's repeal of its Employment Equity Act violated the Charter's equality guarantee, the Ontario Court of Appeal remarked that if there is no constitutional obligation to enact the legislation at issue in the first place, as far as the requirements of the Constitution are considered, the legislature is free to return the state of the statute book to what it was before, right? The impugned legislation. And you see similar remarks in other cases. However, I think that these cases run counter to the Supreme Court's subsequent charter jurisprudence. To name but one example, in Shauli, Chief Justice McLaughlin and Justice Major acknowledged that although the charter does not confer a freestanding constitutional right to health care, and this is the important part, where the government puts in place a scheme, right, to provide health care, that scheme must comply with the charter. And so that to me suggests that regardless of whether the government is under a constitutional duty to act to begin with, once the government has chosen to act, the resulting law or program will come under the charter's scrutiny, and the government cannot shirk its charter obligation by reasoning that it is not constitutionally bound to enact the impugned law or introduce the program in the first place. And aside from jurisprudential concerns, any interpretation of Section 7 as including positive obligations, as we all know, will also likely encounter assertions that the scope of such obligations is imprecise, and that judiciary lacks the institutional competence to sort out what many people see as essentially questions of social policy. And we see, that position taken by Justices Binney and LaBelle in Shauli, for example, saying that, healthcare-related questions are better left to be dealt with by the Quebec's National Assembly, because that's the proper forum for us to decide what is considered to be reasonable healthcare and reasonable wait time, right? But I think my proposal with respect to Section 7 positive obligations, by focusing on the effect of retrogression, actually can largely avoid these kind of arguments. I think in the context of retrogression, the scope of one's Section 7 positive rights and the state's corresponding duty is not defined by what the court thinks or anybody thinks constitute a basic level of life necessities, right? We can kind of skirt that question. Rather, the relevant benchmark is really the level of benefit or protection afforded under the previous law or program. And that, as we know, was determined by the legislature or the executive, right? So, and the role of the judiciary in this kind of situations is confined to assessing whether the impugned retrogressive measures have threatened one's life, liberty, and security of the person, and whether any such threat accords with principles of fundamental justice, as well as the proportionality requirement under Section 1. And so all this, I argue, falls squarely within the court's constitutional adjudicative function and their expertise. And so that's kind of my modest proposal, my way of kind of moving the hippopotamus, as Alex just mentioned. And hopefully that is one way for us to kind of crack the Section 7 positive rights discussion, or the door further open. Thank you.
Thank you very much, Professor Chen, for this very interesting presentation on the potential of the principle of non-regression in international law for the Canadian jurisprudence. Et la dernière conférencière, mais non la moindre, la professeure Kristen Vézina. Kristen Vézina researches social and economic rights and health injustices. She uses social legal theory and empirical methodology to investigate the law in action as it is or is not mobilized by social actors. She seeks to better understand the legal culture of human rights that reproduces the marginalization of social and cultural economic rights, such as health risk, housing, food, and standard of living in Quebec and Canada. She seeks to position economic and social rights in the practices, representations, and values of actors working within and on the periphery of the judicial system. She is the principal researcher of the Action Research Community on Economic and Social Rights, la communauté de recherche-action sur les droits économiques et sociaux, which brings together co-researchers from 7 Quebec, Canadian, and French universities, including Professor Lamarche, Professor Jackman, Professor Young, and Marie Carpentier, who are here today. It's also gathered people from Quebec institutional organizations, and from Quebec and Ontario non-governmental organizations. So, la parole est à toi, Kristen.
Merci. Alors, merci beaucoup de m'avoir invité à prononcer cette conférence en français. Je pense que ce sera plus doux pour vos oreilles, mais il sera bien sûr possible pour vous de poser des questions en anglais si requis. Alors, bon, c'est l'occasion, bien sûr, pour moi de remercier les organisateurs, les organisatrices de cet événement qui est vraiment important, je pense, dans les travaux réalisés en matière de justice sociale au Canada. Alors, merci beaucoup pour cette invitation qui me touche au plus haut point, puisque j'ai l'impression de lire Martha Jackman depuis que je suis toute petite. Et je suis déjà bien avancée en âge, mais je suis encore, je ne sais pas si on peut encore dire une jeune prof, ça fait seulement 10 ans que je suis professeure, mais en tout cas, voilà, la pensée de Martha a vraiment contribué à structurer ma pensée sur les enjeux relatifs aux droits économiques et sociaux. Et je suis très heureuse, très touchée de m'inscrire dans cette transmission qui forme le pouls qui fait battre le cœur de notre métier de professeur. Merci, Martha. Alors, je souhaite aujourd'hui vous présenter une partie de mes recherches relatives à la culture juridique des droits de la personne. Il s'agira pour moi de partir des constats tirés de mes premières recherches sur les tendances à la Cour suprême du Canada pour voir en quoi et comment ces tendances se répètent dans la jurisprudence des tribunaux inférieurs. Ici, en l'occurrence, j'ai choisi de m'arrêter à la jurisprudence des tribunaux inférieurs relative au campement des personnes itinérantes. Je trouvais utile dans mon titre de mentionner le contexte post-pandémique dans lequel on se trouve. Je voulais par là rappeler que la pandémie de COVID-19 a agi comme un véritable révélateur des failles de l'État-providence et des injustices socio-économiques, ayant eu pour effet de limiter la réponse de l'État face à cette crise. Il me semblait donc important d'isoler cette variable pour tenter d'évaluer son influence sur l'appréhension par les juges du besoin d'État. La question principale qui sous-tend ma présentation est celle de savoir comment la culture juridique des droits de la personne qui prévaut au Canada opère en excluant les droits économiques et sociaux. Et puis, en réponse à cette question, il y a 4 points qui seront traités au cours de ma présentation. Le premier point portera sur la présentation de cette culture juridique des droits de la personne en tant que matrice d'exclusion des droits économiques et sociaux. Le deuxième point de ma conférence portera sur la mise à l'épreuve de cette matrice dans la jurisprudence des tribunaux inférieurs relative au campement à travers le Canada. Le troisième point portera sur les possibles voies de passage des droits économiques et sociaux au sein de cette culture juridique des droits de la personne. Et enfin, si le temps le permet, quelques pistes de réflexion prospective. Alors, tout d'abord, la culture juridique des droits de la personne, de quoi on parle ici? Alors, je souhaite préciser que les écrits de Martha, les écrits de Bruce, les écrits de Lucie, les écrits de Colleen Sheppard ont contribué, bien sûr, à me faire prendre conscience du fait que le statu quo perdure en matière de droits économiques et sociaux et qu'on fait face à des murs qui semblent infranchissables, mais qu'il existe par ailleurs une multitude de vecteurs qui sont susceptibles d'être mobilisés dans le droit. Donc, face à ce constat documenté de manière exceptionnelle par mes collègues, j'étais un peu obsédée par ce besoin de comprendre pourquoi ça ne bouge pas. Pourquoi le statu quo qui perdure? Et donc, c'est dans le contexte de cette question que l'idée de travailler sur la culture juridique des droits de la personne m'est apparue pertinente. Ce concept-là, la façon dont je le mobilise dans le cadre de mon travail, je l'appréhende à travers une perspective socio-juridique pour me donner des outils, une panoplie d'outils autre que celui du droit positif pour penser l'exclusion des droits économiques et sociaux. Donc, le fait d'utiliser le concept de culture juridique des droits de la personne me permet de regarder le droit de l'intérieur, du point de vue de ses raisonnements juridiques et ce qui en reste concrètement dans les faits. Moi, c'est surtout ça qui m'intéresse, qu'est-ce qui en reste concrètement dans les faits. et aussi de faire un pas de côté par rapport au droit positif pour le regarder un peu plus de l'extérieur, pour faire ressortir son modus operandi, pour faire ressortir ses rouages cachés. Autrement dit, le concept de culture juridique permet de rendre visible ce qui ne se voit pas à première vue. Il s'agit concrètement des pratiques, des idées, des représentations et des valeurs qu'entretiennent consciemment ou non les acteurs du système juridique et qui forment le droit. C'est donc sur cette base que j'ai réalisé une première recherche qui mettait en lumière les tendances de cette culture juridique des droits de la personne au sein de la Cour suprême du Canada. Et j'ai réalisé aussi, toujours en mobilisant le concept de culture juridique des droits de la personne, une autre recherche plus empirique, celle-là, en effectuant des entretiens avec des avocats de l'aide juridique et des ONG au Québec. Alors, ces travaux antérieurs m'ont permis de constater que la culture juridique des droits de la personne non seulement produit et reproduit le statu quo juridique, mais qu'elle s'impose aussi de manière hégémonique, c'est-à-dire que elle s'impose, cette culture, sans laisser la possibilité de s'en sortir. C'est pour cette raison qu'elle forme une véritable matrice qui moule le droit en excluant les droits économiques et sociaux. Et donc, c'est la forme du moule qui nous intéresse ici. Une fois qu'on a extirpé le droit de ses arguments juridiques, donc je ne parlerai pas de l'article 7, je ne parlerai pas de l'article 15, j'ai plutôt cherché à extirper le droit de ses arguments juridiques et de sa rhétorique. Qu'est-ce qui reste? C'est ça la question qui me préoccupe. Quels sont, autrement dit, les éléments irréductibles qui forment cette matrice d'exclusion des droits économiques et sociaux? Alors, voilà ici quelques éléments de cette première recherche là, qui a été faite sur la culture juridique des droits de la personne, les principales tendances à la Cour suprême du Canada. Dans le cadre de cette recherche, j'ai structuré le travail sur la base de 3 indicateurs de droits de la personne. Les titulaires de droits, qui sont-ils? La nature des obligations qui s'imposent à l'État et la méthodologie employée par les juges pour rendre leur jugement. Donc, en parcourant un échantillon de 10 décisions de la Cour suprême du Canada issues du contentieux relatif aux droits de la personne en matière sociale, donc principalement santé, logement, éducation et pauvreté, j'ai rattaché à chacun de ces indicateurs ce qui se passait concrètement en pratique. J'ai essayé de faire ressortir les représentations de ce qu'est le droit, de ce qu'est un droit de la personne, de ce qu'est le rôle des juges selon les acteurs juridiques eux-mêmes, ainsi que les valeurs cristallisées dans chacun de ces éléments constitutifs des droits de la personne. On voit ici les éléments les plus saillants. Premièrement, on constate une récurrence dans les caractéristiques des titulaires des droits de la personne. Pour être un titulaire légitime de droit, il faut soit être une personne autonome, une personne responsable de ses choix. C'est la première combinaison gagnante pour qu'un juge reconnaisse la personne comme étant un titulaire de droit. Et j'entends par là la reconnaissance en fait, j'entends par titulaire de droit le fait d'avoir profité de la protection du droit. Donc, ce qui signifie qu'on a d'abord préalablement identifié une atteinte au droit et que cette atteinte a été jugée non conforme selon l'article 1. Donc, qu'est-ce qui fait donc qu'on peut se trouver comme étant un titulaire légitime de droit? Soit on est une personne autonome et responsable de ses choix, on assume ses choix, ou soit encore on a une condition incontrôlable qui nous empêche de faire ses choix. En dehors de ces caractéristiques, les demandeurs ou les défendeurs, selon le cas, n'ont pas eu accès à la protection des droits de la personne dans mon échantillon. Deuxième point, on voit poindre des caractéristiques qui structurent les obligations de l'État. Celle d'abord, assez paradoxalement, de la symétrie de ces obligations à l'action ou au désengagement de l'État. On constate par exemple que lorsque l'État décide de ne pas agir, les tribunaux sont empêchés de lui imposer des obligations. Cette situation entraîne 2 conséquences. L'État participe lui-même à la délimitation des obligations qu'il accepte ou non de s'imposer. Et tout ce qui relève de ses choix de ne pas agir, de son action par l'inaction, reste confiné dans une boîte noire à l'abri du regard judiciaire. Enfin, troisièmement, on note que la méthodologie juridique, c'est-à-dire les raisonnements, les rhétoriques, les arguments retenus ou non, les syllogismes, l'évaluation de la preuve, des expertises, la crédibilité des témoignages, a pour effet d'invisibiliser les injustices socio-économiques, voire même, et là je fais écho au concept de mécadrage abordé par Martha, évoqué par Lucie, voire même de les travestir, ces injustices socio-économiques, c'est-à-dire de transformer finalement une situation inégalitaire du point de vue factuel en non-discrimination, une situation de précarité en situation de sécurité ou de responsabilité personnelle, etc. Ce phénomène, bien sûr, n'est pas sans faire écho au concept de violence du droit, cher à Pierre Bourdieu. On voit aisément que ces tendances prédominantes dans l'échantillon étudié forment chacune à leur échelle des obstacles à la justiciabilité des droits économiques et sociaux. Leur articulation forme un mécanisme qui s'auto-reproduit et qui protège le système contre les droits économiques et sociaux. C'est ce que j'entends par matrice d'exclusion des droits économiques et sociaux. Cette situation interpelle d'autant plus quand on sait que la force de la culture réside dans sa portée hégémonique. Pour voir, comprendre, cerner le déploiement de cette matrice, d'autres analyses sont bien sûr requises. Elles sont aussi requises pour voir si la culture juridique des droits de la personne s'impose de manière hégémonique ou si on observe des résistances qui s'y opposent ou à tout le moins qui cherchent à y introduire d'autres caractéristiques éventuellement favorables à une protection des droits économiques et sociaux. Dans le cadre de la recherche que j'ai réalisée au fin de la présentation d'aujourd'hui, je me suis concentrée sur les décisions des tribunaux inférieurs, comme je le disais tout à l'heure, relatives au campement des personnes itinérantes, pour repérer, premièrement, ce qui se faisait, pensait, valorisait autour des trois mêmes indicateurs de droits de la personne que ceux décrits précédemment. Ça a été la première étape de mon travail. Et deuxièmement, pour voir si des résistances au paradigme dominant, à la matrice d'exclusion, étaient observables. Les tendances observées dans ces décisions ont pu révéler les mêmes caractéristiques que celles qui nourrissent la matrice, et ce, même quand elles ont eu pour effet, ces décisions, de protéger le droit des personnes itinérantes à demeurer dans leur campement. Autrement dit, et c'est vraiment important de le noter, les décisions qui protègent les campements, soit par le biais d'injonctions, soit par l'invalidation des règlements, s'inscrivent dans la culture juridique des droits de la personne et ne relèvent pas d'un nouveau paradigme. Au niveau des caractéristiques des titulaires légitimes de droit, comme on le voit à l'écran, de manière un peu petite, je m'en excuse. Donc, au niveau des caractéristiques répertoriées dans ces jugements, on observe que même dans les circonstances difficiles que représentent les campements, seules les personnes qui font des choix et qui sont responsables se qualifient comme titulaires de droits de la personne. Une nuance semble être ici apportée dans le bassin de jurisprudence que j'ai étudié sur la nature des choix en question. Il semble en effet que seuls les bons choix permettent d'être reconnus comme titulaires de droit. Ainsi, par exemple, le fait de ne pas choisir le refuge est disqualifiant dans certaines affaires. Est-ce qu'on voit un peu... malheureusement, je n'arrive pas à voir de loin. Alors, j'imagine que pour vous, c'est la même chose. Je m'en excuse. Est-ce que, David, le premier, capacité de faire un choix à l'abri, hein, c'est bien ça qui est écrit? Donc, pour être titulaire de droit, il nous faut avoir la capacité de faire un choix à l'abri, de faire un choix, d'adopter une stratégie pour l'accès aux services, pour être soi-même capable d'aller chercher les services, alors que, par ailleurs, j'observe dans la jurisprudence qu'on est disqualifié si on fait le choix de ne pas aller en refuge, c'est l'affaire Williams de 2014, ou si les juges estiment que la personne est résistante à à coopérer et à avoir accès et à se comporter de manière responsable. C'est dans l'affaire Black de 2020. Excusez-moi. Quant à la nature des obligations, deuxième colonne, qui s'imposent à l'État, tout comme préalablement observé à la Cour suprême, on constate que l'obligation de s'abstenir d'agir de la part de l'État, donc s'abstenir notamment d'interdire les campements la nuit via des règlements, se déploie cette obligation sur un fond d'injustice socio-économique systémique normalisé par le droit. Seule la pointe de l'iceberg, soit l'intervention de l'État via l'éviction ou le règlement limitant l'accès au territoire, est ciblée par l'obligation d'abstention. De nouveaux éléments ont ici émergé de l'analyse, toujours en lien avec ce terrain sur lequel se pose la question de l'obligation imposée à l'État. J'ai ainsi pu constater que l'absence de toute action de l'État en matière d'itinérance, allant des services sur le terrain au nombre de places en refuge et de leur véritable accessibilité, avait une influence sur la reconnaissance de l'obligation de s'abstenir d'agir de l'État. Ainsi, plus l'État est proactif en amont, plus il a les coups des franges pour interdire les campements. Et à l'inverse, moins il l'est et moins il est susceptible de justifier ces interdictions. Enfin, sur le plan méthodologique, les mêmes travers à travestir les faits d'exclusion sociale en situation égalitaire, par exemple, ont été observés. J'ai aussi noté l'importance de faire passer la question posée au tribunal à travers le chat, hein, j'emploie le chat, le petit trou de l'épingle, à travers le chat étroit de la question constitutionnelle. Est-ce que tel ou tel article du règlement porte atteinte aux droits et quelle réparation est visée sous l'article 24 ou l'article 52. Certaines réparations en tant qu'élément constitutif des droits de la personne m'ont aussi interpellée dans l'analyse de ces décisions relatives au campement. Bien que j'estime que ces réparations demeurent dans le paradigme dominant de la culture juridique des droits de la personne, j'ai vu à 2 reprises qu'un peu par derrière, en passant par les réparations, les juges allaient un peu plus loin. Par exemple, dans Adamson, une injonction a été accordée forçant les personnes à quitter le campement lorsque les places en refuge seront disponibles. Dans Abbotsford, la déclaration d'invalidité du règlement s'étend à l'interdiction de camper le jour suivant la nuit. Donc, on a élargi la période possible pour camper dans le parc. Même si je considère que ces réparations sont plutôt associées au paradigme dominant en raison du fait qu'elles découlent, ces réparations, de l'obligation de s'abstenir d'agir qui s'impose à l'État, elles présentent aussi une force de résistance intéressante et c'est ce qui m'amène au 3e point de ma présentation. Le risque avec la culture juridique des droits de la personne, c'est sa tendance hégémonique, c'est-à-dire sa capacité à s'imposer de manière naturelle, comme allant de soi, en tout respect des principes structurants de notre ordre constitutionnel, sans qu'on ne questionne ce fait, sans avoir la conscience qu'autre chose est possible, comme par exemple la justiciabilité des droits économiques et sociaux. Il est donc crucial de s'interroger sur la portée hégémonique de la culture juridique et pour ce faire, il faut s'intéresser aux résistances à cet ordre établi. Si ces résistances existent, l'hégémonie n'est pas complète et par conséquent, le moule de la matrice d'exclusion des droits économiques et sociaux peut changer. Cette recherche effectuée sur la jurisprudence relative à la jurisprudence des tribunaux inférieurs a permis de réaffirmer les grandes tendances hégémoniques de la culture juridique des droits de la personne, comme par exemple la normalisation de l'exclusion et des injustices socio-économiques, comme l'individualisation des problèmes sociaux, comme la désolidarisation. Mais elle a aussi, je pense, permis d'identifier certains éléments de résistance que je souhaite apporter à votre attention. Premièrement, l'élément de l'agentivité des titulaires de droit. J'ai observé dans les décisions une certaine reconnaissance de la capacité d'agir des personnes, de leur propre rationalité. Donc, ça m'apparaît être un élément intéressant dans la mesure où on n'utilise pas, on n'instrumentalise pas cette agentivité pour faire comme si les personnes avaient toute une panoplie de choix puis qu'elles pouvaient choisir les choix qu'elles préfèrent, puisque la panoplie de choix, lorsqu'on est en campement, est très restreinte, n'est-ce pas? Mais quand même, l'idée de cette reconnaissance de la capacité d'agir, si on la rattache à la pleine reconnaissance de l'extrême vulnérabilité des personnes, peut peut-être être une possible voie de passage pour penser autrement les droits de la personne. Le deuxième élément qui m'apparaît être important du point de vue de la résistance, c'est l'exigence d'accessibilité des refuges, là, tel que reconnu plus récemment, tel que reconnu d'abord dans Abbotsford en 2015, puis réitéré de manière beaucoup plus forte dans l'affaire Waterloo de 2023. Cette exigence d'accessibilité des refuges est importante car, bien qu'elle serve au final à permettre l'interdiction des campements, parce que c'est de ça dont il s'agit, si les places sont accessibles, les autorités gouvernementales pourront interdire les campements. Elle a quand même, je pense, une portée structurante en amont, puisque ça implique nécessairement que l'État les rende accessibles, ces places, disponibles et accessibles. Donc, il y a quelque chose à creuser sur son impact en amont, sur le plan de l'action de l'État. Troisième élément de résistance, qu'on porte sur la reconnaissance de l'inaction de l'État pour justifier les campements. On voit dans la jurisprudence que moins l'État a agi en matière d'itinérance, s'il n'y a rien qui a été fait, puis là je fais un lien avec une demande en injonction en 2023 au Québec, portée par la clinique juridique itinérante, on constate que s'il n'y a rien qui a été fait, bien, il est plus facile de reconnaître le droit de l'État d'interdire les campements. Donc, ça signifie que s'il a préalablement agi en matière d'itinérance, encore une fois, ça limite la possibilité de limiter les campements et donc cette reconnaissance peut avoir une portée structurante également en amont. Un élément qui semble être aussi important du point de vue de la résistance, c'est la notion d'intérêt public inclusive. Dans l'affaire Waterloo de 2023, on voit que notamment dans le contexte notamment des demandes d'injonction, souvent on s'intéresse à la question de savoir quel est l'intérêt public est-ce que l'intérêt public va prédominer versus la situation des personnes itinérantes elles-mêmes. Puis dans Waterloo, on sent comme l'idée que, ou enfin la valeur de vouloir élargir le concept d'intérêt public pour introduire également les personnes itinérantes dans cette acception de l'intérêt public. Finalement, comme je l'évoquais tout à l'heure, bon, les réparations ils peuvent aussi constituer des éléments de résistance, des réparations qui seraient transformatrices, même à petite échelle, comme les cas de figure que j'ai évoqués tout à l'heure. Alors, l'ensemble de ces éléments doivent retenir l'attention parce qu'ils peuvent servir à façonner autrement le moule de la matrice pour créer de possibles voies de passage favorables aux droits économiques et sociaux, peuvent notamment inspirer les plaideurs lorsque vient le temps de monter un dossier. Bref, en conclusion, parce que je présume que le temps file, évidemment, ce que je viens de vous présenter ici, c'est une micro-recherche qui s'inscrit dans le vaste chantier qu'impose la recherche sur la culture juridique des droits de la personne, tel que je l'ai défini en introduction. Vous aurez compris avec moi que le concept est vaste, nous amène à la fois à réfléchir sur ce qui se fait concrètement à travers l'outil du droit, puis ce qui se fait aussi concrètement dans la vraie vie à travers les stratégies des acteurs, ce qui nécessite notamment du travail empirique. Donc, c'est un vaste programme, n'est-ce pas, qui s'impose avec cette idée cette volonté de documenter la culture juridique des droits de la personne. J'ai noté ici certains éléments, certaines pistes de réflexion qui méritent notre attention. Premièrement, dans le cadre de mon travail, je me suis concentrée principalement sur la jurisprudence. Lorsque j'ai analysé les tendances à la Cour suprême, je me suis intéressée à la jurisprudence en matière sociale, telle que je l'évoquais plus tôt. Et je pense maintenant que ce qui est important, ce qui serait pertinent, c'est plutôt d'aller documenter cette culture juridique des droits de la personne telle qu'elle se déploie dans d'autres secteurs, dans d'autres champs. Évidemment, on peut penser au contentieux climatique, les affaires matures et la rose, mais également dans d'autres sphères, comme par exemple en matière de liberté d'expression, liberté d'association, parce qu'on constate que les obstacles sont souvent en géométrie variable. Ensuite, aller documenter ce qui se fait en doctrine. Alors, évidemment, la doctrine contribue à cette culture juridique des droits de la personne. Martha a été inspirante, encore une fois, sur cet élément-là. J'ai toujours apprécié certaines remarques que tu faisais dans tes textes relatives à certains auteurs qui maintenaient les fermetures, les triples verrous sur les droits économiques et sociaux. Donc, ça fait partie de la culture. Les curriculums de formation des facultés de droit, ça fait aussi partie de cette culture juridique des droits de la personne. J'enseigne, par exemple, les droits et libertés en première année. Et là, j'ai commencé cette année, après 10 ans d'enseignement, à introduire une section, une séance sur les droits économiques et sociaux, parce que classiquement, ça ne faisait pas partie de mon programme. Donc, ces éléments sont également à documenter dans le cadre du projet, ainsi que les stratégies des acteurs du droit, je l'ai évoqué. Et Vanessa est ici dans la salle. J'aimerais terminer en disant que le travail aussi relatif aux déterminants structurels de la culture juridique des droits de la personne, on l'a évoqué ce matin, notamment en lien avec le rôle du législateur et du pouvoir exécutif, mérite également d'être documenté pour avoir une vision vraiment, j'ai envie de dire, à 360 degrés de cette culture juridique des droits de la personne. Alors, en terminant, merci Martha pour la source d'inspiration que tu as été et que tu continues d'être, et je suis vraiment très touchée de m'inscrire dans la lignée de tes travaux. Merci beaucoup pour votre attention.
Merci beaucoup, Christine, pour cette excellente présentation, très intéressante. Puis ta méthodologie nouvelle sur la culture des droits socio-économiques. Oh, thank you, everyone. Now, thank you to the fourth of you. Sorry, it was an honor to be here today, honoring Martha Jackman. And je pense que vous avez tous et toutes rendu un grand honneur à la professeure Jackman par vos présentations. So now it's lunchtime. So and we will be back around 1:30. Thank you.
Expected to be here and hoped to be here. Don McCrae was one of the deans under whom Martha was a professor in her earliest days, and he sent me remarks. He had planned to be here, but in fact he is still in Geneva on a case, and he sent me remarks. And so my first job is to be Don McCrae and to read his remarks for you. And I have to tell you that the last time I had to read Don McCrae's remarks at a conference to the assembled audience, it was because he had been hit by a skunk and didn't have anything that didn't smell like skunk. So I'm used to subbing in for him, but usually it involves other kinds of challenges. Anyway, this is Don. Martha, I apologize for not being able to be here today for the conference and the dinner this evening, as I had planned to be. And I want to thank Sanda for agreeing to pass on the tribute that I would have liked to make if I had been here. Martha and I go back to the early days when I was dean. Martha was one of the first people hired after I became dean. I well remember the occasion when I went down to Yale to see 3 Canadian law students, all U of T grads. I remember it too. And all were doing master's degrees. Some of these names will be familiar to you. There was Martha, Kent Roach, and Todd Ducharme. And some of you won't know who they are, but they're all professors. I guess Todd's moved on, eh? He's a judge. Over lunch at Yale,
When I was trying to explain that the University of Ottawa was not a law school simply training students to practice law in rural Eastern Ontario, as its reputation had partly been, and I would add that was the best of its reputation, quite possibly, Martha interrupted me and said, "Has the University of Ottawa Law School really changed? Or is it just Don McCrae going around saying it has changed?" Don's text says, that was, of course, vintage Martha. I would say, drop the vintage there. And years later, Don says, Kent Roach said to me, "You know, Todd and I were completely puzzled by that lunch. We were both careful, polite, and respectful, while Martha interrupted you, was rude and direct, and then you offered a job to Martha and not to Todd or me." He adds, "Actually, I don't think it hurt their careers." But of course, that was the point. We were in a process of changing the school and developing new initiatives, a common law and French program, promoting feminist teaching and studies, enhancing diversity, responding to student needs. And that needed someone like Martha, who was not only bilingual, but bold, innovative, and prepared to stand up for her views. And so, in my view, Martha was one of the best hires we made. She worked with Sanda, Liz, and with others who were here and those who came later to build the school's reputation in its commitment to enhancing the study of women and the law and to bringing a feminist perspective into teaching and the functioning of the law school. And Martha has maintained a commitment to feminist and broader social issues throughout her career. She was of great help in diffusing the exam accommodation crisis, which some here may still remember, where the school was under attack from part-time faculty, I'd say full-time faculty, the bar, the press, and the central administration. She has been active not only in her scholarship on law, poverty, health, homelessness, and the charter, but has been actively engaged outside the school in LEAF and NAL. And throughout her career, she has remained committed to these principles, particularly when there was pressure to turn the law school into a large legal factory. Martha has always adhered to the commitment to equity and inclusion that were part of her early years when she joined the faculty. So I want to join those in paying tribute to Martha and thank her for her contribution to the law school and her role in the development of Le Programme de Commandant en Français, for promoting and supporting the ideals of social inclusion that she and others brought to the law school, for her work on issues of health, poverty, homelessness, and the importance of the charter for these issues, as well as for her commitment outside the law school to using law to make an important practical contribution to those issues and encouraging students to do so as well. Merci, Martha. Don. Now, mine's not nearly as nice. And I want you to remember that Dawn had something to say about the exam accommodation. And I have a few things to say about that too. So Martha Jackman is incredibly loyal and occasionally wrong about those who she is loyal to. She can be intemperate, but never gives up on her friends or her politics. If she is your friend, she has signed up for life, as many of you, I think, know. Martha never lets a friendship drift or fail. She is a friend-full person. And she does the hard work of not just staying in touch, but of getting together, traveling to see you, leaping continents to stay connected. Martha gave the best faculty parties, often with both French and English language program colleagues, partners, and children. I remember you guys when you were really little, you were the best behaved of any of the children in the faculty cohort. Back when we had frequent informal faculty parties, and she bridged both the solitudes of the common law in French and common law in English programs and faculty. And they were great parties. Maybe the best was the Halloween party where Elizabeth Sheehy dressed as Barbie, a good 20 years before the movie and while Greta Gerwig was still in grade school, and Sheila McIntyre dressed as Bev McLaughlin in a leopard patterned short skirt, complete with fishing rod to teach Louise Gosselin to fish. Martha wanted someone here to talk about what she calls her Martha-isms. And although I am reluctant, she should get at least a little of what she wants, or thought she wanted. So I offer you briefly 3. At her original hiring interview for a job at the law school, she blew off the student meeting to stay later at lunch with the women faculty. It's true, we were having a good time. When asked to chair a public meeting with the student body to consider broad bar and student complaints that the exam accommodation system was awarding accommodation inappropriately, she began the public meeting with the students by declaring, quote, "We won't be changing anything we do, but we are here to listen to you." Close quote. And this one I wasn't present for, but I think maybe some people who are here were. When interviewing for the dean's position at a rival law school, she allegedly used the F word and warned faculty that she would expect them to do the work. Luckily, possibly not surprisingly, we got to keep her. Martha's teaching also gleams with politics, purpose, and connection. All of her teaching was outstanding, honest, political, and committed. Martha taught the charter course for every year for 36 years. And luckily for the law school and its students, has agreed to do it again next year. She taught charter law as it is, and more importantly, as it should be. In addition to the Cura grants she piloted that Lucie referred to earlier, her commitment to students, to education, and to law resulted in her design and implementation of important, creative, and dedicated teaching modules to ensure access to legal tools to those who are less obvious users. With Nicole Laviolette, she created the Programme de formation pré-droits pour étudiantes et étudiantes nouveaux immigrants et réfugiés, an intense 3-week summer program for new immigrant and refugee students admitted to the French language program. For 3 hours every morning in the summer, she taught the charter course. In the afternoons, the students engaged with guest speakers and took relevant field trips. The objective was to address the culture gap, legal, academic, and social, and other individual systemic barriers the students faced to success in law school. She created in the French language program and taught the charter course, the environmental law course, the social justice course, the women and the law course, and the feminist law reform course in a bilingual format. With Julie Sugarman, someplace here, she then created the online version that has become NAL's FLR RFD 101 online course. The Programme Français de Common Law will be the poorer without her, as will the law school and the law school community. The community of visionary and engaged legal activists can be sure they can continue to count on her. Thank you. And I will... Martha, have you noted how many people have said, "We're counting on you"? You are so not off the hook. Marie-Ève, à vous.
Merci, bonjour, good afternoon, Martha. First of all, I'd like to thank Sanda for thinking about me to say a few words about Martha, as well as the organizers for a really, really excellent symposium. Je suis vraiment touchée que vous ayez pensé à moi pour rendre hommage à Martha. Martha est un modèle, une professeure et chercheuse exceptionnelle, une femme brillante et inspirante et déterminée, et une grande mentor. Martha est l'une des premières collègues de la section de Common Law qui m'a accueillie à mon arrivée à la faculté, avec François Larocque en fait. Elle s'est tout de suite intéressée à mes travaux et m'avait demandé de présenter ma thèse de doctorat lors d'un séminaire de la chaire Greenberg. My PhD thesis was on the criminalization of homelessness and featured a study of legitimation, or how state actors, the police in particular, justify the use of repression and criminal law against the most marginalized people in our society. During the seminar, I presented at length my findings, focusing on legitimating discourses and criminal law theory. When I was done presenting, I remember vividly Martha asking, "This is all very interesting, Marie-Ève, but have you ever thought about making a Section 7 argument?" Of course. Dans les années qui ont suivi, c'est devenu un thème dans nos discussions. Et d'après ce que j'ai compris, je ne suis pas la seule. Et j'ai fini par l'écrire, ce texte, sur l'article 7 de la Charte. Je me suis même fait convaincre d'en écrire un sur l'article 15. En effet, même si Martha a toujours aussi posé un regard critique sur la Charte canadienne, elle a bien sûr énormément contribué à défricher et alimenter l'interprétation de celle-ci. C'est une pionnière, une juriste extraordinaire qui a fait école pour sa pensée originale, créative et ambitieuse, comme l'a dit Lucie, sa grande liberté de parole et d'action, sa foi inébranlable et sa défense vigoureuse du droit à l'égalité et des droits socio-économiques. Mais en raison de mes propres intérêts de recherche, ce sont surtout ces textes sur la pauvreté, la justice sociale et le contentieux stratégique qui m'ont le plus marqué. C'est son sens de la justice et de l'injustice qui m'a à plusieurs reprises servi de boussole. En 2007, Martha a publié l'un des textes que j'aime le plus et que j'ai le plus souvent cité, soit Reality Checks, Presuming Innocence and Proving Guilt in Charter Welfare Cases, une analyse de l'arrêt Gosselin de la Cour suprême du Canada. In this chapter of an excellent book entitled Poverty, edited by some people in this room, Margot Young, Susan Boyd, Gwen Brodsky, and Sheila Day, Martha explains that it was the inability or unwillingness of judges to grasp the context and social reality of poor people, to engage in reality checks, that was partly to blame for Ms. Gosselin's resounding loss at the Supreme Court. At the time, she was making a plea to give a voice to poor and marginalized people. Looking back, I think I can say that the empirical research I have conducted throughout my career has been an attempt to respond to Martha's call to ensure that judges are forced to listen to and confronted with these realities. En terminant, je veux remercier Martha pour son mentorat et pour son œuvre féministe qui est tout sauf théorique et qui m'a permis comme femme professeure puis comme doyenne d'avoir confiance en moi et de prendre ma place comme leader. En 2019, alors que l'université avait retenu ma candidature pour le poste de doyenne et que je m'apprêtais à signer mon contrat, je me souviens encore très bien d'une discussion avec Martha au détour d'un corridor où elle m'avait donné de précieux conseils sur le leadership au féminin comme « Oublie pas de négocier un gros salaire. » Tu sais que tes collègues masculins ne se gêneraient pas, eux. Martha, merci pour ton œuvre absolument remarquable, ton militantisme, ta recherche engagée, ta solidarité, le modèle que tu incarnes pour nous et la voie que tu as pavée pour des générations d'étudiantes et de collègues comme moi. Merci.
Bonjour, je m'appelle François Larocque. I'd like to start by congratulating the organizers of this wonderful conference for a wonderful colleague. That's quite impressive. And I know we were scheduled for one day, but we could, I think, easily fill 3 days of conferences and papers on the themes that Martha care about, which I think is a testament to her productivity as a researcher and her intellectual legacy as a researcher. But I was dean for a little while, so I'm sensitive to the fact that research is only a part of our job as professors. In fact, 40%, if you're curious, the professors in the room know this, 40% is meant to be teaching and 20% admin work. So quantitatively speaking, I argue, Martha's largest contribution to the academic world, I put to you, is to the Programme de Common Law Français, where she taught and sat on committees for 60% of her time. And she did this for 36 years. So it is to this aspect of Martha's brilliant career that I'd like to pay tribute, en français, si vous permettez. Alors, et ça va être très concis, très court, parce que plusieurs des choses que je veux souligner ont déjà été dites, mais je veux quand même le dire parce que, comme collègue à Martha au programme de Common Law français, nous lui devons une très grande marque de reconnaissance. Alors, Martha est une pionnière et un pilier du programme de Common Law français. Je dirais non seulement de l'Université d'Ottawa, mais on oublie aussi de celui de Moncton, où Martha a commencé sa carrière. Martha a enseigné 3 ans au programme de Common Law en français à Moncton, qui est, à quelque sens, le programme qui a précédé ou qui a aidé à donner un envol à ce programme ici à l'Université d'Ottawa. C'est Michel Bastarache qui était là. Ah, c'est bon. Pardon. Bref, alors que le programme de Common Law français de Moncton prenait son envol, ils sont tournés vers Martha. Et nous, Don McRae a eu la sagesse de faire la même chose ici lorsque notre programme de Common Law français avait besoin de prendre ses fondements, ses fondations et d'être pris au sérieux. Et ça prenait donc des professeurs avec beaucoup d'aplomb, beaucoup d'ambition pour aider au programme de Common Law français à s'enraciner. Et pour ce faire, il faut, au moment de l'embauche du programme de Common Law français, quelques caractéristiques de base. D'abord, il faut parler français, ce que Martha fait, évidemment brillamment. Et on oublie parfois que le français, c'est sa langue seconde. Mais elle a contribué au développement d'un corpus juridique de la Common Law français par son enseignement et dans sa langue seconde avec brio. Il faut donc d'abord parler français, mais aussi il faut comprendre, je vous dirais, la mission spéciale et particulière de ce programme-là, qui est de former des juristes, des avocates, des avocats, qui vont être capables de desservir les populations de langue française minoritaires au Canada. Tant que franco-ontariens, des Acadiens, des Franc-Saskois, des Franco-Albertains, des Franco-Colombiens, ont tous passé par le programme de Common Law français et bénéficié de l'apprentissage de la professeure Jackman. Et cette mission-là est tributaire du fait, là je vais parler comme professeur de droit linguistique 2 secondes, tributaire du fait que, bien, dans les débuts des années 80, il y a eu la Charte canadienne des droits et libertés, évidemment, et son article 19 qui donne à chacun le droit d'accéder à la justice dans la langue officielle de son choix, la justice fédérale du moins. Et en 1984, en Ontario, la loi sur les tribunaux judiciaires a été modifiée pour faire du français une des 2 langues officielles des tribunaux de l'Ontario. Et donc, le droit d'accéder à la justice ontarienne en français a pris son envol. Et donc, on a vite compris la nécessité d'avoir des juristes et éventuellement des juges capables de desservir les justiciables francophones des provinces de Common Law. Et donc, ça, c'est un aspect de la mission que Martha a compris dès le départ. Et elle s'est montrée la championne la plus ardente, je dirais, de cette mission-là, du programme de Common Law français. Et pour ça, tu es un mentor et un modèle pour moi. Tant dans la façon de rappeler la mission du programme de Common Law français à nos étudiants, mais aussi à nos collègues. Et que ça fait partie, tant dans notre comité d'admission que dans les comités d'embauche, un facteur important de notre programme. Et donc ça, c'est 2 caractéristiques que Martha a toujours su démontrer d'en donner l'exemple. Elle a enseigné, on a déjà nommé quelques cours qu'elle a enseignés, mais au cours de sa brillante carrière, elle a enseigné Introduction à la législation et au droit public. Elle a enseigné le partage des compétences, le droit constitutionnel, le partage des compétences. Elle a enseigné la charte, évidemment, pendant 36 ans. Elle a enseigné aussi le cours Femmes et droits, le cours de justice sociale, le cours de droit de la santé, le cours des droits socio-économiques, tout en français. Ça veut dire que des milliers de juristes, des milliers, sans exagération, depuis le début du programme, des milliers de juristes, des générations de juristes ont reçu de Martha Jackman une formation solide en critique sociale, en critique féministe du droit, en français, grâce à Martha Jackman. Alors, et ça, c'est sans compter qu'elle a aussi fait des tâches administratives importantes. Elle a été vice-doyenne au programme de commande en français, je vais dire vice-doyenne aux études supérieures aussi, de mémoire, sans compter les nombreux chaires, la chaire Shirley Greenberg et le poste au Centre de recherche sur le droit de la personne. Bref, Martha a touché à peu près à tous les aspects de la vie universitaire au pavillon Fauteux. Incluant évidemment siéger sur d'innombrables comités, incluant, comme je le disais, l'embauche et les admissions. Donc, Martha, pour l'excellence de ta contribution à la mission du programme de commande en français, au nom de tes milliers d'étudiants et de tes collègues qui t'aiment, qui t'apprécient, je te dis un grand merci. Je te souhaite beaucoup de bonheur dans ta retraite, beaucoup de nouveaux défis stimulants, puis je sais que tu vas nous revenir l'année prochaine. Mais que j'espère que tu reviendras encore et encore et encore. Tu as été une collègue et une professeure influente, une collègue généreuse, unique, irremplaçable. Merci beaucoup.
So being given an opportunity to speak about Martha, who I adore, surrounded by so many brilliant feminists, is a real honor. So I want to thank Sanda for asking me to speak about Martha's contribution to feminist law reform advocacy and political work with NAL, and also some forgiveness if I stray slightly from my assigned topic. The first time I heard Martha speak was at a lunch and learn at this law faculty in 2005. She was deflated, speaking about Shauli, and she talked about feeling like she was swimming upstream. It was the first time in law school that I had heard anyone speak so honestly and evocatively about how exhausting, frustrating, and sometimes lonely political, human rights, and social change work could be. Drawn in by her authenticity and her brilliance, at the end of that talk, I worked up the courage to go over to her. I can't remember exactly what I said, but I tried to convey how moved I was by her remarks and that I hoped she would never give up. I was so nervous. I felt like I was talking to a feminist charter rights rock star. I don't remember exactly how she replied either, but I do remember that she was kind and warm. It was my first experience of what would become many, many more of Martha's generosity. Now, almost 20 years later, I can't help but reflect not only on Martha's generosity, but on her resilience as an advocate. Yes, she was deflated. Yes, exhausted, almost winded, but by no stretch did it mean that she lost steam. The year after I first heard Martha speak, the Harper government defunded national feminist organizations by making women's advocacy ineligible for funding. Martha was instrumental in keeping NAL, which she chaired or otherwise ran in some capacity, alive during the Harper decade. There were years with a lot of hope, late nights of editing advocacy letters, creativity, laughter, friendship, and no staff. It's a big deal to keep a feminist organization alive through a decade of defunding. And despite what many of us involved with NAL for those years said, that we were dormant, that we weren't doing much, This really doesn't reflect what Martha and others, including, and I want to mention Alison Dewar here, who I so wish with us today. It really doesn't reflect what a group of women did and contributed during those years. Martha worked tirelessly for NAL, often as part of a small-ish collective of feminists speaking out, using her power and her sharp legal analysis to advocate for substantive equality rights. And while I could list off some of her formidable contributions to feminist law reform during those years, and through NAL more broadly, I'm going to focus on just one piece in particular, which is less about the what than the how. Along with Pam Cross, who I know is sorry she can't be here today, Martha was instrumental in dreaming up a feminist law reform clinic idea in quite a lot of detail. We were going to provide full service law reform campaign support and advice to lawyers and organizations with systemic inequality matters that needed to be constitutionally rectified. We did a ton of research. We consulted a lot of people. We raised money. It was a really cool idea. When it was clear that implementing on it in the way we had originally envisioned was not going to be possible, I was crushed. Martha called me and said, "I'm just going to do it anyway." Bold, undeterrable, resilient. She spent the next 6 months creating the content for a course on the tactics and tools necessary to pursue systemic legislative remedies to inequality. She piloted the original Feminist Law Reform 101 course to a small group of students back in 2013. She took students to the Hill to meet with parliamentarians and learn about how to prep useful advocacy materials. She taught them how to write briefs for parliamentary committees. She explained how government decision-making works and who is who in the public service, and the relationship between those in the public service and those on the political side. She brought in media experts to talk about writing opinion editorials and how to prepare yourself to be interviewed on television. She brought in journalists to teach successful strategy around filing access to information requests. She taught about raising money for systemic feminist change, including the messy and sometimes dangerous politics of doing this work before the Canada Without Poverty decision. She fully envisioned what would be necessary to train up the next generation of feminist law reform activists advocating for substantive equality, and then she just did it. It was brilliant. With financial support from Shirley Greenberg, we eventually turned that in-person course into an open access online course on feminist law reform that NAL has now revised and made its own. But the genesis, both the engine and the brain behind it, was all Martha. It was so strategic. She understood that the only way to secure ongoing systemic feminist change was to make sure that the next generation had the necessary skill sets, networks, and know-how, the training and the relationships, many of which had been lost given the defunding of the sector. When the Liberals were re-elected in 2016, Martha's advocacy picked up again, and I watched and learned from her as she collaborated with other national women's organizations that had been defunded. Martha, again, with incredible strategic thinking and generosity, led the sector using her expertise and relationship-building brilliance to maneuver her way through government offices and politicians, drafted multiple advocacy letters, and ultimately got the sector refunded. We wrote a $1 million grant for NAL and actively advocated with and/or were references for the refunding of NWAC, Dawn, LEAF, FAFIA, and CREA. Martha rebuilt NAL with that initial reinvestment, hiring 2 successive EDs and helping to rebuild a functional organization that is thriving today. But what is truly remarkable is that all of this was done while she was actively parenting her girls and on top of her teaching, research, writing, publishing, and test case litigation, with solid intersectional feminist praxis and incredible humility. One example of this humility is that she would often send me and other young feminists that were working with her advocacy letters or briefs or funding applications she drafted to edit and provide feedback on. She didn't need to do that. In turn, she would comment on our own writing and advocacy with kindness and patience, always making it better. Collaborating without dominating, offering feedback without any hint of judgy superiority, clearly lighting the way. Brilliant, strategic, undeterrable, bold, generous, authentic, deeply caring, kind, and so fun. These characteristics don't always go together, and particularly not in activist circles where even among feminists, protagonism and ego can sometimes take up a little bit of space. But for Martha, they do go together, and there's no protagonism or ego. Instead, this combination of characteristics is her special sauce, as is her deep commitment to friendship. NAL is solid thanks to Martha, and a generation of young lawyers and activists are being trained in the invaluable skill sets required to bring about feminist change. I am transformed by the opportunities I've had to work with you. I am confident that the lives of many, many young women have been transformed by you. Martha, I want to thank you not only for your dedication, commitment, and mentoring, and all the fun we've had along the way, but for what you've modeled in your activism and for the hope that you inspire. And so I'm going to ask everybody to raise even a glass of water if you have one. In admiration, gratitude, and deep feminist friendship.
Thank you, everybody. My name is John Curry. I'm Professor Emeritus of the Faculty of Law at the University of Ottawa and a longtime colleague and friend of Martha Jackman. It's a great honor for me to participate in today's tribute to Martha and to be chairing this, this panel. I love the title of this panel, Securing Social Justice Close to Home, because I can't think of anything more quintessentially Martha than bringing what could be theoretical, what could be abstract down to earth and making it real on the ground. Our friend Lucie did a brilliant job of actually outlining the intellectual architecture that Martha helped put in place over the course of her career surrounding equality rights. But that intellectual scaffolding or architecture was never meant to be confined to the ivory tower or theoretical in nature. It was always meant to have real-world application, and indeed did in Martha's work. And so this panel will in fact be an opportunity for our panelists to reflect on how social justice activism can be made real and can be brought close to home. To do that, we are joined by three eminent colleagues. Carrie Frock is a professor at the Faculty of Law at the University of New Brunswick, where she teaches advanced constitutional law, administrative law, and feminist legal theory. Professor Frock brings a feminist analysis to Charter of Rights and Federalism jurisprudence, and in that vein is preparing a book manuscript tentatively entitled The Gendered Constitution. I'm keeping these bios as brief as possible. There are greater details available, of course, on the website. Our second speaker will be Bruce Porter, a longtime collaborator of Martha's. Bruce is the director of the Social Rights Advocacy Center. He is widely published, many articles, many book chapters on social rights in both Canadian and international law. And with Martha has been engaged in human rights advocacy work before the courts and before the United Nations as well. Bruce in particular has coordinated 13 interventions by the Charter Committee on Poverty Issues at the Supreme Court of Canada and is a leader when it comes to the National Housing Strategy and the National Right to Housing Network as well. And finally, Vince Calderhead, for 30 years, worked with Nova Scotia Legal Aid on a wide range of poverty-related issues. While doing that, for most of that period, he taught poverty law and human rights at Dalhousie's Schulich School of Law. He has frequently appeared before the United Nations, various United Nations human rights treaty bodies, advocating for better protection of social and economic rights in Canada. And he's currently a lawyer at Pink Larkin, where he works pro bono on cases that seek to advance the rights of people living in poverty. Alors, les présentations, les interventions d'aujourd'hui se présenteront en anglais, mais il va de soi que si vous avez des questions ou des commentaires à faire à la fin, en français, je me ferai un plaisir, je me charge d'en faire une traduction libre au besoin, si c'est nécessaire, mais peut-être que ça ne sera pas nécessaire pour nos conférenciers. In any case, let's begin with Professor Frock, and approximately 15 minutes per presentation so that we can leave a bit of time for discussion near the end.
Well, thank you to the organizers. I'm really pleased to be here today and really honored to pay tribute through my work to a mentor of mine, a very important mentor, Martha. For those of you that were expecting a PowerPoint presentation, I'm sorry to disappoint you. In the words of InSync, it's going to be me. So, and you'll have to bear with me a little bit because I'm going into waters that I haven't really tread, and that's to do with scholarly ethics. And I want to introduce you to a little fun fight in my neck of the woods where constitutional scholars are wringing their hands wondering how ethically we as scholars can do advocacy work. And the argument goes a little something like this. We all can see the rise of populism. Populism has as one of its less charming attributes anti-intellectualism and eschewing experts in favor of looking at demagogues and gut feelings. So the idea is, well, if populism is on the rise and people already don't trust experts that much, you know, and constitutionalism is super important, but entwined with power and politics. Maybe we should take special efforts to make sure that our objectivity and neutrality are beyond reproach by observing strict separations between the scholarly work and any activist kind of work. And activism is defined in this little bun fight as anything that seeks a material outcome rather than the pure search for knowledge in the scholarly enterprise. So I'm going to use that, and this is part of a bigger paper, to use that debate as the jumping off point to talk about the ethics of scholarly activism, or to use its less lovely phrase in this debate that's happening, schoolactivism. And I don't like it because it sounds kind of like slacktivism. So, and it's, you know, anything but activism, and in scholarship is pretty active. So what I want to do is I accept the premise that there are certain ethical principles that scholars have to adhere to. So I'm not going to argue against that. I'm not going to argue against the fact that there's something called truth and that maybe we should pursue it. Really, what I want to do is look at the ethical requirements and comment on the fact that of all the different constitutionalists that have weighed in on that, none are really talking about grounding this debate in any sort of reality where constitutionalists who are also activists operate. Martha, me, people on this panel, many others. And it's surprising because this debate about ethics was kicked off by an equality scholar whose name is Turam Ketan. And what was surprising to me as I looked at these various inputs is that feminists for, I don't know, 40, 50 years have critiqued the way that legal abstractions serve to obscure the workings of power within law, and obviously constitutional law is a major element of that. So I wanted to approach the issue of ethical scholarly activism from a feminist perspective. And it's inspired by something that happened to me at the beginning of my academic career that just about totally short-circuited it when I told a hiring committee that I wanted to change the law in the world rather than just focusing on changing the legal canon. And obviously it's inspired by many constitutionalists that have mentored me, including Martha herself, who continues to inspire for her work alongside feminists, frontline workers, poverty activists, who are truly making improvements of the law for people whose needs and wishes elected officials have no apparent interest in attending to quote Eli and our Supreme Court. So what this debate has to do with is something called role morality. And the idea of it is that if you have a certain social role, there may be peculiar aspects of that morality that are different, or at least complicate ordinary morality. We can all think of examples of that when lawyers have someone that confess a crime to them. Typically, we would think of common morality means, well, we report them. But role morality might mean that we don't. If, for instance, that person is a client, that would be a very bad thing if you're a lawyer to report their confession. If you're a priest and they're a penitent, if you're a psychological counselor, of course, this is kind of simplifying things, but you get my meaning. Role morality is something that we have in our particular roles, and scholars are no different. Scholars are to a great extent supposed to be pursuing truth and knowledge. Damn the torpedoes if it's unpopular. Of course, that's a very kind of optimistic view, but that's the idea. So what I say is that certainly there has to be some role morality where, as a scholar, there's a certain degree of independence, of neutrality, but I say that that has to be tempered with a notion of accountability and a notion of feminist accountability to community. And we've been talking about communities and inclusion all, for most of the day today. And it's interesting to me that that notion of accountability, although the philosophers that talk about role morality talk about accountability, but that is absent from the discussion as constitutional scholars. So I'll talk a little bit more about this debate and role morality. I will talk about feminist understandings of accountability and feminism as a set of moral principles in addition to simply political ones. And I'll show how we need to have that as part of our ethics and morals as feminist constitutionalists. And for those that are wondering about my topic, about how a person should be in academia, it borrows from a book by Sheila McIntyre that's called How Should a Person Be? And the protagonist tries on various personas of her various friends, trying to get at the core of who she should be. But the book is also about women's struggles to make something permanent, something that matters. They're concerned a writer, and whether one is talking about art, which is often denigrated, women do it and then call it crafts, or women's scholarship, which is often dismissed as political or merely activism. The struggles are comparative. And it's just as fraught trying to figure out how to live your life as a feminist scholar as it is as a feminist artist living in worlds that aren't really made for you. And the role morality that defines what it is to be scholarly must be sufficiently nuanced to be able to differentiate between external influences that legitimately inform one's moral imperatives and those that don't. A cancer researcher that takes money from Benson's and Hedges, we might want to say, well, perhaps that offends role morality for a scholar, or working with any other well-financed group against the interests of the marginalized. So it's important not to make straw people, when we are making these arguments about what role morality should be for constitutional scholars. It's very few people are actually arguing for this notion of purity, that we should have this pure search for knowledge, or we should be absolutely neutral. I think most people recognize by now that, this purity and neutrality never really existed. It's more about whether or not the integrity of your research is affected by virtue of your motive. Ketan talks about you can pick whatever topic you want as an activist, but when you go into scholar mode, you have to kind of put on a different hat and be totally neutral and just go wherever your research takes you. And he says that the problem indeed is one of motive, because activism, if you're undertaking scholarly research as part of activism, it has shorter timeframes. It requires what he calls an attitude of certainty, and scholars can be lured by the rewards for accomplishing material things. And scholarship, on the other hand, he says, requires time for distance, for research and reflection, an attitude of skepticism, and the reward instead comes from truth-seeking and finding truth and being a knowledge creator. So he says that, the really easy case is someone that skews their research because they want a certain outcome. And so it's dishonest research, and we can all say that's bad. But he says the harder case is someone that, is simply doing the research and becomes celebrated for whatever material outcome that they produce as a result of this research. And he says that perhaps, this research, which he kind of thinks is by its nature short-sighted, although he's never really contemplated feminist research, I guess, which is always playing the long game because results are slow. And when he talks about, people being celebrated for material wins, again, that comes very little in feminism. But he says that even if you're not doing dishonest research, your stance could be contrary to scholarship because you'll be more reluctant to be revising your stance. You might be subconsciously kind of influenced by these celebratory comments about what your research has accomplished in the material world. And so the responses to Ketan's critique, and there was a lot of them, this created a flurry of activity. Some said, well, the psychological element or motive is really irrelevant. Just look at scholarship on its own grounds, and if it's not a good scholarship, then critique it on that basis. Some people said, well, you're going to consign research to social irrelevance if you can't look at what it accomplishes materially. But none of them really talk about who was envisioned when speaking of a scholar activist and who was not. And for example, John, you, the scholar who turned Department of Justice person who penned the torture memos, because he took off his scholar hat when he wrote them, put it back on. He's not an activist, but perhaps people that are making research potentially to be used at the Supreme Court would fall afoul of this rule morality. So to sum up here, because we've only got 15 minutes, what I think and what this theory of role morality fails to cover is that maybe scholars have other sources of role morality. And so in the longer paper, I talk about why feminism is not just a political stance, but it's a moral stance. You have responsibilities to your communities. You have responsibilities to people that came before you. It's a promise and a commitment you make by virtue of calling yourself a feminist. It's just as subject to role morality as being a scholar is. So there has to be some way that we can take the understandings that this debate has developed about the need for nuance, independence, neutrality, because we don't want, people funded by the Federalist Society to be thinking that what they've done is okay, but still incorporate this notion of accountability, which really isn't about people having a say over your work, but being accountable to them for the implications of your work, for how you do the work, the research methods, etc. So I'll leave it at that. Sorry, I went over a little bit, but I'm happy to answer questions about my larger paper. Thank you.
Thank you very much. Thank you very much, Professor Frock. Bruce.
Thanks so much. Yeah, the title of my talk was to reflect on 30 years of collaboration with Martha, sum it up in 15 minutes. It's impossible, Martha. I did a bit of calculation, and I think we co-edited a book. We co-authored 6 book chapters and articles. We co-directed 2 $1 million SSHRC research projects. We co-authored an alternative social charter with a few others, and then we've worked with our wonderful colleague Vince on at least 6 FACTA for the Charter Committee on Poverty Issues, and that's really just the tip of the iceberg. All of the collaboration with Martha has been an act of generosity from Martha. When she met me, I was I was in exile from graduate work in social and political thought and had started up a human rights organization that was dedicated to try to make human rights work for people living in poverty. And we recognized our common mission, but since then, on so many occasions, Martha has lent me her legitimacy, her brilliance, her reputation, as well as her law degree. And her academic credentials to really kind of smuggle me into spaces in which I was not qualified on my own to enter. And she's totally changed the trajectory of my work life, and I will be forever grateful. The fact that we have survived all of those things and remained the closest of friends is a testament to the qualities that people have been talking about today, Martha's loyalty and her generosity and her kindness. So I won't go on because I've got other things to talk about. When a couple of weeks ago, Martha and I ended up rereading the Gosselin Factum that we did with Vince Calderhead at the Supreme Court because we were trying to remember what we'd done with fundamental justice. And we had 2 kind of opposite reactions. The first was kind of depressing. We looked at it and realized that basically we said everything then that we've been saying for the last 25 years. We haven't really learned much, and we're kind of stuck in Groundhog Day, making the same argument over and over again to recalcitrant judges. I was saying, like, we should have been computer scientists or astrophysicists or something. At least things would have moved in the course of our career. Here we are stuck. But the other, and I don't want to focus too much on that because we want to honor the impact of Martha's work. The other reaction was, I actually found it moving and kind of profound what we were saying. And I think that's kind of important, that when I realized, you know, what we were asking for in that case wasn't just adequate social assistance. It was, well, we actually summarized it in the first paragraph or two, that what was at stake in that case was whether people living in poverty were going to receive the equal benefit of the Charter, or whether they were to be constitutional castaways, in the words of Justice McLaughlin. Martha made that phrase more famous subsequently in her article, where she explained how the McLaughlin court had actually succeeded in making people living in poverty precisely that. But the thing that kind of struck me was not so much how sad it is that we lost that case, but how profoundly important what it was that we were working on was, and what a privilege it was then and continues to be working on the kinds of issues that we've worked on. Because these were not actually issues that were going to be solved with one kick at the can. And I don't want to minimize the tragedy of the loss in Gosselin or other cases that we've worked on for people living in poverty. If we'd won in Gosselin, maybe we wouldn't have passed so many homeless people on the way to this symposium. But the issue that we were addressing, a kind of dominant legal paradigm in Canada that excludes the most marginalized, and particularly those suffering socioeconomic deprivation, has a profound dimension to it, which was not going to be solved in a single case. And so I actually feel, kind of in retrospect, incredibly privileged to have worked with people like Martha and Vince in this kind of rarefied space. And we have learned some things along the way, and I think that it's kind of our obligation to try to ensure that we're passing on some of that. Really, it's more a question of kind of wisdom than any specific sort of lessons, but I just wanted to reflect on just a couple of them in the short time about what Martha and I have learned in the process of all of this. I was thinking about a meeting we had back in 1989. It was probably the first time that Martha met the members of the Charte Committee on Poverty Issues. She had published the 1988 welfare rights under the Charter, which really has functioned. If you read it now, it really is kind of the foundational text for our movement. It was then, and it continues to be. So we invited Martha to come and advise us. We had just formed the Charte Canadienne on Poverty Issues to address the fact that poverty issues were not being brought forward in charter cases. The Court Challenges program had initiated a meeting, and out of that came the Charter Committee. And so Martha came out to talk to us about how we might strategize around poverty issues under the Charter. But instead of talking about this incredibly mobilizing and optimistic vision that she had articulated in her article, I think she had the kind of voices of the crits of the time, and you have to realize what it was like back then. There was a lot of skepticism about anybody progressive trying to use the Charter, and we were accused of deluding people living in poverty if we suggested that they should be going to court and hoping for anything from rights which were so often delusional. And so Martha, quite naturally, decided that she'd better warn people living in poverty in the committee about the dangers of conservative courts. And she explained that it was very unlikely that the courts were going to find that there's any positive obligation to protect the right to life or security of the person for people living in poverty by providing adequate social assistance or housing or to address homelessness. And that maybe we need to think about kind of, smaller victories at the beginning. Perfectly sound advice. But we were taken aback by the sense of hurt and anger that we got from the impoverished people at the Charter Committee on Poverty Issues. And it was, of course, unfair to Martha, and she was hurt because of actually, to ever accuse Martha of somehow believing that these substantive claims to positive obligation shouldn't succeed would be entirely unfair. But I think what we miscalculated was there was a dominant notion that what poor people want from lawyers and the law is instrumental victories to address just material deprivation. Surely they don't care about these fine-tuned arguments about the actual interpretation of rights. Wrong, completely wrong. And we learned from that meeting that poor people understand poverty very deeply as a violation of fundamental human rights. And they understand that being excluded from a human rights paradigm that is dominating in a democratic society is probably the worst form of exclusion possible and has all sorts of profound effects. And so that theme, excuse me, that theme has run so deeply, as people have talked about in Martha's work, the theme of the need to understand and interpret constitutional and human rights in an inclusive fashion that doesn't make people living in poverty into constitutional castaways. You have to realize that when we intervened in Gosselin, we were accused of, by some progressive allies, of being quite irresponsible, that there was no chance in a million years that the Supreme Court of Canada was going to accept that there's any positive obligation under Section 7 to provide an adequate level of social assistance. And so we do have to recognize that there has been some progress made. One of the things that most angered people living in poverty was this legal paradigm that suggests that there's no overriding obligation to address poverty or material deprivation, that the rights only click in, according to this paradigm, if the government decides to do something, then they may have to be subject to the Charter, but there's no overriding inherent right to dignity or security for people living in poverty. When we still, there's been so many times when Martha and I have addressed the desire of litigators still to avoid arguing these kinds of overriding positive obligations and to frame arguments within the accepted paradigm that, of course, the only time you have a right is once the government decides to implement a program or adopt legislation, but there's no right, there's no obligation to implement it. But when you think about it, would any other group, in representing any other group, would we go to court and reassure the court that, of course, we're not suggesting that you couldn't simply allow the members of this group to starve to death or to go without any housing whatsoever? That, of course, would not be a violation of their rights. It's only when in the government's largesse it decides to do something, then people living in poverty may have rights to claim. And so there's this kind of underlying notion that rather than inherent human rights, poor people only have rights based on an initial act of charity. And this runs through the kind of way in which people living in poverty and the claims they advance are considered suspect in exactly the way Martha has described so eloquently in articles like Reality Checks. You'll notice in Martha's scholarship, and this has been mentioned, that she always goes back to the facts. She reads the trial judgment carefully, what actually happened to Louise Gosselin or Jennifer Tanenjaja or Janine Godin. How can we actually unearth the way in which a legal paradigm has denied them a real voice, has done violence to the realities that they were living and experienced? And so that ability that Martha has always had, and she feels it so deeply, to see the way in which rights claimants have been denied a fair hearing by a legal paradigm which is premised on the idea that somehow somebody who's a beneficiary of a program doesn't really have an inherent right. They only have an ability to question elements of that program over on the periphery, but not the core element that relates to their fundamental rights to dignity and humanity. And the other issue, just really quickly, that I will mention, and it's the subject of a separate discussion, and it's been mentioned before, is the role of social and economic rights in charter claims. We were always referring to the Irwin-Toye decision from the 80s about how the right to life and security of the person surely may include socioeconomic rights recognized in international law. The problem, of course, is that the courts have considered this a kind of optional category. And so this openness that was expressed very early on in the Charter has never been resolved. And courts continue to treat this as a kind of extra special category of rights. And by referring to and really misapplying Justice McLaughlin's statement that Wai Chen was mentioning, about the Charter not containing a freestanding constitutional right to health care. Therefore, people who need access to publicly funded health care, even for the protection of their life, end up being denied the protection of Charter rights because somehow they, unlike others, unlike people who need private health care, are required to show that somehow there's a self-standing right to publicly funded health care, even for someone whose life depends on it. That, of course, is the issue we're dealing with in the Toussaint case. So the paradox that we've dealt with is that instead of reading the Charter to include social and economic rights, this extra category of rights has been used as a way of denying people living in poverty the enjoyment of fundamental rights, like the right to life and the right to security of the person. We are developing new approaches to the use of international human rights law, and the chair of the panel may be able to provide some assistance with this, but we're looking at the way in which this oft-repeated mantra of courts in Canada that international human rights are not directly enforceable by courts unless they've been incorporated into legislation is so often abused and misunderstood that dualism does not at all mean that there should be no access to justice in Canadian law for rights recognized in international law. It's just that the mechanisms are different. So, sorry, I'm really losing my voice. So I think the idea here is that we have to stop treating these categories of rights as being so separate, drawing on very rich developments in international law now around the right to life, particularly recognizing that the right to life does impose positive obligations to ensure access to housing and healthcare, to address climate change. So we can start to see in a holistic way that accountability to international human rights norms has to include accountability to all of the dimensions of human rights and international law, including social and economic rights, as very core, as Martha has so often articulated, to the values that are fundamental to Canadian society. And I better quit now because my voice is gone. Thanks.
You have 15 minutes to rest that voice before the next round of questions. So Vince.
Thanks very much. I'm someone who's been on the periphery of these kind of get-togethers for decades, and I'm always pleased and relieved when I've been in these kinds of settings, primarily academic settings, when coming over to the side of the group would be Martha, where I would be, and Martha would bring me in, introduce me to this person or that person. And even though I wasn't a scholar or an academic, she would nonetheless make me feel welcome, and that my perspective was an important one. So that's my own personal moment of thanks. I was introduced to human rights by Bruce and Martha. I had the thinnest appreciation of what they were. And I don't even mean social and economic rights. I mean, even the idea of discrimination, the applicability of human rights to government services. All of that comes from Bruce and Martha. And this is going back 30 years, or probably longer, 35 years, maybe 40 years. And I'm a little bit pleased when I reflect that now human rights are everywhere in the world being talked about and are vital and are seen as anchors for justice in the world. Human rights are here. But in terms of my own personal career, I'm the person who works with the scholarly material and to assist in both framing cases and for use as ammunition in courtroom battles. I'm that person. However, even going back a bit further, when I was a graduate student in politics and history, what we were taught, what I was taught, was that philosophers have hitherto only interpreted the world in various ways. The point is to change it. And some of you may recognize that line from 1845. And so that's kind of informed my approach to law and to legal activism. I would call it human rights work. Martha's scholarship has focused on women's equality for sure, the right to health for sure, and the right to an adequate standard of living. I want to focus on the third of those constitutional rights and the right of those in poverty to an adequate standard of living. It seems to me that Martha's uniqueness and contribution as a scholar, in my view, is rooted in two things. Her ongoing and enduring focus on poverty in Canada as a human rights violation. Laser focused, it's there. It was there last year, it was there 10 years ago, it will be there next year and the year after. In addition, her willingness, I would call it enthusiasm, to be involved in what I would call legal praxis. Specifically, a belief that the Constitution of Canada protects the rights of all to live a dignified life. That belief she's dedicated her career to, both as a scholar and in the trenches. She's someone who has put her money, has devoted her time to where her mouth has been, to where her writing has been, getting her hands dirty in the daunting spaces of the courtroom. I mean, the cases that she's been involved in, many of you already are aware of them. Just quickly, for those who don't, Eldridge, hugely important case in equality rights litigation in Canada. She was there in the courtroom. JG, probably a lot of you don't know JG, a constitutional right to legal counsel when in the context of child welfare cases, hugely important. It has constitutionalized legal aid in that context. The Gosselin case, which everyone in this area talks about, from 2002. I sat in the courtroom down the street at the Supreme Court of Canada with Martha, and we sat there as Louise Gosselin's story was brought before the court, the hardship that she faced. And in that context, I recall sitting beside Martha and Martha looking at me, and I was kind of attentive and listening to her as people like Iacobucci and, yes, Beverly McLaughlin started talking about, well, she had choices. She could have done this, she could have done that. Anyone who spent a week, a month working with people in poverty would just viscerally know the shallowness of that kind of comment. And I recall Martha leaning over to me. There's not a lot of open talking in the Supreme Court of Canada, and whispering, and I won't share it, but it's not something that would get published. And then there's Shauli, Tenenjaja, Toussaint, Faulkner. These are all huge cases in the area of social and economic rights. Who was there? Martha. So let me just say a couple of words about Martha's thesis. And it's not literally a thesis, but I'm going to call it a thesis. This is the welfare rights piece from 1988, University of Ottawa. That thesis remains intact. Section 7 of the Charter imposes positive obligations upon the state to ensure that the poor have a right to an adequate income. That thesis remains intact despite what many, if not most, lawyers or even academics believe. Her fundamental thesis remains, in my view, the only principled and coherent approach to the interpretation of Section 7, which gets at both entitlement to assistance and adequacy. No other use of mirrors or rhetoric will accomplish the paradigm that Martha articulated so many years ago. It's a piece that is encyclopedic in its survey of historical, contemporary political, legal, doctrinal sources, and characteristically, Martha grasps the nettle and deals with the hard stuff right up front, doesn't pretend it doesn't exist. It's all there. All the arguments you'll hear today, many of which you've heard in this room today, Martha addresses in that piece. She even throws in a reference to Section 36, which others have mentioned here today and which warmed my heart. Martha's work, as others have said, both informed and informed and inspired anti-poverty advocates for over 3.5 decades. Since the shocking setback of the Mass decision in, I think, 1995, and the heartbreaking result in Gosselin in 2002, the vast majority of lawyers and indeed law professors would say that the claim in Gosselin, the positive obligations claim, is either preposterous or is a dead letter. And yet, Martha's thesis remains not only intact, but in fact has yet to be fully and properly addressed by really any court, let alone by the Supreme Court of Canada. Within the framework of social and economic rights litigation, partially as a result of a combination of what I think of sometimes as self-censorship and timidity by advocates, the rights of the poor to an adequate income have only been more marginalized as the decades have worn on. Social assistance adequacy reached its high point in Canada when adjusted for inflation in 1988. Allow me just to close with my prediction. Bruce and I often make predictions and then court decisions and elections. And here's my prediction. At some point, the Supreme Court of Canada will return to, and for the first time, squarely address the question raised in Martha's thesis. And when it does, I predict that the outcome will bring a smile to the soon-to-be retired law professor being honored here today. Thank you.
Thank you to all of our panelists for those comments. We now have a few minutes available for questions or comments. There are microphones at there's a microphone at that stand. There's another microphone on this side. So anybody who has a question, please direct yourselves towards the back of the room. Sir, please. Could you please take the microphone so we can all hear you? That's great.
That's all right.
That's all right.
Your voice is great for the room, it's not for the folks in the computer. I'm pleased to be here today because I was a student at the University of Ottawa in both common law and civil law, and it's wonderful just to see so many people here talking about social justice issues. But here's my question. We all know that every Supreme Court justice has 4 law clerks. So there are approximately 40 law clerks working at the Supreme Court every year, coming from law students coming from law schools all across Canada. And these law students write bench memos for Supreme Court justices. Has anyone, and they're quite influential actually, if you've ever seen a bench memo, and I'm not going to go into too much detail, but the amount of red ink that happens to be on them, and the bench memos fly back and forth between the judges and the law students. These law students can be very, very influential in shaping decisions made by Supreme Court justices. Has anyone ever done any research into who these law students are, their backgrounds, what institutions they studied at, and more importantly, in the case of what we're discussing here today, the law professors who mentored them?
So I'll give the panel an opportunity to comment on that, but perhaps Professor Rodgers?
Can partially answer that question, I think. But I can't answer the question you really asked. Generally speaking, students who would like to clerk for the Supreme Court of Canada need letters of recommendation, including from their dean, who historically, in my experience, didn't have to rank them, but had to say why they should be chosen. And the choices that are made by any member of the Supreme Court of Canada really are the deciding factor. So one could make a case for example, language diversity, cultural diversity, educational diversity, all sorts of factors that should be taken into account. But in the end, it's the judges, quite likely with the advice of their clerks and quite possibly with a commitment to their own alma mater, because they would be most familiar with the legal education there. So it's a letter of recommendation kind of process, and those are both useful and complex.
Thank you, Professor Rodgers. Professor Schneiderman, perhaps you have something to add.
Is this on? Yes, I have a partial answer. So I participated in a public opinion survey of 3 audiences: law clerks at the Supreme Court of Canada, law teachers, and officials in the Department of Justice. And we canvassed them around a number of constitutional questions and values questions with a political scientist who knows how to do this work. I don't. A guy named Joseph Fletcher. What we learned is that, and we were testing the court party thesis, which is kind of what you're getting at, which was proffered by University of Calgary political scientists, who said that students who go to clerk at the Supreme Court of Canada channel their left-wing law professors' views, and as a result, you get decisions like Andrews and complaining about a number of these decisions. So we wanted to kind of test that hypothesis in this way. So it turns out that law clerks are the most conservative of those 3 groups, right? Law professors, if I recall correctly, we did this some time ago, were somewhere in the middle, and Justice Department officials were actually quite left-wing, it turns out. So that's a partial answer to the question posed.
Thank you, that's very helpful, Professor Schneiderman. Do any of our panelists wish to comment? Professor Fromm.
Well, like a politician, I'm going to answer the question that I made up in my own mind to respond to that. But I think the logically prior question is, where are the law professors coming from that are teaching the clerks and teaching the students? And what kind of diversity, not only, racialized diversity, comments or our commitment to indigenizing law schools, but socioeconomic diversity. Are there people that have that lived experience of being poor that are law teachers? And I've done a little bit of work looking at where law professors come from, and in terms of in Canada, looking at mainly coming from still Oxbridge and the Ivies in the United States, even though we've had graduate programs here for I don't know how many years. Who is it that has the money to go to these elite institutions, for instance? So that's the thing that I'm most curious at, because you see the fruits of that in the kind of scholarship. And I mean, look at Peter Hogg, who's like the god of constitutional law, and the quotes keep on being brought up about socio-economic rights, and these are issues that are fought at the ballot box rather than something that's rightfully dealt with in the court. So how influential are things like that, and are we really investigating where they're coming from? So anyway.
Can I just make a quick comment on David's research? I'm surprised, but that justice lawyers came out as being so progressive. But I think that probably the left-right spectrum might be distorted on this issue. Because I was just actually thinking about this recently. Martha and I were on a case conference yesterday on the Toussaint case, and I was struck again how lawyers at Justice are on an absolute mission of hostility against social and economic rights, against any accountability to international human rights bodies, and basically about any kind of notion that international human rights can be enforced by domestic courts. And I've encountered this at the UN, I've encountered it in cases, and they claim to be operating on instructions, but I actually think that it's very much self-motivated as well. There's some kind of thing happening in Canada, particularly a dominant legal culture, that it's the job of a justice lawyer to defeat any social and economic rights-oriented claim and to make sure that this is considered a completely separate category of rights, that it's non-justiciable, that charter rights are interpreted narrowly as negative rights that don't impose budgetary obligations on governments. And it's had a huge impact, I think, on the evolution of the charter. This notion that justice lawyers should be hostile to social and economic rights, I think it's something we need to deal with.
Right. Other questions or comments? Going once, going twice.
No one wants to fight me. It's so much different than going to a Runnymede event.
All right. Is that you, Sanda, standing to take the microphone? Very good. All right, so then I think what we'll do is we'll draw this session to a close, but I would ask you to thank our colleagues and our presenters today with a warm round of applause. And we have a break now until, if I'm not mistaken, 2 o'clock.
And Sheila McIntyre, one of the illustrious co-organizers of the conference and a very well-respected equality scholar. So without further ado, our panelists are going to speak for about 15 or 20 minutes, and then we'll open it up for questions. I'll turn it over to Professor Chalifour.
Voilà. Ah oui, ça fonctionne. OK. Donc, bonjour tout le monde. Merci beaucoup à tout le monde et puis en particulier à Sanda et à Sheila de m'avoir invité à présenter aujourd'hui en honneur de Martha. Je ne peux pas dire à quel point c'est un privilège de participer à cet événement et de pouvoir réfléchir vraiment directement à l'influence de Martha dans ma carrière et aussi personnellement. C'est grâce à Martha que je suis à l'Université d'Ottawa. En fait, j'ai été engagée par Martha pendant qu'elle était vice-doyenne pour enseigner le droit de l'environnement et ensuite j'ai fait demande pour ce poste, c'est pour ça que je suis encore ici aujourd'hui. C'est elle aussi qui m'a encouragée puis qui m'a poussée à faire une demande avec ma collègue Heather McLeod-Kilmurray et Sophie Thériault, qui n'est pas ici, je ne pense pas aujourd'hui, pour un fonds de recherche CRSH pour faire de la recherche en justice environnementale et en particulier un projet qui a été refusé en premier, mais Martha, comme on a déjà mentionné, a encouragé de faire demande à nouveau et même une troisième fois, oui, une troisième fois, mais avec son encouragement et puis les révisions, etc., nous avons finalement eu un succès. Et puis, c'est Martha qui a toujours pensé aux autres et puis a encouragé tout le monde à célébrer puis à fêter les succès des autres. Et puis, elle a organisé des réceptions pour moi et des collègues quand on a eu des reconnaissances. C'est Martha aussi qui m'a aidé beaucoup lors de ma carrière à équilibrer les demandes de l'enseignement et de la recherche et de l'administration, bien sûr, avec la vie d'être une mère et une famille, puis d'équilibrer ça et d'être efficace dans la préparation des cours sans compromettre la qualité. Donc, pour ça, j'en suis évidemment très, très reconnaissante. Et puis, c'est aussi Martha qui m'a inspirée et qui m'a incitée à faire une intervention pour l'Association nationale droits et femmes, NOL, pour effectivement faire un argument féministe devant la Cour suprême du Canada dans le contexte du renvoi sur la tarification du carbone. Et puis, ça a allumé mon intérêt à ce sujet, évidemment, quelque chose qui me passionne depuis longtemps, mais à continuer à être activiste et puis de représenter NAL et puis ensuite les Amis de la Terre devant les tribunaux pour essayer d'avancer la justice sociale et la justice climatique. Et puis, je pourrais évidemment continuer. Et je suis très heureuse qu'il y a eu plusieurs collègues qui ont fait toutes sortes de commentaires à l'heure du dîner pour que je puisse aussi faire la présentation, parce que si je continuais à parler de tout ce que Martha a fait pour m'inspirer, pour m'appuyer et pour m'aider lors de ma carrière, ça prendrait tout le temps que j'ai ici devant vous. Donc, un gros merci. Je me rejoins aux autres pour te remercier pour tout ce que tu fais pour la profession, pour tes collègues, pour les étudiants, pour le programme de Common Law en français et pour, évidemment, la justice sociale. Donc, cette présentation et la recherche que je fais, c'est pour toi. Et puis, ce que je voulais faire aujourd'hui, c'est, ça avance pas, mais est-ce que tu peux avancer les diapos? Je ne sais pas ça. OK, voilà. Donc, ce que je voulais faire, je vais commencer en français, mais je vais aller en anglais dans quelques minutes. Et puis, je voulais effectivement réfléchir à l'idée du changement climatique et de la justice sociale ensemble. Et puis, jouer un petit jeu de « Où est Martha ?» dans ce sujet. Donc, vous connaissez le jeu « Where's Waldo ?» Mais ici, on va jouer « Où est Martha ?» Parce que, bien que la recherche et puis les travaux puis l'advocacy de Martha sont plus dans le contexte des droits socio-économiques, et moi, je travaille plus dans le domaine des litiges climatiques et de la justice climatique, Martha est là, elle est très présente. Et puis, en fait, comme on va voir, elle a en fait inspiré, je pense et j'espère, un développement très positif dans les tribunaux canadiens en ce qui concerne la justice climatique. Et peut-être même des droits positifs. On verra. Donc, j'ai organisé mes propos, comme vous allez voir, et puis, effectivement, je vais faire quelques commentaires sur les droits positifs dans le contexte de l'article 7, mais je vais me concentrer sur la jurisprudence sur l'égalité et, en fait, la façon que les tribunaux, je crois, interprètent de façon en erreur le droit à l'égalité dans le contexte des décisions canadiennes climatiques. Donc, je veux juste commencer avec quelques propos, puis parce qu'on est à la fin de la journée, j'ai beaucoup d'images, et puis j'espère de vous garder réveillés avec ça. Quelques propos assez sombres, mais vraiment importants pour comprendre les litiges climatiques, et puis que les effets du changement climatique, vous le savez, sont existentiels. Notre Cour suprême a reconnu ça, et puis non seulement existentiels, irréversibles, et donc très urgents. Et puis, il va falloir que je me souvienne de faire les deux en même temps, sinon vous pouvez me le dire. En effet, le changement climatique, quand on parle des effets graduels comme la hausse des mers ou l'augmentation de la fréquence et l'intensité des événements météorologiques extrêmes, sont très graves et ont des effets multiplicateurs pour les personnes les plus vulnérables de la société. Donc, que ce soit les enfants, les personnes aînées, les personnes handicapées, les peuples autochtones, on sait que le changement climatique et ses effets vont avoir des effets disproportionnés pour ces personnes. Que ce soit Carter Vai, qui a été décédé de l'asthme, d'une attaque d'asthme due au feu de forêt et la fumée, ou les personnes mortes qui sont surreprésentées chez les aînés et les personnes handicapées en Colombie-Britannique suite aux vagues de chaleur. Donc, les personnes qui cherchent l'égalité ne sont pas juste affectées par le changement climatique. Puis encore là, on retrouve Martha et ses inspirations dans ses propos, sont également affectées de façon disproportionnée par les politiques mises en place pour répondre au changement climatique. Donc, quand j'ai commencé ma recherche dans cette question, c'est en conversation avec Martha qu'on a parlé du fait que Parfois, ces politiques-là qui répondent au changement climatique peuvent aussi avoir des effets disproportionnés. Et ensuite, j'ai été inspirée en partie par Martha pour faire une analyse féministe de la tarification sur le carbone et puis aussi une comparaison entre les différents outils de tarification comme le cap and trade et puis les taxes, etc., chez les peuples autochtones et puis les personnes vivant en pauvreté. Donc, ce que j'ai découvert, c'est que oui, si les outils ne sont pas bien, s'ils sont pas bien conçus, ils peuvent avoir un effet très néfaste. Donc, ça crée un double fardeau pour ces populations. Et on voit ça aussi dans les politiques d'adaptation ainsi que les politiques sur les pertes et préjudices. Donc, il faut faire attention à ne pas créer un double fardeau et puis il peut même avoir un triple fardeau, mais je n'aurai pas le temps d'en discuter aujourd'hui. Donc, tout ça fait en sorte que des litiges climatiques partout au monde maintenant qui revendiquent des droits, parfois des droits positifs, pour l'action climatique. Et puis, on voit de plus en plus de ces litiges et puis de plus en plus de succès. Donc, en 2015, les tribunaux du Pays-Bas ont reconnu pour la première fois les dimensions des droits de la personne dans le contexte du changement climatique, puis ont tenu le gouvernement responsable pour une action insuffisante, des cibles inadéquates pour le changement climatique. Et puis donc, des droits positifs, effectivement, dans le contexte de droits constitutionnels aux Pays-Bas et les droits européens. Et puis, la cible des Pays-Bas était beaucoup plus élevée que celle du Canada à l'époque, puis elle est encore toujours. Et depuis ce temps-là, il y a eu une vague de décisions partout au monde, de plus en plus de succès, et souvent dans les plus hauts tribunaux, dans les cours suprêmes, les plus hauts tribunaux, dans toutes sortes de pays. Donc, par exemple, en France, on a tenu le gouvernement responsable d'avoir fait des échecs dans leur cible du passé, donc de n'avoir pas rencontré leur cible. On a vu en Allemagne un tribunal qui a reconnu que le gouvernement n'avait pas reparti équitablement le fardeau de réduction des émissions parmi les générations. Et aussi, même en Irlande, qu'on n'avait pas précisé clairement comment les objectifs seront atteints. Et puis, je m'excuse, je l'ai encore fait. Et puis aussi, on a vu dans des décisions, dans des tribunaux internationaux, par exemple, juste le mois passé, la Grande Chambre de la Cour européenne des droits de l'homme, de la personne en Europe, ont reconnu effectivement un gain de cause dans un litige mené par des femmes aînées pour effectivement revendiquer encore de l'action plus ambitieuse par le gouvernement de la Suisse. Et puis, juste il y a 2 jours, le tribunal international de droit de la mer a reconnu aussi des obligations sur les gouvernements pour réduire leurs émissions de gaz à effet de serre pour protéger les océans. Donc, on voit du progrès partout, mais pas encore au Canada. So now I'm going to turn to English. I think there's a button to press for those who are listening to the interpretation. So let's look at Canada. What's happening here? And it's not all bad news. And if we're looking and still playing the Where's Martha game, there's some really positive developments. And I'm a half glass full person, so we're looking for those. So there are 5 lawsuits right now in Canada, 4 that are still in progress and 1 that is complete. And what we see, and I'll talk about them briefly in a moment, what we see in those decisions are there's some convergence. So first of all, there's some acceptance of the climate science, which is very positive. Nobody's debating climate change anymore. There's recognition, look at this, that climate change poses serious risks and disproportionate harms for certain groups like Indigenous peoples and children and youth. So the court have recognized this. It's not being debated. There's also an understanding that we have to act, and that the fact that climate litigation is novel and it presents novel questions isn't itself a barrier. So that's good news. And I see Martha in that. There's also some areas of divergence or uncertainty. I'm being generous in how I characterize that. Some problems, of course, with respect to justiciability. I'll come back to that. Some of these issues are with respect to framing, and in some of the other papers I've written, I go into some length about this. Positive obligations.
the courts in these other jurisdictions have been holding their governments to account in large part for inaction or insufficient action. That's challenging in a Canadian context. We're still fighting an uphill battle in terms of getting the courts to recognize that governments have a duty to create a livable, or to sustain a livable planet. And there's a whole morass of discussion to be had in terms of whether these are negative or positive rights. And of course, Martha and Bruce's scholarship is very helpful there in terms of pointing out that this dichotomy is not always helpful. And there are some really interesting questions with regards to causation, whether we have charter rights for future harms or intergenerational equity, and also really interesting questions on age-related discrimination. So in a nutshell, there's a lot of decisions. There's not time to go through all of them. I wanted to point out a few concerns and critiques that I have with respect to how the courts so far have been interpreting, particularly Section 15. And what we're seeing is repeating what we've seen in Section 15 jurisprudence generally, which is treating Section 15 as a poor cousin to Section 7, despite the court's recent admonition for doing that. We are seeing courts conflating what I think is clearly age-related discrimination against particularly children and youth as something that's a temporal distinction, which I think they're just getting it wrong. They're also, and Cheryl's group intervened on this as well in the Mather case, that they're applying a stricter causation test to Section 15 than Section 7. So if I have time, I'll elaborate a little bit on this in a minute, but I just wanted to give you the Coles notes. That was in the Mather case, which is a case that youth have brought against the Ontario government that is pending before the Ontario Court of Appeal. So it's gotten all the way up. It's the first climate case to have a hearing on the merits, and it was argued before the Ontario Court of Appeal in January, and we're waiting for a decision. And there are some shoots and sprouts of hope in that decision with respect to positive rights, and I'll come back to that because I do think Martha and Bruce's scholarship have been really influential there. The LaRose case and the companion case called Mitsiyik, they've been heard together. They are two decisions in the federal court that are against the Canadian government, fairly similarly framed, against basically arguing that the government's not doing enough fast enough to reduce emissions, and that's harming the clients in this case, which are a group of children and youth, some of whom are Indigenous. And in that case, there was a motion to strike that was pleasantly overturned by the Federal Court of Appeal just recently, but they only overturned on Section 7. So they're allowing essentially this case, these companion cases to go ahead on Section 7, but not on Section 15. And I'll tell you why I think they're wrong there too. Basically, in that the Coles notes is that they characterize the harms as only future harms and completely ignored what is really clearly in the statement of claim, alleging all kinds of present harms to young people because of their physiological impacts. And I'd shown you on the screen just a few slides ago, a young boy who died clearly because of wildfire smoke related to climate change. So I think that's very problematic, and also, followed the Sharma route in terms of being less open to positive rights. And then Environnement Jeunesse, which is the only case so far that's been finalized, and it is by the Quebec Court of Appeal. Leave to the Supreme Court was denied, so it's a very final decision. And again, there they conflated, I think, what are age-related distinctions with generalized harms, and I think really missed the boat. But it can be distinguished, I think, from the other two cases because it was a request to certify a class action. And so in the context of the class action, they didn't include everybody who might be harmed by climate change. So maybe the vehicle wasn't the best one. But so some of those issues conflating, I think, harms specifically for young people or for Indigenous communities were, and that wasn't argued actually in Environnement Jeunesse, but can be distinguished. So how much time is left? Sorry, I put a clock on and then I didn't look at it. So Okay, perfect. So I'll just give you a few little notes, and I want to come back to Martha's scholarship and where it has influenced these decisions. So the Mather case, this is the one that, well, maybe now the LaRose case has some possibility too, because it's moving to a hearing on the merits. Thank you. So the Mather case is the one against the Ontario government. And it wasn't struck out. There was an effort to strike it out. It survived, went to trial. And as I said, there was a decision of the Superior Court of Justice in April 2023, which failed. So not a success on either Section 7 or Section 15, but some hope in the decision. Look at the findings of fact on the screen here. Indisputable that the applicants and Ontarians generally are experiencing an increased risk of death and a risk to security of the person. Thank you. I'm reading from my slide. That Ontario's target falls severely short of the scientific convention. So they do have an inadequate target. And the target is causally linked to the risk of death and harm to security of the person. So that is amazing, right? Amazing findings. And of course, that climate change disproportionately impacts young people, Indigenous peoples. So why did it not succeed? Well, we hope it will at the Ontario Court of Appeal, and we're waiting for that decision. But basically speaking, it failed on principles of fundamental justice. But what the court said, and this is where we come back to Martha and her trailblazing scholarship, is on positive rights, the court said that they do make the applicants characterized their case as a negative rights case because they didn't want to get rejected on this basis. But the judge actually said, well, it kind of is a positive rights case. And you know what? This might be that special circumstance that might justify imposition of positive obligation. So climate change, this might be it. So you were right, Martha, when you said maybe the environmental facts are what will turn the courts, in favor of a more progressive interpretation. We'll see. But so it failed on principles of fundamental justice, but on positive rights, some hope, right? Some shoots and sprouts from the wizened stump of hope there. On Section 15, unfortunately, again, there, I think a very stunted and wizened, as in stunted, interpretation of Section 15. So no general positive obligation on the state to remedy social inequalities, repeating Sharma, but that's not really what was being argued. What was argued is that young people are disproportionately impacted by climate change due to their physiological impacts because of their younger bodies, and also because of the burden that they're going to face as they live on into the future. The court said, well, that distinction's temporal. And what they did is they took a snapshot year and just said, well, everybody, you take 2050, everybody's going to be impacted by climate change. And yes, of course, but some people far more than others. And so, again, I don't want to get too far into the weeds, but myself and my colleague Erin Dovelstein, who's here as well, argued on behalf of Friends of the Earth that in the intervention that we think there were several errors in this analysis, but one in particular, which again, the David Asper Center also argued, was that Justice Vermette actually applied a higher causation standard to Section 15 than she did to Section 7, because in Section 15, she said, well, in Section 7, she said, we have to take the global context of climate change into account, and every emission from Ontario is measurable and contributes to the problem. It doesn't matter that other countries and other jurisdictions also contribute. Ontario's emissions count. But then on Section 15, she said, well, climate change is impacting young people disproportionately, but that's because of climate change. It's not because of what Ontario's doing. So completely internally inconsistent. So I think that's an error that needs to be corrected. And then also quantifying the distinction as temporal, I think, is problematic. Age-related distinctions, of course, are tricky, and there's really no basis, no jurisprudential basis upon which to hang this analysis. But, it's a person's young age that makes them physiologically and psychologically vulnerable. And so, yes, other groups will be impacted too, but this isn't a temporal distinction. This is truly an age-related distinction. And we can talk about this more in questions, because I just want to wrap up so others can have a say, and you can go and perhaps sit out in the sun. This conflation of age and time, I think, and I had all sorts of ideas about Alice Through the Looking Glass, and I never got to it. But think about Alice in Wonderland and time when you're hearing these. But this conflation, I think, was also present in Environnement Jeunesse, but in that case, I think it's distinguishable because it was a request to certify a class proceeding. So finally, La Rose, again, some good and some bad, and definitely some influence here because Martha's work and Bruce's work was cited by the Federal Court of Appeal when it successfully overturned the successful motion to strike this decision, which had been overturned based on justiciability. But the Federal Court of Appeal said, well, no, there is a justiciable question here, and especially on Section 7, we need to hear the case, and there's a reasonable prospect of success. And they did not overturn this motion to strike on Section 15, unfortunately, and they did give the proponents leave to amend their claim because one of the problems with justiciability had been that it was too broadly framed. Lots I could say about that, but I'll continue on. So on Section 15, again, the issue in La Rose was not that they didn't get into the temporal distinction. What they did is they qualified all the harms as future harms. But I played a little game of, it wasn't, whereas Martha, it was actually counting how many times the justices mentioned that this might change in future. So I won't show you all these screens, there's too many, but basically the judge repeatedly said, well, for now, Section 15 can't be interpreted this way. And if you look, they'll say, as the law currently stands, we can't look at intergenerational harms or future harms. First of all, the statement of claim, as I said, cited all kinds of present harm that they just completely missed. But in terms of future harms, even there, why not? Why can't we look at the burden that these children will face as they go into potentially an unlivable planet? And the court hints at this constantly. I've put in green, the shoots and sprouts of hope that I think inspire me and that I can link to Martha's scholarship that, the court says extending Section 15 to this would be an unprecedented application and not the kind of gradual incremental change by which the law evolves. Well, if we wait for that gradual incremental change, the planet's not going to be here anymore, not a livable planet anyway. And the jurisprudential roots of coming back to whys and stumps and shoots and sprouts. I have not wine and not perfume, but I have gardening and arborist analogies for you. That, the judges said again, the applicant's claim have no jurisprudential roots and they're conceptually outside the scope of Section 15, at least as it has been understood to date. Well, isn't it the job of the court to change that interpretation? And I'm hoping it'll be the Supreme Court's role. So I'm going to wrap up. They do acknowledge that psychological distress is a present harm, although they say that's better understood under Section 7. Again, I think it should be understood under both. I don't see why, even though they're interrelated, they need to be analyzed exclusively under Section 7. So to close, I do want to note the part of the decision where the Federal Court of Appeal cites Martha, and particularly acknowledging the importance of positive rights, remaining open to the possibility, this court is saying at the Federal Court of Appeal level, that this might be the time when we can interpret positive rights under the Charter. And in comparing and justifying their rejection of the Section 15 claim, they say that even if the Section 7 claims, even if construed as positive rights, still rest on doctrine, albeit unexplored, that's why it has a reasonable prospect of success. So there's Martha and Bruce, and wow, that's, to me, a reason to be hopeful. So where does that leave us? I did it again. I'm sorry about that. So, where does it leave us? Well, I think I'm hoping that even though Section 15 has been, really relegated to second tier again, even though the Supreme Court has warned us not to do that, I wonder if maybe we can seed some hope under Section 15, maybe by rooting future claims around maybe only present harms and getting the court to focus directly on those and not getting distracted by the future harms, maybe identifying claimants with intersecting grounds. The claimants here do have intersecting grounds, but maybe making more emphasis on that. And maybe as the groundswell of international case law continues to change the jurisprudence globally on this, that maybe the Canadian cases will be pollinated by the fruit of international cases. I just tried to find as many analogies as I could. And so as I close, I do have to note the Supreme Court in 2023 in a disappointing decision on the impact assessment, started in its first paragraph as saying that judiciary has an important role to play in protecting the right to a safe environment. So as we end this game of where's Martha, I think you'll see her work everywhere in this climate space. I think her work is actually helping to sustain the life force of the planet. And we have to ask ourselves, and I'm serious, I'm actually serious. Do we want our Constitution to reflect death, destruction, and the demise of the planet? Or do we want it to be a tool for inclusion, respect, support, protection, and care? I think I know what Martha would say, and now I hope we can hear it from the courts. That's it.
By some unnerving twist of fortune, the final panel, which was about new ways of thinking about Section 15 in human rights law to overcome post-Vreend and Eldridge resistance to substantive and systemic inequality claims. 3 out of 4 of the Section 15 panelists scheduled to address Section 15 have canceled. Is it an omen about the future of Section 15? I'm sorry, it's just rattling, that it all landed here. Because I was a Section 15 scholar, I actually don't accept that we leave this conference without big picture thinking about Section 15. I commend Bruce and Colleen for their contributions, and I would like us to create some more. When Sanda and I first sat down with Martha to talk about this symposium, Martha wanted a blue sky symposium with only good news and progressive examples to go forward with, and we kind of thought that we couldn't get you together on that premise. But she gets a blue sky session, and it's right now, which is, I invite all of you, I mean it, to put your visionary hats on and think largely and audaciously. I've been retired for just over 14 years, or just under 14 years, and I know almost nothing about current Section 15 jurisprudence, which is great. Your comments don't need to be bounded by knowledge of Section 15 law. What courts or tribunals or legislators or constitutional scholars have said before now. You make the precedent. That's actually where the law was when Martha and Colleen and I were in first year, and probably Diana as well. I mean, there are many of you, but I had a course on equality rights before the charter came into force, and the short content was, there were none. That's what we got taught week after week. So I want you to think hard and innovatively about how we should teach about substantive inequalities, how we write about them in our scholarship, pleadings, facta, how we mobilize others, preferably in inclusive coalitions, accountable to those we presume to advocate for, and mobilized by equality principle. I'm going to make, I think it's 4 suggestions, and then invite you to either expand on them or add more. And maybe somebody could undertake to take notes, and then there's a record, because maybe the most audacious claim is, I'm suggesting we do these in a coordinated, consistent, collaborative fashion. Like everybody does it, not just an article here and there. All of the suggestions are resonate of Colleen's concept of constitutional advocacy as a practice of resistance. I would like to say kind of on the confrontational side of resistance. I do think in the same way that time's running on climate change, inequality is worsening at such a pace that urgent doesn't quite cover it. It's time for drastic action. Smarter than oil companies developing techniques to suck out more carbon or something as an offset. It's not offsets. We want something bigger. So here are 4. No less a scholar than Catherine McKinnon on equality said the process of equality thinking and litigation should be describe how inequality operates on the ground, and then argue for a law that would fix that. In other words, you shape the legal argument according to the description of the inequality. And when I first heard her say that in the 80s, I thought that was really great. You know, it would be reality checked and it would be driven by reality of facts, but it actually hasn't worked. Even if you call people castaways, or even if you build on the concept of loneliness to describe the dispossessed, it seems not to work, no matter how compelling a picture of the situation of Gosselin and Bastarache nailed it. It doesn't seem to move the needle. In 2006, I argued in a piece titled Answering the Siren Call of Formalism with the Subjects and Verbs of Domination, that we should flip the model of advocacy, or try it. And instead of describing, educating courts on what it's like to be poor or what it's like to be the survivor of recurrent violence, we argue instead how the suspect law or the challenged law serves the dominant, how it's rooted in the interest of power, how its continuation reflects and perpetuates power, and talk the language of domination to the dominant. In other words, equality isn't something that happens to people, it's something that serves domination, and just talk to power about power. It's a j'accuse kind of strategy. It would take on straight up that we do not know, we didn't know, we never thought, we couldn't imagine, it couldn't be like that, your facts aren't relevant. We take on squarely the both innocence and ignorance of privilege as such, that it serves an interest, and stop trying to think it's just a knowledge problem. I find it hard to describe quickly, but I wanted to give you an illustration from Shireen Razak. She argued that the educational method believed that with a little practice and the right information, we can all be innocent subjects standing outside hierarchical social relations, not accountable for past or implicated in the present. It's not our ableism, racism, sexism, or heterosexism that gets in the way, but their difference, their biology, their lifestyle, their poor choices. In some, the difference approach, they are different. I can't remember who talked about difference today, and I think it's Aimée, but focusing on the difference of Section 25 claimants, that an argument that tries to open eyes to the different from you existence of subordinated groups reinforces an important epistemological cornerstone of imperialism. The colonized possess a series of knowable characteristics and can be studied, known, managed accordingly by the colonizers whose own complicity remains masked. So it's an attack on both complicity and the idea of the other that is kept somehow vital by describing the other for those who have no contact. So that was one. Oh, I have to reach for, no, wait, not my code, her code. 1, 2, 3. Right, that's number one. I think it would be done in Section 7 as well. The second possibility, this was an invention today, so it's not well worked out. As a systemic practice, as advocates, one and all, resist all dichotomies used in human rights in Section 7 and Section 15 analysis. Every single one of them, and expose them. So for example, social versus political rights, state action versus state inaction, positive versus negative rights, democracy versus judicial review, individual versus collective rights, core and non-core rights, formal versus substantive rights, charter versus indigenous rights, constitutional rights versus injusticiable rights, or however that game is played with justiciability, written versus unwritten constitutional rights, and you see how it goes. I didn't write them down probably in the right order in terms of which ones I support and which ones they support, but the idea is pitting them in opposition is the end game for denial of rights. I think actually, generally one is actually a subset of the other. In many judicial efforts, including what you just heard broken down by Nathalie. In Seaboy, for example, in 1991, Section 15 was argued directly in support of the rape shield laws, i.e. the laws that prevent sexual history evidence from being used against a complainant. And the court never mentioned Section 15, not once in the whole argument, other than to say equality rights, not Section 15, equality rights are interests within Section 7. So we'll answer no Section 15 claim. And in this case, it was the other way around, only twice in one case. You've got this right under 7, but not 15, and you've got this right under 15, but not under 7, on the same facts, on the same. So we actually have to probably keep arguing them together. That's not well worked out, but I actually think there's something to it. This third one would have been argued by Faye Faraday. She refers to judges' obdurate refusal to address the role of power whenever they litigate 15 claims. She has an article on Fraser, which also picks up work of Martha Jackman's in Constitutional Forum, which you can read at some length. Her proposal was to create a taxonomy, much like Christine Vézin's, of how they do it, how judges sidestep 15 claims. Again, a little bit like Nathalie's, only not in one case, but the same repeat evasion tactic. Maybe it's justiciability, maybe it's a higher burden of proof, but there are also phrases that recur, which are kind of like the judges in the majority opinion in Ciboye, who said, in the contraception case, Eve, the majority in that case about imposed contraception on a woman with developmental disabilities, the majority judgment, which was all male, had the sentence, "We know nothing about contraception." Kogi, you're supposed to laugh there. The judges say, "We know nothing. I don't know. I'm ignorant." When do judges say that? I'm stupid. I never knew. And our job is to pick out those phrases where they do this disarming stupidity out loud and say, you know what, they did it here, and they did it here, and they did it here. And so it would be like Christine's chart, which goes, it's tactic 1, quote, 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 quote. Tactic 2, quote, 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 quote. Taxonomies, and it could be in multiple fields, but it kind of renders the case comment approach like multiple. You need to work in teams. You can pick a theme and go for it, and computer searches would make it really easy. So what Faye would call it is, the emperor's old clothes. Nothing, he's got clothes on. He doesn't. She doesn't undress them because they do it over and over, and it's not innocent. Here we go again. I tried to put it on never cut out, and it wouldn't accept my fingerprint. This is Margot's machine. Yeah. A number, what is it, 4? Aimée made me think about decolonizing legal concepts of we and of person, of society, of public interest, and most of all, I think, reasonableness, the reasonable person who exists behind the curtain in section 1 analysis. I was reminded of Christopher Stone's famous piece, an article in a book, Should Trees Have Standing, where he wrote, "We are inclined to suppose the rightlessness of rightless things to be a decree of nature, not a legal convention acting in support of some status quo. It is thus that we defer considering the choices involved in all their moral, social, and economic dimensions." I've always thought that every argument I ever made in equality litigation, which Justice Department lawyers would call sometimes utopian, and more people would just say, be reasonable. I never thought I was making up something that wasn't law and wasn't supported by principle, if not precedent, legal principle or precedent. I always thought the cases were winnable. I thought Farrell, which was mentioned earlier, the rollback of equity in Ontario, was completely winnable and argued it as such. I believe in those arguments we make. The judges make choices. And when they deem poor people beyond the scope of a constitution, you do have to wonder what a constitution is for. So remember, when I read "Do Trees Have Standing," I went, what? And now I don't think that at all. And we have to get judges to stop thinking of the claims of the subordinate as the claims of things, or say it's the new person's case. And Lord Sankey, in the person's case, having shown there's no precedent for women as persons, except a queen, but that doesn't count, And there's no precedent for women holding public office, and statutory interpretation doesn't help, except he does serve the purpose. And they say in the middle of that turning point judgment, do women have the right to be persons under just one piece of legislation, Canadian Senate rules? Some people ask why women should be persons in law. This was in first year law. I read this and it blew my mind. And we say, why not? And as a first year law student, when I went, but you've just said there's no precedent and all the precedent is against this principle and you don't like it. So you just say, why not? Women can be persons. So I decide today. They could do it. Every judge you confront could do it. And you all make good legal arguments. We all have done so. And it's a choice. And it's really time for us to get a bit aggressive about it and confront them with, it's really your choice. McLaughlin herself, who rolled back so many things, reversed so many precedent in a very short order, including the labor cases, which were barely 10 years old. The Supreme Court can reverse itself. Without precedent, without new facts, they've done it. And I think we really have to, engage them. There is one more. We have to agree collectively to hammer home what Martha described as the intimate connection between democratic participation, human dignity, and true justice. No democracy without rights. Life, liberty, and security of the person doesn't say that security is only what's in hand. I mean, all the limits imposed on Section 7 are judicially constrained concoctions, confections. And I don't think we've pushed hard enough on democracy is not possible without a positive answer to this question. I do want to say that, Vriend seemed pretty impossible, but there is a precedent for failure to act. Silence violates the Charter when, in the court's view, everybody else is doing it. Sexual orientation is there in 8 out of 10. Okay, so it's meant to be there. I read it in. I made up the words. I think that's it from me.
Thank you both. Thank you both for very thoughtful and thought-provoking remarks. I'll now open it up to questions. There's microphones at the back of the room. So please. That was excellent. Bruce.
Thank you. Funny how this group isn't asking questions. I don't understand it.
Yeah. We all agree.
Natalie, I just, the climate change litigation fascinates me in some ways around this causation question. I wonder about the idea of, rather than finding the causation issue being whether the emissions from Ontario are causing the violations, whether the violation is caused by a failure or refusal to comply with commitments made internationally for collaborative, collective effort among states, that we're dealing now in the global sense with harms that are created and by a failure of states to be holding themselves accountable to international norms, And so the kind of thing that we're working on in the Toussaint case about sort of the good faith obligation under international law, Pacta sunt servanda, it's recognized as a universal principle. John Curry has suggested that it may be a peremptory norm, means that it's a component of fundamental justice if you look at Kazemi standards around fundamental justice. So I just wonder if what you think of the idea of, rather than arguing that the emissions in Ontario are causing the harm, it's Ontario's failure to comply with international commitments in good faith.
That's a great point. And in fact, I remember Bruce and Martha and myself and Aaron and others having conversations about this in the context of this climate litigation. So I think you're absolutely right that that's a very powerful argument. I think the causation one comes up in these cases because the governments, whether it's federal or Ontario government, defend on the basis that they're a drop in the bucket. You know, Ontario Council got up and said, well, you know, it's not because of us that climate change is happening. We're, you know, tiny in the grand scheme of things, point the finger to, you know, US, China, Russia, whoever you want to point your finger to, but we're tiny. And that argument, you know, the sort of de minimis argument has been made in courts around the world as a defense by the governments in particular, who are saying, you know, well, we're trying, but, you know, we can't solve this problem alone. And thankfully, I haven't seen yet a court that has accepted that argument. So even the US courts, US Supreme Court, in a decision many years ago, courts around the world, including our Supreme Court, the Ontario court, have refused that argument, have basically said it doesn't matter. We have a global collective action problem. And if we were to accept that argument, nobody could ever be held responsible. So I think, to your point about the alternative argument, I think the alternative argument is very compelling, and I'd love to see the courts convinced about just cogent norms or, you know, norms in relation to international commitments. But I'm also really happy that the courts are squarely rejecting that causation defense, which I thought initially, most of us who worked in this space initially were worried about that one. But so far, the courts have been categorical, including in the carbon pricing reference, the Supreme Court just saying that's a non-starter. It's a collective action problem, so it doesn't matter. Every single emission counts. And so it doesn't matter if you're 0.5% of global emissions or 2% of global emissions or 20%, your emissions count. So we're going to see the causation link, which is really important because it could have been a big barrier. But I would really, so far the courts haven't really grappled, I think, to a satisfactory level with the international obligations. You know, they've been argued, particularly by interveners, and certainly the context against which the cases have been argued have included those commitments. But we are now seeing in some of the international decisions that link being made much more directly. So haven't seen it yet very directly in the Canadian cases, but I think it's coming, and I think they're really powerful arguments. So I'm intrigued, and we'll keep thinking about it.
So that felt like vintage Sheila McIntyre. I've missed your voice in these conversations. I can't believe it's been 14 years. It was like yesterday. I was thinking when you were talking about how we should resist the dichotomies, and also when you said, you know, that we need to, I did take notes, by the way. We have to decolonize concepts like we and person. I was thinking it's time that we take another look at the grounds, the enumerated and analogous grounds in section 15. And, you know, I'm remembering the Faulkner case that Martha was involved in, where the court looked at socioeconomic claims, but spread it out into 3 separate grounds. And, you know, as much as I appreciate the legacy of Kimberly Crenshaw and intersectionality, I think we've never really grappled with what intersectionality means. And more we're seeing a fluidity of oppression that is crossing so many different grounds. And so I think it would be an interesting time to take a look at that part of the section 15 analysis.
Blue sky, blue sky.
My contribution is not as ambitious as Sheila's. It's very modest. And that is that we do more comparative constitutional law. especially around social and economic rights. The stuff that's going on, particularly in Latin America, is jaw-dropping. And I would direct you to read the work of the Colombian Constitutional Court around those rights. You know, they treat international human rights a bit differently. They're directly incorporated, but their analyses that turn on proportionality, I think, should be instructive to Canadian judges. They talk in terms that will be cognizable to them. Their proportionality analysis is far more sophisticated than what goes on in Canada or Europe. So please turn to the Global South and in the hope that they can teach us something.
Margot.
So, thanks, this was a great panel. I have 3 suggestions for Section 15 litigation. The first is to spend more time talking concretely about what substantive equality is, so that people stop saying, well, you never tell us what it is and nobody knows what it is, it's just an empty term. The second is to spend some time talking about why Section 15 captures different harms than Section 7, that the comparative element is actually really important, and that inequality has harms of its own because of that comparative relativity, or whatever you want to call it, so that 15 does something Section 7 can't. And then the third thing is to give up the hope that doctrinal change will make a difference. I don't really think it's about finding the right formulation. I think it's about a much deeper politics and ideology, and that simply recasting the test one time after another isn't going to get us anywhere, really. So there.
Thanks, Margot. Any other comments or questions? Oh, Colleen, here we go.
Hi, thank you. I feel a responsibility because Sheila said, so eloquently stepped in at the last moment. She said, this is going to be a discussion. So, I mean, one of the things I find hopeful about some of the equality work is the recognition, or I have at least, I know it hasn't always borne out, but is the recognition of systemic discrimination, or focusing on the systemic, or even the structural, if one wants to look beyond simply the institutional level to the larger connections sort of between the individual, the micro, the meso, and the macro levels. And putting the focus on systems or systemic inequalities resonates a bit with, I think I can't remember which point, maybe I took notes too. The second one, sort of resisting dichotomies, focusing, and the first, looking at how, domination happens. And it takes us away from a categorical approach, and it also takes us away from an individualized litigation approach. And I think the other thing related to the systemic is the ways, and this resonates a bit with environmental as well, as how regulation has shifted over the years, where we think of human rights, the first generation of human rights regulation was focused on retroactive individual complaints-based processes, and that's still important. And I think litigation, test case litigation, that resonates or that addresses individual lives and brings those stories into the courtroom and into the media. But I think we've seen the emergence of this sort of more reflexive turn in regulation, where we've seen legislation trying to regulate institutions or imposing obligations on institutions through employment equity, pay equity, sexual violence in university, disability initiatives even. So their legislation is trying to regulate how institutions implement or take responsibility over implementing some of the normative choices we've made in the legislation. And those efforts are very mixed in terms of what institutions are doing. But again, it puts the focus more on institutional responsibility and institutional change at a more systemic level. So I guess those are 2 things. I've done my bit. Somebody else has to come up now.
Any other comments?
This will be terribly rudimentary, I think, but just to add, I guess, to your list of dichotomies to eradicate, if we can, or at least work at, and it's one that's deepening, I think, in the court's jurisprudence, is this dichotomy between international and domestic law. in the human rights area as well, where the court is actually on a retrograde course, is entrenching the notion that somehow international law is out there and can only play some sort of peripheral confirmatory role once you've already reached the answer to the constitutional question through the application of domestic precedents. I suspect that's the handiwork of Justice Brown, the late, great Justice Brown. I don't know, but so there may be some hope of reversal of that, but it is a very disturbing retrograde development, I think, in the charter jurisprudence of the court and the approach of the court generally, and seems to be at odds with that of many other apex courts, actually elsewhere. So anyway, that's a very modest contribution.
Can I just say this is so fun? So I have two. One is a bit crazy. So the not so crazy one is administrative law and charter values and thinking about Section 15 in that context. I think lots of exciting energy could happen there. And then the second is constitutional change. So this draws on what both Margot and David talked about, but you know, so many countries, especially in the global south, have way more progressive constitutions than Canada has. We have such a hard constitution to amend, and so I think we've given up, that it's not on the table. But I think we have to put it back on the table really solidly.
Any final comments? These are all great. Going once? Going twice? Oh. Well, I'd like to thank our panelists and all of you for a wonderful discussion this afternoon and all day, in fact. It's been a really wonderful, wonderful day. And thank you all for coming and all of your heartwarming and heartfelt contributions.
And if you weren't thinking about it, the papers were great today. And by the way, so were the student papers yesterday, the grad student papers. I was there. It was inspiring. It was inspired by a particular person. Everybody had. You know, we had really cutting edge papers. I forgot to bring them up, but on child welfare reform, on planetary health, one of my favorites, just because I like big and new ways of framing things, on simply the impact of Martha on a student who went through that program and will next year teach the Feminism 101 course. She took Martha's con law course. She's probably the only person in history who took it 3 times, twice as a TA, and she didn't want to miss a thing. So she spoke, and the third and fourth, it's been child welfare, planetary, reflexive regulatory, I'm not sure the perfect language, but reflexive regulation as a model for reconciling Indigenous and domestic Canadian law norms. Yes, that's about it. Yeah, so. Close, yeah. No, I mean, I was close. It was just, anyway, they were great, so they may be coming too, but really don't be shy. I'm really glad I got to be here today, and I'm really glad that you got to remind Martha of the magnitude, enormity of her work. So, papers, dinner for those of you who are registered, and remember there's a we. Thank you.